at all points, and a reminder that the materials for today's program are available through the link that you would have received from our Eventbrite email. So that will lead you to a web page on the OGen website where all of the materials for today can be found, so please feel free to navigate your way to that page at any point if you're looking to access any of the content, including copies of the agenda in electronic format. There are 2 microphones in the middle of the room, which we encourage people who are going to be coming to ask questions here in the space today to use, so that those people who are participating through the live webcast are able to hear your questions. So please, I encourage people to come up to the microphone and use that. And if there are any issues or any problems with today's program, if you have any questions, I'm going to get my colleague and conference organizer extraordinaire, Michelle Thompson, in the back to give a bit of a wave. She's been responsible for putting together much of today's program. She can answer those questions. So without further ado, I'd like to introduce our first speaker, Paul Cooper, who will be giving today's welcome address. Now, Paul currently serves as a bencher of the Law Society of Ontario, and he is a member of the Criminal Lawyers Association, the Canadian Bar Association, the Toronto Lawyers Association, and the York Regional Law Association. But as a dedicated advocate for equality in the legal profession, Paul is an annual sponsor of the Criminal Law Association's Women in Criminal Law Conference, and he's also a founder of the popular Garage Series, a regular continuing professional development event that brings together members of the legal community in a fun and informal setting. So without further ado, I'd like to invite Paul Cooper up to the stage to give us our welcoming address.
Thank you very much, Jess. I also want to thank both Jess and Julie for everything you're doing. It's just amazing. I'm here on behalf of the Law Society. Actually, I wear a few hats, but I'd like to welcome you to widening the circle, public legal education and information and access to justice. It's such a pleasure to see so many people and members of the legal profession and from the community sector gather to discuss the issues we share and the ways we can work together to increase access to justice in Ontario and across Canada. And it's a special privilege that I have because I get to welcome another 450 people that are on the webcast. This is amazing. And thank you for joining us on the live stream. It's a privilege to have you tuning in from all across the province of Ontario and the country. Imagine today with our technology, we're actually using it to bring everybody together. We look forward to receiving your questions, comments, and insights as the day goes on. This event is part of the Law Society's 4th annual Access to Justice Week. I wish to take this opportunity to thank also the Law Foundation of Ontario for their steadfast support of this work. Now, I said I wore more than one hat, and my personal stuff is me as an individual trying to push that huge boulder up the hill through my career, if I can get it a centimeter. If I'm lucky enough to get it a centimeter, I hope I've done well. But like so many people here, it's not only about what your profession is, it's about how you mentor others. It's how you teach others, how you support others who are in the front lines. As a bencher, I've had the privilege to be able to work with the Access to Justice Committee and the Legal Aid Working Group. It's taught me that it's individuals like everybody here and on the webcast, that when we come together and we're able to share ideas out of the box, we're able to achieve the goal that we're all striving for. So as a trustee of the Law Foundation, that's another hat that I've been privileged to wear. I'm so pleased to be here on their behalf as well, because they are one of the funders of Access to Justice Week. There's also the panelists who are giving their time. And some of these panelists are part of our grantees, sharing their stories of their very, very important work. Access to Justice Week is our opportunity to bring together a diverse set of leaders from every corner of the legal profession to talk about some of the pressing issues facing our sector. And it's our opportunity to share those conversations with a wide range of stakeholders who are our allies, our collaborators in the pursuit of a better solution to the access to justice challenge. We are all too aware from various reports over the years that there is a growing access to justice need. A 2016 study on public perceptions of access to justice conducted by TAG, the Action Group on Access to Justice, on public perceptions of access to justice, found that 40% of Ontarians do not believe that they have a fair or equal access to the justice system. That same study found that 3 in 10 Ontarians have little confidence in their ability to access a legal professional or be treated, this is very important, or be treated fairly by the legal system. Everyone deserves integrity. And a majority said that they had a little to no confidence that they would be able to afford the services of a lawyer or a paralegal. One of the ways that the Law Society and its justice sector partners are working together to attain our common goal of accessible, fair, and effective justice system for Ontarians is through TAG, which began at the Law Society as the Treasurer's Advisory Group on Access to Justice in 2013. It was a key component of a new framework that saw the regulator playing a greater role in helping Ontarians with legal problems. It is a response to access to justice reports that we're calling for more coordinated and collaborative action to address a growing to justice need. Today's program, in fact this whole week, but today's program is the result of this coordinated and collaborative action. Access to Justice Week continues to inspire thought, provoke discussion about realities faced by Ontarians, and it's equally applicable across Canada. The Law Society is extremely pleased to host this conference and looks forward to the outcomes of today's discussions and workshops. Those ripple effects will be felt in the future. In closing, thank you for allowing me to convey my very best wishes for an effective, successful, and productive conference. Let's have many lively discussions in the room and as we leave the room. Thank you very much.
Thank you so much, Paul, for setting the context for today's program and sharing how we can all play a role in moving the needle on access to justice. Our first session of the day, I'm very delighted to present. As an organization that puts on conferences and various events, I don't know if this is something that others in the room share, but sometimes we struggle with trying to make sure that we're making meaningful territorial acknowledgements to start our programs each day. So I'm very excited that our first mini session of the day is really about engaging with that work. And I'm delighted to have my colleague Leah Horzempa from Sister Circle Consulting, who is Métis from Georgian Bay in Ontario. She is a lawyer, an educator, a facilitator, public speaker and consultant who currently works and lives here in Toronto. And she provides group facilitation, research, education, and consultation across many different domains and brings specialized knowledge and insights in Indigenous knowledge systems, research methods and governance, restorative justice, community governance, economic development, and reconciliation to achieve nation-to-nation relationships. Leah has an honors bachelor's degree of Arts and Science from the University of Guelph, as well as a Juris Doctorate from Osgoode Hall Law School. And during her recent public interest articling fellowship funded by the Law Foundation of Ontario, Leah actually wrote a report to help non-Indigenous professionals in the restorative justice industry better honor and engage with the Indigenous origins of their work. And this is titled Indigenous Knowledge and Restorative Justice, a Guide for Restorative Practitioners. Now, Leah is currently on a journey to reconnect with her Métis heritage and culture. As part of this journey, she's learning traditional beadwork, leatherworking, and wild food harvesting. And she's also building relationships with her First Nation and more than human kin. Thank you so much for coming in this morning to do this session, Leah.
Good morning, everyone. Thank you, Jess, and thank you, Michelle, for having me today. I'm really excited and I'm very grateful to be having this conversation with all of you today. And I think it's a really important topic, territorial acknowledgements. So I think I don't really need to introduce myself because Jess did such a good job of telling you all who I am. Of course, I am Métis and of mixed European ancestry from near Georgian Bay here in Ontario. And today I'm going to talk about both the purpose and the practice of territorial acknowledgements. And I do want to remind you that I have saved some time today to make sure to answer any questions that do come up. So that's whether or not they're coming through the webcast. I know we have a lot of people joining us online, and thank you for that. But I'm happy to answer any questions as well. And I'm also looking for any ideas that you may have sitting in the audience about what makes a good land acknowledgement from your perspective and in your experience. So hopefully we can do that kind of mutual learning together today. And I'd like to point out this photo here behind me. So this is, I was thinking about, what am I gonna show? What am I showing everybody today when I'm talking about land acknowledgement? So this is the land that I think of when I think of what responsibilities do I have to land, what connection do I have to land? This is where I grew up, near Georgian Bay, and these are the trees that I saw every day when I was waiting for the school bus, and they really mean a lot to me. So I wanted to share that with you, and to say thank you to my partner, Matthew, for taking all the great photos that I'm gonna share with you. So these are all the photos that are gonna be in my presentation today. They're just from around the land where I grew up. So I hope that you enjoy that as well. So we're just gonna start off with a short little video.
Hello. Oh. Hello. First, I'd like to remind everyone here to turn off your cell phones. Before we begin this evening's performance, we would like to acknowledge that this theater stands on territory of the Anishinaabe, the Haudenosaunee, the Huron-Wendat, and the Petun First Nations. We are also mindful of broken covenants and the need to make right with all our relations. And now, please enjoy the show.
Oh, sorry, hello?
Yes.
Sorry, excuse me, should we go?
Excuse me?
Oh, no, I just mean if we're on someone else's land, shouldn't we leave?
Oh, no. The theater is here now. We'd just like to acknowledge whose land it is.
I'm sorry, I'm so confused. So if we're on someone else's land, shouldn't we do something about that, or?
Hopefully we'll enjoy the performance.
Oh, okay, so some of the money from the ticket sales of the show are going to the Indigenous communities?
Well, no.
A portion of them?
No, the ticket sales go to the theater.
So is the money from the bottled water sold here going to the First Nations for clean drinking water, or?
Oh, no, that money goes to Nestle.
Nestle.
They're a sponsor.
I'm so sorry. I'm so confused. So, whose land are we on? What are we doing?
It's a dialogue.
How are we making right?
Well, there's a plaque you can read in the lobby.
I don't understand.
I'm getting a message from the stage manager that we need to begin the show, so please take your seats.
But,
Have a good time.
Good
night.
Guess I'll sit down. Enjoy the show. Just enjoy the show.
So a friend of mine shared that video with me, and I thought I better share it with you as well, because I got a really good laugh out of it. And I think that it really raises some pretty important experiences that a lot of us are having around the practice of land acknowledgements currently. So, I mean, I certainly picked up on a little bit of awkwardness there, a bit of discomfort, certainly some confusion, and kind of this sense that this whole practice seems kind of pointless. So we're going to talk a little bit about that today so we can wrap our heads around why are we doing this and how can we do it in a good way. And I forgot to mention at the beginning that the link to my presentation is on the downloads page that was mentioned at the beginning. So if you are looking to see it, you can also just Google YouTube Land Acknowledgements Baroness von Sketch. But I've also provided some of the references that I relied on today for my presentation on that downloads page as well. So I would really encourage you to take a look at that. So what is the purpose of territorial land acknowledgements? Why is it important that we acknowledge that we're currently on the territory of the Anishinaabe, the Haudenosaunee, the Huron-Wendat, and the Mississaugas of the Credit First Nation? It might be helpful to think what the practice is not for. So firstly, it's not about land ownership. And this is something that can be a little bit hard to wrap your head around when you're really steeped in a sort of Euro-centered or Western way of understanding land as property or as real estate. But for Indigenous people, we pretty much understand that the land owns itself. And I think if you think about it for more than a little bit of time, you think, yeah, the world and the Mother Earth tends to just kind of own itself. And it doesn't really matter how long we might be here or what we might do to it while we're here. That's actually a very short period of time in the broader scheme of the whole lifespan of our Mother Earth. So that's something to think about, that it really is just about how we live in relationship, in good relationship with that earth. So it's not about private property and it's not about land ownership. Land acknowledgements are also not a way to justify continued dispossession of land for non-Indigenous people. So I think that is something that also was kind of raised in that video. That kind of comment, well, the theater is here now, and we just like to acknowledge. So that to me, I really picked up on some complacency, a bit of complicity of just sort of, this is the way things are. This is how it's all kind of shaken down here, and this is the way we have to move forward. So land acknowledgements are not a way to just sort of say, here's how things are, and kind of state it as that's that. So what is the purpose of land acknowledgements? Well, according to Chelsea Vowell, who's a Métis writer and lawyer from Alberta, she says that at the beginning, when land acknowledgements were first being practiced, they were actually very powerful statements of continued Indigenous presence on the land. And they were actually somewhat shocking, and they might be a little unwelcome in many settler spaces, and they may even provoke a great deal of discomfort. And that was sort of the purpose, that they were used as a way to recenter and reprioritize Indigenous presence here on the land. And it's also important to know that land acknowledgements and the practice of them arose through Indigenous activism to be recognized. So Chelsea Vowell talks about it ultimately as resistance to invisibilization. So that's that countering of that systemic erasure of Indigenous life worlds from this place and from the public consciousness. But it's clear now, I think we saw in the video, and possibly from some of our firsthand experiences of hearing land acknowledgements in practice, that the practice has really become removed from that original purpose. It's pretty typical now that they're sort of scripted and recited. Often people will mispronounce the names of the nations, and there's sometimes very clear, obvious body language or a tone of insincerity or a complete lack of interest. I think I've actually seen somebody recite a land acknowledgement while having a temper tantrum about it. So it is possible. That is possible. And it's very clear to those of us who are Indigenous in the audience and really looking to hear something positive about ourselves and see that that understanding of relationship is reflected. So that's really what we're looking for. So I talked to a lot of different Indigenous people before I came to speak with you this morning. And I asked them, these land acknowledgements, what do you think about them? And I got a whole range of diverse responses that I think it might be interesting for you to hear. Some people said, well, Leah, it's something, and that's better than nothing. Or, it's the very least they can do. Others said, well, I don't feel comfortable if I'm in a space or I'm at an event where there hasn't been that land acknowledgement. Some people said, I'm sick of hearing these land acknowledgements, where the people who are saying them, it doesn't seem to mean anything to them. And I'd rather they didn't bother at all. And others have said, it's really just to make themselves feel better. It has nothing to do with us, and it has nothing to do with reconciliation at this point. So clearly, people are having a lot of negative emotions about the current practice of land acknowledgements. So it kind of raises the question of, should we even do them? And the answer is yes. Land acknowledgements certainly maintain an important role in rebalancing space and power. But they have to be done in a good way to be effective. So Chelsea Vowell, as well as Hayden King, now Hayden I haven't introduced yet, he's Anishinaabe from the Beausoleil First Nation on Gitchaminising in Huronia, Ontario. He's also the executive director of the Yellowhead Institute at Ryerson University. And they both talk about, and I believe this should be in the resources that are on the downloads page. These are things that I sent for you to review. They both talk about how land acknowledgements are quite useful and they're still impactful in certain spaces. But it seems that in certain spaces, they're more impactful and useful than in others. So Chelsea Vowell points out that you really start to see the strongest critiques of land acknowledgements in the places where they've been done the longest. So it seems like there's an element of time where they're becoming less effective over time. And Hayden says it has to do with privilege in a space, that we sort of need to have higher expectations of these acknowledgements and in reconciliation generally in spaces where there's a lot of privilege, such as in universities or at conferences like today. And I would argue pretty much all of professionals like us, we are probably being held to some of those higher expectations of land acknowledgements. So overall, the purpose of land acknowledgements is that they're a statement of continued Indigenous presence here on the land. They are functioned to disrupt and resist settler narratives that erase us and oppress the land in all our relations, and they are to provoke reconciliatory conversations. Okay, so how do we make the practice of land acknowledgements match then with that intended purpose? And one of the things I've learned in preparing for our conversation this morning is that it's probably best for non-Indigenous people to be doing the acknowledgements. As an Indigenous person, I've been asked quite a few times actually to deliver a land acknowledgement. And I typically will kindly sort of say, is it really me that needs to do that acknowledgement, right? Is it me that needs to do that work? And probably not. I think it would be much more meaningful, certainly for those of us who are, again, Indigenous sitting in the audience, it's really meaningful to hear a very heartfelt land acknowledgement from someone who's not Indigenous. So that's one thing to think about. But you may see Indigenous people doing all sorts of acknowledgements. And land acknowledgements are quite common for Indigenous people to do, especially when, Indigenous people are in different territories. So that's not to be kind of conflated or collapsed. These are kind of different types of practices than what we're talking about today. But one thing that's very important for land acknowledgements to be effective is that they require mindful presence and personal reflection. So Hayden King, he actually wrote the Ryerson University land acknowledgement. And he now says, I regret doing that. Because in fact, he says, people need to be writing their own land acknowledgement. So it really doesn't seem sufficient that you can kind of have some organizational template or standard acknowledgement that then everyone can kind of go up and recite. That seems like that's becoming an antiquated practice. And the important piece of preparing for a land acknowledgement is that important research that you're doing. That's that learning. And so when you're doing the research for an acknowledgement, you're likely going to discover that there's a lot you don't know, and there's probably even more you don't understand about Indigenous ways of life or Indigenous perspectives and realities. So that's that key. That's that kind of trigger to you to say, okay, I need to actively seek education when it comes to this understanding. And I'll just say it's important to compensate Indigenous people when you're asking them to educate you about those things. So doing that research and preparing that land acknowledgement, it's an opportunity to reflect the learning that you've done. And you can also reflect what that knowledge compels you to do. So Hayden talks about, what would a good land acknowledgement sound like to him? And he says, this is the land we're on, and this is what we're doing or what we're going to do to breathe life into our obligations to those communities and to those treaties. So what can you include in a land acknowledgement that you are researching and that you're writing? Well, I kind of thought there's a couple of different categories of information, including land, people, and knowledge. So again, this is the bush near around where I grew up, and this is just looking right into my backyard here. So what is the significance of land to Indigenous people? And that's a really big question, and it's a really big answer. And it's something that I am only just learning myself, and I think I'll be learning about that for the rest of my life, of what is that sacred relationship between Indigenous peoples and these lands. And, you know, I've come to learn from different elders and knowledge keepers and different community members that land really is the basis for everything in Indigenous societies. But, you know, we often talk about land as Mother Earth rather than as land. And you know, the earth is where we go to learn how to live a good life. All of the earth and all of the natural relatives that we have here on the land, those are our teachers of how to live. It's also where we go to observe the natural legal orders and legal systems that are the foundation of Indigenous legal systems. It's the source of all of our food and our medicines that keep us well. It's our economic foundation so that our communities can thrive and prosper. It's the foundation of our spirituality, and in a very real way, it's also the very core of what makes Indigenous identity at the individual, at the community, and the nation level. So Indigenous people acknowledge the land in many different ways, and they will typically acknowledge Mother Earth and all of the relations. So when we do acknowledgements, we acknowledge the earth, the water, the animals, the birds, the trees, and the plants, all the bugs and the insects, the wind, the soil, the rocks, ultimately that entire universe that is our home. But we also acknowledge what our responsibilities are to that land and what our responsibilities are to those relatives. So Ruth Colazar-Green, she's a professor at York University, and she's a Mohawk of the Turtle Clan, and she talks about land acknowledgements and says, you know, we really need non-Indigenous people to reflect on and understand their responsibilities to the land as well, and sees that the land acknowledgement is a really great opportunity to do that and to have a part of that conversation. It's also a great opportunity when you're talking about land to be reiterating that the First Peoples really are the experts when it comes to living in good relationship with the Mother Earth and for stewarding the land for a bright future for our children. So this is myself and a couple of my cousins walking around in the bush just this past spring. So another important topic of information that you'll want to be covering when you're doing research and when you're preparing a land acknowledgement is about the people. You want to learn about the nations that are around you. And you also want to learn not just about their culture or their ways of life. That can be really interesting. But you want to learn what they're doing to restore self-determination and sovereignty and the stewardship over their lands. That's what really important information for you to know to be a good ally. And a land acknowledgement is an opportunity to honor your relationships with Indigenous people. So if you don't have relationships with Indigenous people, then that land acknowledgement is also an opportunity to acknowledge what you're doing to build those relationships or improve those relationships. And you can talk about how you or your organization is making space for Indigenous activism or is supporting different Indigenous initiatives or different programs that are happening near where you work. So one of the things about, you know, we're all facing climate change. We're facing this global warming, and we really need to come together. And it's important to see that Indigenous people are one of the many species whose presence must be protected on the land to maintain our biodiversity. You know, we have some sort of competing dialogues about conservation that are really starting to we're starting to critically evaluate these with global warming happening. And so in kind of typical Western notions of conservation, we sort of mark off a piece of land and we say, okay, now we don't touch that land. And we leave it and we don't look at it and we just let it do what it's naturally gonna do. And in Indigenous ways of understanding conservation, that's really not adequate. To conserve that land is to conserve the relationship that we have to that land. And so Indigenous peoples is actually shown in the research, because I always say, you know, Western science and Western research typically catches up to traditional knowledge and the wealth of knowledge that is known in Indigenous communities. But those parts of the land that still maintain those sacred relationships with the First Peoples are healthier. So it's healthier for the land and it's healthier for the people if we maintain those positive relationships with the land. So I'd like to just encourage you to think about Indigenous people as an important part of biodiversity that must be protected. So when talking about people and when talking about relationships, of course, land acknowledgements are also an opportunity to be acknowledging those treaties that our ancestors made. So instead of just acknowledging what the treaties are that are in a particular territory, I would suggest it might be an opportunity to sort of acknowledge a lot of the bad faith that went into those treaties, and maybe some of the lies that the colonial governments have told us about those sort of original intentions and those initial promises made in a lot of those treaties. I would really like to hear some of that being acknowledged when I hear land acknowledgements out and about. So, this concept of the Toronto Purchase and Treaty 13, that word of purchase was something that didn't really happen. That's something that wasn't a part of that 1787 agreement. So those are ways in which we can start to look at and really investigate, what are these knowledges? What are the things that we need to know? And what are the things we need to be sharing if we're in positions of power or in positions where, we kind of need to be expected to know certain things about Indigenous people and their ways of life. So lastly, a very important category of information that would be really good to put in a land acknowledgement as well is about acknowledging the rich knowledge systems that Indigenous peoples have stewarded here on the land for thousands of years. So this is a real area of interest for myself because I've done a lot of research lately and a lot of writing about, as was mentioned in my introduction, about how the law has really heavily co-opted, appropriated, distorted, and stolen a lot of Indigenous knowledges about law and conflict. So we really see this playing out in a big way in the restorative justice industry right now, playing out in a big way in this alternative dispute resolution space. So these are really opportunities, if you're working in those communities of practice, or if that's your practice, to say, okay, there's probably a lot of Indigenous foundational knowledges that I'm just kind of assuming, or were kind of given to me without a lot of context, that are as universal. I hear that word a lot, that these are kind of universal truths or universal pieces of information, when in fact they can be very easily traced to Indigenous ways of life and to Indigenous teachings. So that's an important component that can be acknowledged in acknowledgements as well, talking about tracing that knowledge and really being grateful and honoring all of the knowledge that we have been gifted from the Indigenous ancestors and from those Indigenous people that continue to teach that important wisdom and knowledge. So, when it comes to Indigenous knowledge, Lee Miracle, who's a Stolo, a very prominent Stolo writer, and she's an elder at the University of Toronto, and she talks about knowledge as an Indigenous cultural birthright. So trying to think about parallels in Western, Euro-centered way of being, and you kind of think, well, what do I inherit? Well, I might inherit a piece of property, right? Or I might inherit a sum of money. And in Indigenous ways of understanding, the inheritance that we look forward to is that vast body, that complex, rich system of knowledge that our ancestors have maintained on this land for thousands of years. So Ruth Colazar-Green, she says that land acknowledgements can be a really great opportunity to deepen our understanding of the Indigenous theories that are contained in engineering, in science, in liberal arts, in fine arts, in environmental studies, in business, and in law. So a couple of notes about land acknowledgements overall is that they must be alive. They can't be static. So they must grow with you as you learn. And that has to be continually evolving. And as you're developing relationships with Indigenous people, that land acknowledgement will grow as well to reflect that. And what works today, that's probably not going to work in 3 years. It's not going to work in 5 years. It certainly won't work in 10 years. Because the fact of the matter is we're in a time of truth and reconciliation. So these conversations are being had at a much higher rate and a much higher level within our public discourse. So we're all needing to learn actively sort of day to day of how to stay up to date and how to be really good allies with Indigenous people. And the First Nations, the Inuit and the Métis were in a time of resurgence. So we're taking back some of that space that we've been withheld from having for a long time. And so we're going to be holding you kind of to that higher expectation that Hayden talks about. We're here and we're looking to build those really positive relationships of kinship and mutual support, and hopefully working together with this climate change coming forward. So now we have some time for questions. And again, I'd like to remind you, if there are things that you think, oh, Leah, I really like to talk about this in a land acknowledgement, or I have, I've learned from somebody that this would be good to talk about, please share that with everyone as well. Okay, if there are no questions in the audience, I'll take the first one on the webcast. So the question is, how do we as lawyers, how can we promote, make it popular, and make public and our clients aware of land acknowledgements? So, one of the things I talk about with lawyers is that, I was actually teaching a class at Osgoode Hall last week in the mediation seminar. And and somebody asked me a question. They said, now all the law students, they have to take a minimum of one course about Indigenous law and about Indigenous people. And they said, what do you think about that? And they actually framed it as they have to take one course to graduate. That was the kind of framing of it. And what do you think? And I said, I think that's the bare minimum that we can be expecting of our law schools and our legal communities. I actually think it's pretty difficult to be giving advice to our clients without understanding in a deep way that there are plural legal systems on this land. There are legal traditions and systems of law that have existed much before colonialism happened. So to be a good lawyer, I would argue today, is that you need to actively be educating yourself across all of those different legal systems. That's certainly something I have to do as an Indigenous lawyer. And I think that that's how we can all start to move forward a little bit more easily. Because if you're able to understand those Indigenous systems of knowledge, those Indigenous systems of law, then you'll be able to have those kinds of cross-cultural dialogues, those conversations, a lot easier. So a little bit of research can really go a long way. So I think that's one of the things that lawyers can do to really promote Indigenous knowledges, is they can promote Indigenous law. And they can tell their clients that, part of what it is that they're going to do, especially for those of us, I know that's not really where we're coming from today, but for those of us working for clients in the natural resource sector, I think that's very important, is to be acknowledging to our clients that there are other systems of law that we need to be accounting for when we are doing our advising or doing our legal practice. Okay, I've got a couple of questions here in the audience. I think, you're first here.
Yeah, good morning, Leah. Nice hearing you speak again. I just wanted to say I'm really glad you touched on that point about the Indigenous legal systems, because one thing I would like to hear more in land acknowledgements are what Indigenous agreements govern the land. For instance, I'm not sure if we're currently on the land governed by the dish with one spoon wampum, or if that's actually a little bit farther north of here. But of course, certainly hearing those kinds of things would help increase my knowledge about where all of those wampums exist and where they pertain to. And it would certainly put in the minds of the people hearing it the notion that there were Indigenous legal traditions and formal agreements that predated colonial settlement.
Thank you for that. So I won't talk much more, as we don't have a lot of time, about the dish with one spoon wampum. But yet that does apply here on this territory. And I would say what's important to sort of add to an understanding of Indigenous legal systems in land acknowledgements is that the systems just function very differently. So you don't necessarily need to point to these sort of concrete agreements or contracts like what we might consider in sort of Western or Eurocentered legal practice, that there are sort of embodied ways to regulate social control, essentially, and to regulate harmony in community that don't necessarily look like those firm contracts. So I would kind of encourage you to think beyond just this frame of reference that we understand law. And we've got one more quick question here.
I'm just wondering if, in addition to acknowledging the land and the relationship to Native people, if we should not be including in it, in any land acknowledgement, the genocide committed by the church and the state against them, because that's how we got the land. Right? So we talk about acknowledging the land, but not how we got it. So perhaps we should acknowledge how we got it and how we continue to exploit and oppress the people and the land for example, the federal government appealing the decision of the Human Rights Commission. So I think in land acknowledgements, we'll have no short list of things that we could include that are topical and current, and also historical.
Thank you for that. I think that's a fantastic component of what needs to be actually directly addressed in land acknowledgements. So just like I spoke about, let's be honest about what those treaties are. Let's be honest about how the governments and how legal practitioners have treated those treaties. Let's be honest about the genocide that's happened on this land. And I can say for myself as an Indigenous person, going to see an event or a conference and hearing that straight out of the gates in a land acknowledgement might help me to feel more comfortable in the space. It might help me to feel like people are starting to understand how we need to reconcile, really what that reconciliation is about, right? And how do we get to that good action and that relationship repair and that relationship building? Well, it has to start with truth. And I think I thank you for that comment, because that is the fundamental truth that we really all do need to sort of accept and come back to. So I know that we are out of time, and I'm thankful for all the questions today, and thank you for your participation.
Leah, thank you so much. Thank you for sharing your knowledge with us, and thank you for starting today's program in a good way. Thank you for showing us how land acknowledgements are really an opportunity for us as settlers to listen, to learn, to reflect, and to share with others how we can all work towards repairing our relationships with Indigenous people. I'd like to acknowledge that we are privileged to be meeting today on land that I have come to call home, but have also, through my professional work and my personal relationships, have also come to realize has been home to many Indigenous people for centuries who have done an amazing job of stewarding the land and have shown me that there are ways in which I can learn from them to do likewise going forward. I'd like to acknowledge a lot of the hurt that has been perpetrated upon Indigenous people, and how, in my own personal commitment, I would like to ensure that I continue to inform myself going forward and recognize it in public forums such as this, what I have learned over the years. So thank you for starting us off like that today, Leah. And I would like us to move to our next panel discussion, I believe, that's coming up. If I could ask, I think, is it Alex who's going to be joining us up at the front with our panelists? Thank you. Oh yeah, absolutely, thank you. Alexandra Derizier has degrees in civil law and common law from Ottawa University, a civil law exchange with the Universidad Panamerica in Mexico, and was called to the bar in 2009. She has experience with labor relations law, conducted research on humanitarian issues, and has worked at the Federal Court of Appeal, the Canadian Human Rights Tribunal, and the Privacy Commissioner of Canada. She is fluent in English, French, Spanish, and Creole. She is actively involved with the settlement and immigrant service partners in the legal clinic community in Ottawa. And she's passionate about public legal education and an experienced presenter on various topics. Now, prior to joining Connecting Ottawa, she was an employee of Vanier Community Service Centre, working as a lawyer on the Refugee Pilot Project and the Clinique Juridique Francophone de l'Est Ottawa. Alexandra has served on several humanitarian missionary trips in the Dominican Republic, Haiti, and Mexico, and she's going to be stewarding our panel and introducing our panel, our various panelists this morning. So I would like to turn things over to you, Alexandra. Thank you so much.
Thank you. Thank you for that introduction. So I'm assuming everyone can hear me quite well. For this panel, really we'll be discussing what my passion has been about the last 5 to 6 years, which is community justice. And so in my work, I work a lot with frontline workers, and what we do is capacity building. So Connecting Ottawa's mandate is to offer legal services to people who have communication barriers. So people who speak neither English or French as a first language, or people who have a sensory impairment that makes communication difficult, if not impossible, to get legal services. So that's basically what I do, but I can't do my job without frontline workers. I can't do my job without the people who are out there in the trenches doing the bulk of the work. So today we're going to be talking about community justice help. We're going to be talking about what enables people to do what they do so well, giving sometimes standing on that line where it's legal advice, but it's for the good of the individual and it's moving things along. And so I'm going to be going over the biographies of my fellow panelists. And I believe that these people, they represent the people on the ground actually doing the work and actually getting the clients what they need. So in my job, we do capacity building, but sometimes I'll just meet someone who is sometimes building my capacity as a lawyer and teaching me something new because they're doing it day to day, whereas when I come by weekly, the whole ballgame might have changed. So we're gonna start with Carol Barkwell. So Carol is the executive director and founding member of Luke's Place, a unique organization which supports abused women and their children through the family law process. Carol frequently participates on panels, stakeholder consultations, committees, and focus groups, and has presented at local, provincial, and international conferences on the issues faced by women subjected to intimate partner violence as they navigate the family law system. She's been an advocate working with abused women and their children for more than 30 years. She's dedicated to innovation, collaboration, reducing the gaps in service, and developing an effective systemic response to violence against women. We've also got Jordy Dent. Jordy Dent is the executive director of the Federation of Metro Tenants Association. He's been a tenant and tenant advocate on over 3 continents. We have with us today Francisco Rico Martinez. He came to Canada from El Salvador in 1990 as a refugee. He has dedicated his life in Canada to refugee advocacy and support for victims of human rights violence. Francisco is the former president of the Canadian Council for Refugees, and currently he's the co-director for A2J Refugee Center. Recognized for his efforts in social justice, his awards include the Community Leadership and Justice Fellowship from the Law Foundation of Ontario, the William P. Hubbard Race Relations Award from the City of Toronto, and the YMCA Peace Medallion. He also received the Pioneers for Change Award as a recognition of all the contributions that he's made in areas of literacy and access to information. Next, we have Jacqueline Thompson. Jacqueline Thompson is the founder and executive director of Lifespin, which has provided substantial programming to single mothers, families, children, and individuals living in poverty in the London area for over 25 years. She's been a leader in advocating for her community in transforming structures and systems that lead to poverty, homelessness, and other social problems. She has served on the London Affordable Housing Task Force, the Premier's Council of Health, Wellbeing, and Social Justice, the Income Security Advocacy Center's Board of Directors, and the London Community Advocate Network. So I want to applaud the people working here. So if we can just give them a round of applause for the work that they're doing. So today, I just want to give you guys the opportunity to talk about the good things that you do and how you do it. So basically, how you're helpful in moving things along to get the desired outcome. And so I'm going to be asking you questions. I'm going to be kind of open in the way that we go about it. It's a conversation, and we're just going to be talking about what you can do to get your client the best help that they can get. And also, further along the line, we'll be talking about how sometimes you're the ones helping the lawyers figure themselves out, right? So I don't know if someone wants to go first, but maybe we can start with you, Carol, and what it is that you do and how do you do it?
Okay. So Luke's Place supports women at the point when they are considering or have left an abusive relationship. So their primary concerns are safety for themselves and their children, and we work with them as they are engaging in the family law system. So they are looking at legal issues like custody, access, restraining orders in the context of safety, and they're doing all of this really in a climate of fear, with very little knowledge about that system, and often very few supports, especially legal supports, because many women find themselves unrepresented in the system. They don't qualify for legal aid, and they often can't afford a lawyer. So we provide that bridge for them of supporting them emotionally as they consider their options in the legal system and connecting them with lawyers. And I can talk as we go along a little bit about how we do that, but I'll leave it at there for now.
I do have one question, maybe
Sure.
it's a question that comes to the mind of others, is what makes you feel confident, like especially when they come with a legal issue, what makes you feel confident that even with a legal issue, not being a lawyer, that you can help them?
Sure. Part of that is our long-term experience engaging in the system. Many of us doing this work have worked in shelters and other violence against women organizations, and if we walked beside women through those systems, historically, women have had more access to legal representation in those systems, and so many of us have learned through working together with lawyers, and we certainly still do that. We have very close partnerships with lawyers in our work.
So experience is one of your biggest teachers in this case?
That's right.
Okay, got it. So I want to hear a bit from everyone. We'll go over to you, Jacqueline. What do you do and what helps you give the best quality help in the knowledge that you've gained so far?
Well, Lifespin's been around for a long time, and it's a peer-led organization, so it's owned and operated by the people we serve. 60% of our board of directors has to be low income. So the issues that people come to us for are programs and resources to relieve the day-to-day conditions of poverty. And through the stories that they tell us, we design programs to meet those needs if they don't exist. One of the programs is the advocacy work that we do, and that's probably what's of most interest here. And again, it's with the experience of many years of doing it, doing the policy work and challenging the laws if there is not a policy and a law that benefits the people. So we actually sometimes don't stop, we take it a bit further.
Okay, can you just tell us how you take it a bit further?
Well, for example, the Spouse in the House Charter Challenge came from clients that could not get access to the legal help in the legal system because the law was broken. And it was intentionally broken by the government that was in power. So we had women that came to us because they were just going to lose the appeals. So we helped to launch a charter challenge that we won, and then they appealed and we won again. So we changed the laws. And we do that with other things like employment insurance benefits, where older workers were missing the ability to get the benefits that, if you read through the legislation, it looks like they should have been entitled to, but they weren't. So you could go to the Board of Referees, but you're going to lose because the law was broken. So we met with the minister that was responsible, went through it, and they changed the law. So just sometimes taking it one step further.
So I have a follow-up question. So do you don't have any lawyers on staff?
We do not have any lawyers on staff.
So
but
how did you go about changing the law?
That is, you have to reach out and network with people. There's a lot of people that have good hearts, and without those good hearts, we wouldn't get anything done. Lifespin is not funded by any government or anything. It's, again, a grassroots organization, so we have to reach out and develop those partnerships with private bar lawyers, with the legal clinics, with other lawyers working in the clinic system. Somebody has to sign those documents in order to do a charter challenge, and you need a lawyer to do it.
Thank you. Jody, we'll go on over to you. So what I want to know is, take us through the routine of your work and how it intersects then with the legal system.
One thing to note about like my work is that I'm a kind of a glorified administrator. So like I get to do this stuff and fill out all the funding applications and tear my hair out over kind of administrative issues. But the bulk of the work that my agency does is done by the staff, right? It's all the grinding work. It's all the hotline phone calls that never end, that deal with a host of issues. It's the people that actually go out into buildings to tell people how they can fight an L5 application at the Landlord and Tenant Board. It's our staff who are in the trenches with our kind of tenant school project, trying to educate people and trying to build tenant associations and stuff like that. It's really on the ground work. It's really great. And a lot of what the bulk of what we do is just kind of educate people about what their rights are, what the law says, how things work. How it intersects with the law is actually very interesting. When people kind of explain to me you must work with lawyers a lot, I often explain, like, keeping our clients away from lawyers is kind of the #1 thing we try to do, not because you know. Let me clarify that. I know you all live in the legal system, and I often live in the legal system, but I'm sure all of you have kind of been to a party and you talk to somebody whose knowledge of the legal system is Law and Order and Judge Judy. That's it. So a lot of times our job is to try to keep people out of that system because it takes a lot of time. It takes a lot of energy, and you've all seen a client get obsessed with an issue. You know how that goes. You know what their mental state is after 2 years of litigation and just kind of being completely tearing themselves down. So kind of our goal is to try to keep people out of that system, but keep people housed and enforcing their rights. And one of the interesting things that I was talking to Julie about this, I was trying to prep for this, and what she told me is one of the most interesting things that I told her was that the #1 thing that we try to teach people kind of in our work is that they can say no. It's amazing how many people I talk to who are told to move out, and they just move out. Who are told they've got to pay $300 and they just pay it. Who are told, oh, I'm sorry, the top 2 elements of your stove don't work, nothing I can do, and they just kind of swallow it. And so we're often kind of explaining to people is, no, you can just say no. It's not the law of mom and dad. I don't know about you, but when my mom says, you just do it. There's a framework involved, and a lot of our work is you know, our hotline staff, the job is, they're called hotline counselors. And a lot of it is kind of the legal work, but there's this counseling element. There's this counseling element of explaining to people, you know, you get the right to say no, that you don't just have to do whatever your landlord says, that there are tools and legal resources that you can access to kind of push back.
Thank you. And I'm going to ask a question that's open to all of our panelists today, but I haven't forgotten you, Francisco. And so what I want to know is other instances where in the day-to-day work that you do, you try to keep people away from lawyers. I know in the work that I do, even as a lawyer, my goal is to avoid having to get other lawyers involved if we can. And so give us instances, maybe the other panelists, on how you avoid that next step of having to go maybe through the court system or having to involve lawyers and try to resolve things before they get to that point.
Well, in our work, in our office, this is the first thing that we do, to try to, that the person have access to a lawyer. You know, that's the first thing, through legal aid, through, the problem is that the system is not universal. And there is many people that are left out of that possibility. So, and that's when we kick in, you know, because the person needs to materialize the rights to be heard. And our system doesn't go that far. So that's why in order that we do this, we open our programs in basis of the needs of the people that appear in our office. Because they are the ones that identify the gaps of the legal system and the gap of legal aid or the gaps of everybody. And that will start advocating to try to fill the gaps. But in order to provide that direct service, we use everything that the civil society can give us. Pro bono law students, volunteers, staff, international trained lawyers that are an amazing people, because the majority of them, then they come here, are trained in human rights issues, you know, in gender issues, and in many other things that they have suffered back home as a persecution. And then we start working on it. And we are creating a community that is a mix of lawyers. We have like 20 lawyers around our organization that take legal aid and take other cases pro bono. And we have the pro bono law students that go and hands-on in different cases, and we have lawyers, even though we don't have a staff lawyer in our office, we rent a lawyer, an office in our basement. And this guy has grew up with us. You know, he came to do volunteer work for the first time 5 years ago. And then do the article very close, and then they said, well, I don't want to work in other area besides immigration and refugee. Could you house me? And I said, well, we can rent a place for you. And the way that he pay rent is, well, money, but also by reviewing different things that we believe don't have the capacity to do. And we try to be updated in every single change. And remember that immigration and refugee law change every single week. You know, you have different things, you have different procedures. So you have to be updated. And we have developed programs to train frontline workers. Because one of the things that we have been saying to the Law Society forever, they are providing advice, believe me or no. They close the door, and settlement workers and many other people provide advice. Will be a good idea that you open the door and you start giving a training to this type of sector in order that they provide the best advice possible and they link the person to the best resource possible. And that's where we are stuck. Yes and no. You know, the legal advice is the universe of lawyers, and, you know, we have a provincial law that basically said that, but we are under the Immigration and Refugee Protection Act, that is a federal law and has a paramount on the provincial law. So, and that's the situation that we are discussing and we face every single day. Our experience is the key, and our way of listening to the needs of the people is the key. And then the network appears, because the people that want to work with us is people that are conscious, and they want to help, and they want to know, and they want to move people forward and give access to. So we don't work with every lawyer, because we don't believe that every lawyer had that concept. But we have developed a community that developed that concept.
So I want to talk about this further, where do you ever feel that yourselves or staff workers are not crossing the line into legal advice, but are standing really close to that line? Because, and this is a safe place, where they're doing the work. Do you ever feel that there's that tension there in the work that you do, where you might be crossing into giving, well, I don't even use the word legal information. It's not legal advice, and we're not gonna have that whole legal information versus legal advice conversation here today. But where sometimes you feel that you're standing on the line, but it's for the good of the client. And we don't have to give direct examples, but something that helps us understand why the work that you do is so important when sometimes you don't have a staff lawyer present.
Well, it's the invisible hand of the market. Who defined that? The invisible line of legal advice. Where is it? Could you explain it to me? If you are filling a form for someone, and you fill it up, no problem. But if you explain something, a terminology or someone, or what is the meaning of that question, oh, you are in legal advice territory. Well, sorry. Life works in a totally different way. The people need explanations, and they don't have access to a lawyer. So what do you do? And also the federal law provides us in that situation, you know, the possibility to do it. We have been challenged by the Law Society. We have received a letter of cease and desist. We did an investigation. They did an investigation, and then they said, please continue with your good work. You know what I mean? Amazing. So my point is that we know areas of law very well, but we know areas of law that we know, but we are not capable of providing information or advice. In an immigration case, family law appears. So do I am capable of doing that? No. A lawyer appears that is willing to talk and assess the situation. Criminal law appears. So we use the resource that is capable of doing this. International law appears with the cases of the higher, you know, then there are some claims. So there is, you know, the protection of children, the relation of children's aid society. All of that appears in a simple, single immigration or refugee case. Do we have the capacity to go in that direction? No. Do we provide an advice about to acts, about things that they have to do immediately, like leave your home? For instance, your security is the paramount, and you have to leave. Think about that one. Come to our office, and we are going to call the police. Is that legal advice? So maybe some people will say yes. So, but the reality is the one that is educating us about how we react. But we have an ethical code in our office that have been put together for the last 30 years of working in Canada. And we know how to react, and we know the system, and we know the agents of the system as well. Because you have to deal with the police in many of these cases. And we know that how, even though we are a sanctuary city, they put people in detention if they don't have a status in the city of Canada. And we are working with the city on that. So do we provide legal advice? I want to say publicly, yes. We provide legal advice, and we believe that we have the capacity to do it. And we have the paramount of the Immigration and Refugee Protection Act that provide the right to us to do it.
Okay, very passionate. I appreciate everything. Yeah. I want to hear from the other panelists. Do you ever feel that tension and pull of, this is territory that there's a fine line there?
Well, the clients that come to us, they don't have knowledge of the processes that they're going to face further on. So if they're going to a housing tribunal, when they get there, they're going to be told, well, you should have written your landlord a letter and detailed all the stuff. They don't know all of that. So they're going to show up there and they're going to lose because they didn't do all the things they were supposed to do. So when they come to us, we help guide them through the processes. So we work with them to call the building inspector to come in and document the things that they're supposed to bring documents to the tribunal. We don't go to the tribunal with them. We have a legal clinic in our community that does that work. So we don't duplicate what the legal clinics do, but we help guide people through the processes so that they are successful when they get there. The same with disability applications. That's the majority of the case files that we do, is we don't have to refer them for legal assistance to appeal them because we fill out the applications with them and gather all the medical evidence that they need to win. So 97% of the applications are approved the first time they go in because we've done the work with the clients ahead of time. So we're keeping them away from lawyers because they're not losing and having to count on the lawyers to rescue them. And then we can use the lawyers for other things that we can't do. And so it's a symbiotic relationship with the legal clinics in our community. Is we take away all the stuff that they should never have to handle and then let them deal with the issues of law.
That's great, that's great. So what I'm hearing is high success rate, you do everything that you can do, and then you leave the rest that you can't do, that you need a lawyer for the lawyers to do. That's great. Anyone else have that tension going on in their workplaces?
Yes, we do for sure. Women leaving abusive relationships often don't have a choice about whether to engage in the legal system or not. So it's not an option to keep them away from lawyers or that system. So in fact, we do a lot. We provide similar methodology of service as Francisco's organization does, in that we quickly want to help women find lawyers that understand family violence, that can help them navigate the system. We also have a lot of knowledge about the system, so we provide that base information and help them organize their questions and concerns to bring to a lawyer. We thought when we opened Luke's Place that we would be helping women work with lawyers all the time. And we quickly discovered that many women didn't have lawyers. And so we had to find a way. And then that's definitely when the pressure built for us. And these are families that are desperate. And so we quickly engaged with, deepened our working relationships with the legal community and formalized them through, we provide pro bono clinic services, which we've been able to expand more recently virtually. So we connect women in rural and remote communities with lawyers in other communities because they often don't have access to lawyers in their own community through virtual conferencing. We also have an advisory group for our work. And we do work in our courts, so we have formal partnerships, especially to help women at the emergency stage. So we have a formal partnership with the Family Law Information Center so that when a woman needs to file an emergency motion, we help her do that paperwork in partnership with the lawyer in the information center, and they get the legal advice and we help her with the hands-on. So it's just like this and like this too, in terms of legal information merging into legal advice.
Okay.
I think from our end, like that's kind of where we live, in that zone of we can give you some information and some options, but we can't give you any advice. Like that, where basically all our staff are on that ledge every day, having people constantly trying to pull them into the realm of advice. And a couple things about this I think are important. One is that the kind of fear, the reason why we don't give that advice has nothing to do with the client. You know, the clients, I don't, you know, if I were to tell them, you know, we can't, you know, do that under Upper Canada Law Society regulations, they'd be like, what's the Upper Canada Law Society? They just have no idea of the system, right? They don't know that, you know, the amount of times I've given people like, here are your options, and they're like, thanks for the advice. Yeah, it happens hundreds of times every week. They just don't really oftentimes understand those legal distinctions. And I get that, right? Like I'm the same thing when I'm struggling with my cell phone contract, I don't really understand the scenario, I just want someone to tell me what I'm supposed to do here. That's oftentimes what it is. They just want somebody to help them figure out where they're supposed to go. And what we're good at doing is kind of giving options for that. And then you can kind of see people kind of crystallize their own path. And that's always really helpful. The risk for us is never with the client. It's always for us, we deal with tenancy issues, so it's always kind of the industry lobby groups. We're terrified that they're just kind of waiting in the wings to destroy us. And that's not like a fake kind of hyperbolic thing. This is a group that, you know, is publicly saying that, oh, well, they should get cut for their work on rent increases because the clinics do that work. It's totally bogus. Clinics don't do rent increase applications, maybe like one a year. But they're actively trying to destroy us. And that's, again, the fear for us. We just don't want to be destroyed. So, you know, I'm having to tell clients over and over again, I can't give you advice, I can't give you advice. They don't really understand the kind of legal intricacies of that. And they don't understand why we're being so diligent. A lot of times they'll kind of react like this is ridiculous, not realizing that for us, it's this kind of rule hanging over our head that we're afraid that someone's gonna kind of use to clobber us with.
Do you, and this is open to any of the panels, do you ever feel that, I guess, that dissatisfaction when you're in front of a client and they don't understand all this and they're saying, well, why won't you help me? Why won't you help me? I know that in Ottawa, where I work, at one point the settlement workers were doing forms. It was common knowledge we're doing forms because if the forms don't get to IRCC, then nothing is going to happen. And then one day I come and I say, okay, your settlement worker is gonna help you with the forms because I can't help with them with all of the forms. And the settlement workers now are pushing back, oh no, we're gonna get in big trouble. We can't do forms, we can't touch this, we can't touch that. And then there's that client who you know cannot do the forms. So you're stuck in that, I'm sorry I can't help you because of policy XYZ, but the client is pushing back with, why won't you help me? I came to you for help. So how do you deal with those types of situations?
Oh, we help them, you know. So that's the answer, no? We help them. You know, I don't say to people, no, sorry, I'm not going to be able to do anything about this because, no. That's never my answer, because one of the mottos that we have in our office is that everybody has to leave, don't leave with the hands empty. No, the people has to go, because if no, you destroy the self-esteem. Basically, you said, sorry, we are another office that is going to say no to you. So, no. I think the ball has to stop somewhere. And that's when I'm not saying that we take the whole case, but we help. If the person has an issue of housing, for instance, we help. If the person has an issue of family law, we help. If the issue is immigration and refugees, we help. And in the immigration and refugee situation, people come and said, you know what, you really understand my case, why you don't take it, why you have to refer it to a lawyer? And we have to discuss with them that the best option is to be referred to a lawyer that knows way better than us the immigration and refugee protection procedures and articles and laws than us. Then we do it in case that legal aid doesn't provide anything to you. So, but we help them. We never say no. And the person come back. When there is an issue with lawyers, the person come back. And we contact the appropriate people. The problem is that the system doesn't react in the speed than the people deserve. Take years. And the liabilities, and they are going to sue us, what we are do about this, then as a very mingle of our system, create that situation as well. But even if they return without legal aid, without a problem with the lawyer, without a problem with the authorities, what we do is to develop relationship with all the institutions that are involved in the case. We have a very good relation with CBSA, with IRCC, with Legal Aid, with the Law Society, with the this organization that now is trying to regulate, immigration consultants. We try to have a way open in order that we can have also the background support in case that we need it for that person. So we are there in the system. We are in the middle of the system. The system needs us for the people to navigate the system. And they know that, but they don't recognize it formally. They basically ignore the situation. Let me put an example. When we were dealing with the situation with the Law Society, and they sent a letter to cease and desist, at the end, someone came and said, could you remove the term legal advice from your website and put information and support? And they give us a presentation about the terminology that in order that we don't create this image that you are doing what you are doing, and you do it in another way. So that's how you navigate that invisible line. So, but our commitment is we help. The door is open for refugees and for non-status people, and they know that we help.
Anyone else? We also need to not just navigate the systems, but change the systems.
Exactly.
So if you have 100 clients come to you with the same issue and you deal with 100 clients, there's going to be another 100 to follow them if you don't identify what the issue is and then work to change it. So working with our local ODSP office, City Hall, Ontario Work staff to rearrange things so that we don't just keep seeing the same things over and over. So people that are being evicted because they didn't fill out their annual report for their subsidized housing, they're suddenly having to pay full market rent and they're going to the tribunal with an N4. So how many of those are you going to do before you realize there's something wrong with that form? So we're working to reduce a 4-page form for them to fill out every year to 1 page because they already have access to most of the information that they're asking people to find. They have it because their workers collect that information. So you have to be diligent, and I think that's one of the roles that the community organizations play, is that we don't just follow the systems, we work to change the systems.
That's great. Anyone else have that situation where you're being, the person is in desperate need of help, but you have to push back, or maybe some of you are more like Francisco and say, well, no, we're gonna go in and we're gonna help, or what do you do? Do you stand in the middle of that?
We do provide the help as well.
Okay.
And mostly the women are concerned that the system isn't helping them, not that our service isn't, that they can't find a lawyer and that the courts don't understand what's going on in their situation, or shutting down an abusive partner that's engaging in legal bullying and taking them back repeatedly to court. So it's more that we're working with women who feel the system isn't meeting their needs. And the systemic advocacy is critical in our work as well.
And for instance, in human trafficking, it's not in the lawyer's radars yet. But we do a lot of temporary resident permits. We present cases to IRCC. We protect people in our houses. We do a lot of things, and the system have been developed in basis of the work of the NGO sector in that particular area. Legal aid doesn't provide legal aid certificates for TRPs, for instance, in that particular case. The work of exploitation, labor exploitation, and the creation of this program that is open up the possibility for an exploited worker to apply for a temporary resident permit, that also way ahead of the legal career. Because doesn't create the possibility to survive as a professional, just dealing with temporary resident permits. And legal aid haven't discovered that need yet, even though we have been talking many times with legal aid about this one. So, but so far, maybe in a few years, it's going to be possible. So, and that's part of changing the system. I totally agree. We have to improve. For us, changing the system is open up the system for the new situations that are appearing in order that they understand and they can deal with that situation.
Another question I have is for gray areas of the law where it's not that they're not eligible for legal aid or legal clinics, it's just that they don't cover that. So we know that our clients come to us with cluster issues. They don't just have the one issue, they have many issues. And sometimes in conversation, you discover other issues, other legal issues that they have. What do you do when they fall into that gray area of the law where there's nowhere to refer? Any panelists want to pick that up? I know, Francisco, I don't know, in immigration, yeah.
Let me put an example, sanctuary city. It's not a law. It's a false advertising. We know that. Because, for instance, the institutions of the city doesn't obey that resolution. The police doesn't obey that resolution, doesn't follow that resolution. We are now with the city dealing every time. We know that the detentions that happen by the police of non-status people could be possible to challenge legally as illegal detentions because they are not doing anything wrong. You know what I mean? They are not detained in flagranti or anything about anything. They are stopped because the race profiling many times. And what the police do is they bring the person not to the court where a judge is going to say, this is an illegal detention, release this person. No, they bring it to CDSA. And CDSA say, thank you very much. And they detain the person and remove it. You know, I mean, we are working in that gap because that gap is totally unacceptable because we know that the legal system provides resources for this, but the authorities are avoiding to use it in order to apply fairly the procedure. So do we need an extra developing a law in order that we can stop it from happening? Yes. ID carding, for instance, have been one of the main issues that we have been involved. Why? Because it's race profiling in many of the cases, and that's the population that suffered to us. We have to continue developing these ideas under the law and provide the protection that the law requires to protect our own clients. For instance, an example that is not talking just the day because the city doesn't want to include the police in the negotiations of sanctuary city because the police said that no, not yet there. We don't get and there is no way to force the police to do something regarding this resolution from the city of Toronto, for instance.
So it's one thing that you mentioned that resonated with me is working in the gap. I feel in the work that I do that I spend my days working in the gap, working in that empty space or that void. So any of you feeling that same way that you're in the gray area, there's nothing really provided for it, so you're creating things like almost every day. You're creating ways around the problem. We can start with you.
We create ways around a lot of problems because people come to us in crises. And the crises is very small, but what got them to the crises is huge. So you actually have to take the time to sit and listen to their story of how they found their way to you and what the different overlapping barriers are, and then start to deconstruct that with each and every person. And every solution is different for each individual that comes to you. So it is a huge gap. And when there's a lot of people experiencing that, that's when we come up with community programs to address it in a broader area. So for instance, we have a free store and it's a commercial space it's a free store. People can come and get what they need for household items and clothing and winter wear, which serves thousands of families every year because there is no place for them to get that free. There's no place where they can afford those things. To get a job, to go to work, they need to have clothes. people that have jobs, that have young children, that are too old for daycare, but too young to stay by themselves, what do they do in the summertime when the kids are home? So we have a daycare. We have a day camp that the kids can participate in so that the families don't lose their jobs. So it's not just the issue of crises that they're coming to see you for, it's all of the things that impact that family's life.
And are you guys seeing the benefit of having a more holistic approach to the work that you do, where you can have access to pro bono lawyers or law students, or even lawyers, or if, I don't know, some of you have access to staff lawyers. Francisco was saying one of the lawyers leases a space, and then having access to all kinds of community organizations. So there's a daycare, there's a food bank, there's, I don't know, a walk-in clinic. So in our work, I work in a community center. So my client comes to me, I say, okay, you need legal advice, but you haven't eaten in 3 days. We stop there, we have a food bank. I walk down the hall and I say, hey, I need your help. My client needs food, something very basic that has nothing to do with the law. But I can't expect my client to sit in a 2-hour appointment if they haven't eaten. So do you find the benefit of being in the work that you do in having access to legal workers, and then a panoply of other organizations or other programs that help you get the client where they need to be? You can go with Jordy.
Yeah, I think from our end, it's critical to have those resources. And yeah, almost kind of all we do is like here's what the law says, but a lot of times people need what we call an intermediary. They need city inspectors to show up and tell the landlord to put on the heat. They need the residential housing enforcement unit to tell them that that's an illegal lockout and that they better let the tenant back in. They need CERA, their Center for Equality, Rights and Accommodation, to call the landlord and say what you're doing violates human rights. All those things are absolutely critical. To get to your kind of other questions, like an example of kind of either the gray areas, the difficulties for us. A couple months ago, I remember a client called and she got a letter from her landlord, just like typewritten letter, saying, you know, I'm planning on selling the place, you got to move out. And I got this client on the phone, and it's good, you know, because the letter doesn't mean anything under the law. It's not one of those eviction forms. And I'm telling the client this, and then she's kind of like, okay, so you're saying he can't evict me? And I'm like, well, no, I mean, it's possible for him to be able to evict you. Wrong thing to say. Legally required to say it. It's part of my job. But how she interpreted that is, oh, the landlord's going to get me out anyways. He's going to win. And I don't want to fight. I don't want to go through a big fight. So I'm just going to move, but I'm a senior and I'm struggling to find a new place to live. This client is under no threat of eviction. This client is ready to move just because their landlord said a lawyer. So I'm like, you know what? I just do everything over the phone. I don't meet with this client. You know what this client needs? This client needs EPIC. Has anyone heard of EPIC? EPIC, anyone? Eviction Prevention Pilot Program. So I send in a referral form, and then I get to the section that says, has the client got an eviction notice? N4, N5, N6, N8. Client hasn't gotten one of those. So they can't access the program. That person that should have been there to say, this letter is bogus. No. This is one of the most vulnerable clients you can imagine. And they're going to move out. And their rent's going to go up $15,000 over the next year that they're not going to be able to afford. They're going to have to leave this city. It's all totally preventable. And there is no one there to help this client. I referred to the legal aid clinic, and you can just hear it on the phone. Sorry, lawyer, fight, no. It happens all the time.
Does anyone else want to speak to either gray areas of the law and how you handle that, or how you go about your work in a holistic manner? You can go with Jacqueline, then Carol.
Well, we talked about having law students doing some of the work. We work very closely with we have a law school in London. We have the students come and do workshops ahead of time, so before they hit legal issues on cell phone contracts, on how to write a will, powers of attorney, those kinds of day-to-day things that many people face that are low income and can't afford. But we also work with pro bono students in research projects. So we have teams supervised by a lawyer on site that are research-based policy manuals and things that we put together to serve our clients better. So we're not operating in a vortex. It's in a space that we have the legal supports that make it possible to do our work.
And our holistic approach, we're not able to open a shelter because the many requirements, but we open a rooming house. You know what I mean? And we have a rooming house socially oriented, and women and children live there. They're adults, they know how to mingle together and cook together and all this stuff. So we have 3 rooming houses for refugee claimants, women, for victims of domestic violence and in the immigration procedures, and also for survivors of human trafficking. So then we have to open a clinic, a health clinic for uninsured people, because our system is not universal. And we open 2 days a week, and we see between 25 to 30 people every week that don't have medical coverage here. Access to education. We have to open a program to create access to education for youth to post-secondary education. And we do it because they don't have a way to be getting into university because they are accepted as an international students, and they have to pay $17,000, $20,000 a year. Impossible. We developed the human trafficking program in our office, responding to a need. And now we are one of the organizations that have an expertise in providing temporary resident permit application, filling up, dealing with Immigration Canada. So as I said, we respond to the need that appears in our office. We create the Immigration and Support, Immigration and Refugee Support Office with the help of the Ontario Law Foundation, because the people were coming to us for, could you please help me to fill a work permit? Could you please help me, because it's not paid by legal aid and lawyers doesn't do that, but the person has had the need to do that. So in that case, we open up and we do humanitarian applications of cases that doesn't meet the legal aid criteria, so whatever. So everything that we do is based on the needs of people that arrive, and you have to have a holistic approach. We hate this excuse of, it's an extrajudicial matter, so that's why I don't do it. Okay, fine. What is an extrajudicial matter in society? We are ruled by laws. Everything that we do is a judicial matter because could be seen under the judicial system. So in that way, I don't know how to understand this extrajudicial matter to fill a work permit form by a lawyer. Maybe it's because they are not covered to do that. Housing issues, anything. So in my opinion, we have to create the holistic approach to really deal with the holistic needs of the person that is in front of you.
And Carol, how do you guys work holistically at Luke's Place?
So we developed our services to address gaps in the system rather than duplicate. So, and there's lots of them to address. So we work holistically in the legal system through our partnerships with lawyers and our pro bono services and connections to legal aid and the protocols we have in court. And then we work holistically with the service community by being directly connected with shelters and counseling agencies. And we actually last year moved into a community hub, so we're providing services with other like-minded organizations, and so that we can provide multiple points of access for a woman for her needs. But I also wanted to talk about gray areas as well. So some of the gray areas that the women we work with encounter is getting support to pursue property issues in their family law case, and spousal support as well. So often those are areas that are difficult to address through summary legal advice, which is the kind of legal services they can access through us, as well on a legal aid certificate. They can't pursue property. They often then don't qualify for legal aid if there's property to access. And so many women give up. They just do not get what they are entitled to in that regard. And then they face a host of other issues that arise from that in terms of poverty, in stable housing. We have great, I know Toronto does, but our region does as well, great waiting lists for subsidized housing. So that can also increase their safety issues and the stability for themselves and their children by not being able to address that.
Thank you. I think I have one last question before we maybe take questions, but do you sometimes feel, this might be delicate for some of the lawyers in the room to hear, but do you sometimes feel that you have more knowledge and experience than some of the lawyers, that you're dealing with? And why do you think that is?
No, I don't.
Okay.
No. I'm just talking to my lawyer's friends.
Okay.
No, I do. And the office do, because our holistic approach. All our experience comes from working with women issues, for instance, in gender issues, housing issues, that is the needs of the people, health issues, access to education. So lawyers call us and said, hey, what about access to Ontario Works? What about this? What about that? What about family? What about, name it, temporary resident permits? We have a cultural situation here, and I think the person doesn't understand the process. Could you please help us? In many areas, do you know about this type of cases in this type of countries? How will be a good idea to present it to the Immigration and Refugee Board? Do you have expertise in gender issues? How we deal with the new trends of issues that are coming? For instance, the sexual orientation cases, trans cases, name it, no? Then the lawyer doesn't have experience dealing with that one and doesn't have the context. And we sometimes said, lawyer asked, could you please do the basic of claim form in this client? Will be easy for them because you already have developed a trust environment and the person is going to talk and we don't need to call another interpreter. Could you do it and send it to me and I will review it with the person? This is happening every single day, because lawyers are put in a very stressful situation that they need to know everything, which is not true. And here in Canada is a very specialized, society. And lawyers specialize in these type of cases. They don't answer questions about immigration because they do refugee cases, for instance. What do? They refer it back to us in order that we can fill the gap of information that the person needs. Sponsorships, family reunification, name it. They deal with a very specific issue that is paid by legal aid. So we know way more of them in many other areas that are related to the person that is in front of us.
What about you, Jacqueline?
I would agree with that. And it's not just the issues that we're dealing with, but issues that come to us. For instance, when you're helping someone fill out a disability application because they've been in a car accident, they probably have a lawyer that's covering their case, but that lawyer doesn't know poverty law. So if we connect with a lawyer before the case is settled, we're able to help them come up with a settlement that doesn't mean that the client loses most of the money. And so we do a lot of math, retroactive payments, WSIB claims that have gone on for 20 years. When they get settled, people are told they owe this money back to Ontario Works and ODSP. We have to do the math to figure out that, oh, wait, $40,000 that you're claiming should be going to this client. Going back 10 years and prorating the income taxes so that they don't pay all the money back in tax because they got it in 1 year. You have to be aware of all the other intersecting, overlapping areas. If you have to subpoena someone from ODSP head office in Toronto to come and go to court about a overpayment, then do it. Like, they'll settle because they'll get on it and look at the actual information that you're presenting. So there's a whole group of other areas that the poverty law intersects, and I think collectively we have that knowledge and we need to share it with lawyers in other fields that impact on our clients. And in that regard, one of the things that we miss the most is having a social assistance advisory committee where we can meet with the clinic training in the areas, like we're in the Southwest. We used to get to go to the clinic training. That's gone now. So we don't have access to that knowledge sharing from the grassroots with the legal clinics in our communities. We don't have access anymore to the CRO bulletins that used to come out in paper and we get faxes. Now it's all online and you have to have a code. We don't have access to that anymore. And that's some of the things that you can do to help make our work more effective and our work together more effective.
Does anyone want to speak to that? Jordy, Carol?
I think the biggest areas where we see kind of, I think, differences in knowledge, just in language. I remember a friend of mine was talking to a client, he's a lawyer, and he was explaining to them the difference between like a criminal court and a board and a tribunal, and he gave them a textbook answer. And I kind of looked at the client you could just see, and I was like, it's not a law and order court, it's a Judge Judy court. And the client was like, oh, okay. And you know, we do it too. Anyone know what an Aggie is? We talk about Aggies in my work all the time. Above guideline increase, it's just, if you're not using the language, you don't know it. So we see that from time to time, like that lawyers just sometimes so steeped in the legal work and the terminology and stuff like that, that kind of going back into the real world can sometimes be a bit difficult when you're explaining things to clients. But you folks do great work. I couldn't litigate a case to save my life. It would be like a Saturday Night Live skit if I tried, so.
So Carol, is that true for you where sometimes you feel?
Lawyers often come to us and say, you know more than we do about these situations, and that's what makes our model so effective. And we do, in our pro bono clinics, it actually is a live in-action team model. So the lawyer is with the women's advocate, is with the women in the appointment together, and there's often a lot of interpretation going on amongst the parties of the language is key, and sensitizing to a woman's situation in terms of, like, you know, you just have to fill in these documents, and you know, the fear in her eye and in her eyes, and the worker can step in and go, we can work together with you on this, and let's break it down, and let's talk about one document at a time and prioritize and those kinds of things. And we, for the last few years, actually have lawyers come to us to ask to volunteer. We don't have to seek that anymore because of the acknowledgement that we have that knowledge base to offer. Younger lawyers learn from the more seasoned lawyers in the clinic as well as the workers. So it's a system that's a real knowledge transfer for all.
So before we take questions, before we take questions, I love this panel today. I have to say, I learned a lot from you. And what I'm hearing a lot is we're standing in the gaps. We're doing a lot of the work that's not being done. You know, we're the ones standing in the gap. What I just want to say to everyone here is these gaps are not small. They're huge. The people standing in the gaps are trying to fill like this big, big void. So I just want to acknowledge that work that's being done day in, day out in this province and the people who are doing it. So we can give a round of applause to our panelists while we take questions. Are there any questions in the room? There are 2 microphones you can approach. If not, I do have a few online questions.
I want to commend the panel for the work they do. It's fantastic. My name's Doug Wellman. I'm a new bencher with the Law Society of Ontario, and it's a new world for me, getting educated, and I'm on the Access to Justice Committee. And it's overwhelming. And I just wondered if your groups, and there's others in the work you do, is it well known, or is some marketing needed to make everybody aware of what you do?
Well, more information is always better. Spreading the word is critical. That gets tricky because you have to have the resources then to meet those demands. So that's equally important, is to advocate for resources for our work, as well as to spread the word to people that we're out here.
Hello, I'm Maria from Hamilton, and thanks for this fantastic day. I just want to share something that I work for the Hamilton Legal Clinic in Hamilton, And what we do is we partner with agencies, and we've had tremendous support from the Law Society of Ontario with regards to tenant help, legal information, with respect to family law, children's aid, family law, and also with legal education project for parents who need help when their children are facing difficulties in school. So what I want to say that the partnerships are really important. We can't take on all of that work at the legal clinic, so we find partners or individuals in the community, and we help them even to put together their proposals. And I want to thank the Law Society because we're doing an amazing work in Hamilton, and I'm sure it's all somewhere in their website. So thanks a lot. And fantastic panel. Thank you.
You have another question?
I'm here from Vancouver, so I apologize in advance if my question is, if the answer to the question is obvious to those of you from Ontario. But I wonder if the Law Society of Ontario has come up with any guidance with respect to that gray area between legal advice and legal information. Have they explicitly made any statements as to what does not constitute the unauthorized practice of law? Specifically, I'd like some comfort that filling out forms doesn't infringe, it doesn't get into the area of legal advice. We're facing the same situation in Vancouver.
Is there anyone here from the Law Society who would care to venture?
But with the person or the organization that you will need to talk is with CLEO, because CLEO is the organization that navigates that exactly situation between advice and information. They put a lot of documents together, they give a lot of flyers, many things. So in my opinion, they are the ones that I don't know if they have it put it on paper, but they have a very clear understanding about the difference between legal advice and legal information. Beautiful.
For me, the organizations that I deal with mostly, they have never come to me and said, the Law Society has told us this or that. So like you said, it would be very helpful for the regulators to approach with that.
We applied for an exemption probably in 2007, and then I went to a legal conference in Toronto and spoke with some of the lawyers at the conference, and they said, you are covered under the exemption, but you don't make an application for it. So we don't charge clients for the work that we do. We're volunteers. We don't ever charge them for it, so we're going with we're exempt.
I'll take one last question here, someone at the mic, and then our time is up.
Thank you. I have a question for you all because you've been in the community for quite a while, many years, individually and as organizations. And you've been working with the community legal clinics and the legal profession for quite a while. My question is, how has the evolution of professionalization and the continuous identification of community members as clients impacted the work that you do with clinics and with community?
Well, I think in our area, and my co-panelists might share this, there's such a gap and such a need that I think that some of that is just sort of dropped in terms of professionalism. In our early days, there would be some mutterings amongst the legal community about us overstepping and that kind of thing, but I just think that there's such an awareness that the gap is so huge, and that there's that our services are critical for access to justice. So at least that's what we've experienced.
I think from our end, the professionalization wasn't done for clients. I think that's how it was built, and I think that there was some risk of people who are unlicensed taking advantage of people. But I think the vast majority of what professionalization has done is it's meant that fewer people are represented. I think that's the outcome, and I think that's been held up. I think they did an analysis of it and found that. So.
And in our case, that's something that we have to work on because we go by the tradition, or we call it clients. And, and the people understand that, the people that come, then they assume that they are clients of us. But I understand totally your point of view. I think we have to move to another level that is a little bit more recognizing that they are not clients. They are the key elements of their own process. And how to call it, we haven't figured it out, but I totally understand that that's a better way to present this to the main society, for instance. Don't to use the term client, to use something else, a participant in the program or something.
So that is it for us. Thank you very much.
I think I speak for everybody in the room and hopefully online that was a fascinating panel. Thank you very much to Alex for your thoughtful and provoking questions, and to our panelists, to Jordi, to Francisco, to Carol, and to who did I miss? Jackie, for shining a light on the reality and the circumstances that your staff and your clients face. And thank you for the vital and the courageous work that you're doing to really fill those gaps. I would say to those people who are online, because I think a lot of people who are tuning in today via webcast are lawyers, maybe think a little bit about some of the great points that were being made here about creating those communities and networks of frontline workers and lawyers who can come together to provide more holistic support for people within the communities. So we're going to take a 10-minute break and then come back to have our next continuation of this session. I will give people a quick reminder about 2 minutes until we're about to meet again. Thanks, guys.
would you please take your seats? The presentation is about to begin. Ladies and gentlemen, would you please take your seats? The presentation is about to begin.
Thanks, guys. We're back with a continuation of our community justice help conversation. So we just finished up what we were seeing, and we're going to be moving on to where do we go from here. And I'd like our two speakers to come join me up here at the stage right now. We have David Wiseman, who's an associate professor in the Faculty of Law, Common Law, a section at the University of Ottawa. David teaches and researches in the area of property and access to justice, and he's the academic supervisor for the University Ottawa Access to Justice Lab experiential education course. Julie Matthews, I think many of you know, is the executive director of Community Legal Education Ontario, CLEO, an independent public legal education and information organization. And of course, CLEO specializes in producing legal information that is accurate, practical, easy to understand, and addresses people's on-the-ground realities. They'll get started with the rest of the conversation today. Thanks.
Good morning, everyone. Thank you for joining us today. I, along with Jess, as she said earlier, CLEO is the co-host of this conference, and we are grateful to the Law Society and the Law Foundation for making this happen, helping us to make this happen. So David and I are following up on this morning's panel, and by talking about some research that we've been doing over the last year, very much on the topic of what the people you heard from this morning were telling you about. We were looking at the role of community workers in helping people with legal problems. So we are here today, and we're only going to be about, I think, 15 minutes tops, and then we're going to turn this over to you to discuss. But we would like to engage you in the discussion that we've been having. We received funding to do this research over the last year through a fellowship grant that I received from the Law Foundation of Ontario, and that enabled me to take a year away from my duties at CLEO, more or less. So our work built on the research commissioned by the Law Foundation of Ontario a couple of years ago. That report, called the Trusted Help Report, for short anyway, showed that many people in Ontario experiencing legal problems turn for assistance to someone in their local community they trust. Staff at a settlement agency, community health center, a women's shelter, library, and that these staff or trusted helpers go to great lengths, really go out of their way to give guidance and support, as you heard from the panelists this morning. But again, as you heard, and I'm just sort of echoing people who work on the front lines, which I don't, they're often hampered by the lack of clarity about that, the line between information and advice. And they worry about, risk. They worry about the risk of getting into trouble with the regulator, and in some cases with the federal funders in the case of sort of the immigration and refugee sector. So the Trusted Help Report mentioned that the effect of this worry creates a chilling effect on the work they do. So that's where David's and my research started. And just as a bit of a segue, we distributed, I'm not sure if you would have seen it, but we distributed via the link to the materials a summary and preview of the report that we've been working on. It's a summary and preview of a draft discussion paper, and that's because we're still working on the longer, it keeps getting longer and longer by the day, discussion paper. We're going to have some version of it done in November, but we do have a summary and preview circulated if you've had a chance to read it. It's only eight fascinating pages, so if you have a chance. But that's what we're really talking about today. So that's where our research started, trying to clarify the dividing line in order to lessen the confusion that's out there and to bolster confidence of community workers. And we even were looking at whether that line should be nudged a bit in the interest of access to justice. That's where we started. But as we began to review the literature and studies relating to our topic, and the topic branched out quickly, taking us to explore all kinds of other really interesting related fields, it started to shift. Sort of the focus of our research shifted. We began to talk to leaders in the community-based service sector, including all the panelists. I had these long coffee conversations with all these panelists and many others. And we began to talk to leaders and thinkers in the access to justice sector. Some of you are here today in Ontario. And several law students at University of Ottawa Faculty of Law, a whole bunch, 10 or 12 over the course of the year, engaged in various pieces of the research, which for me personally was one of the most fun aspects of the year. So we learned from community workers and leaders about the multifaceted nature of the problems they hear about from the community members who they serve, the holistic help they provide, as you heard this morning, and the good practices that they hold themselves to ensure that the guidance and help they're giving is of really good quality. And I explored some of the innovative work already being done in the justice sector, including that Connecting Ottawa initiative. Gina's here from that, and Alex was the moderator. I shadowed Alex in her couple of afternoons in Ottawa. She met with sort of one community worker after the other and helping them sort through some questions they had so that they would feel more comfortable in helping people with law-related problems. And I also, as I said, talked to many leaders and thinkers in the access to justice world and learned so much during those conversations. And those conversations and the research we did took us well beyond our original focus in looking at the dividing line and gradually led us to the view that that dividing line is a bit of a red herring. Trying to categorize problems, needs, and solutions as legal or advice risks missing the point and fails to reflect reality. Parsing language is what we were trained to do as lawyers, but is woefully inadequate, we think. Maybe this is a little bit of a bold statement, but we think it's woefully inadequate as a lens through which to approach the access to justice crisis. So what we finally did, our discussion paper took a different tack. We do not attempt to clarify the dividing line, which is what we said we'd do, sorry funders, or suggest that it be shifted. Rather, what we propose, that what matters is the quality of the support that community workers give. So, to the pith of our proposal, we recommend that community justice help for life-affecting problems that include a legal element, we don't call them legal problems, life-affecting problems that include a legal element, should be supported and assisted rather than prohibited or discouraged. We suggest that this equip, not restrict approach should be followed where community workers in the not-for-profit sector, 1, have the knowledge, skills, and experience to perform the tasks that assist people in dealing with the legal aspect of their problems. And we heard a lot about this morning about that kind of experience they bring that make them comfortable in helping people with their law-related problems and the multifaceted problems. 2, are working within an ethical infrastructure, codes of conduct, that sort of thing, that protects their clients. Those kinds of codes of conducts, ethical infrastructure, we heard are not unique to the legal profession, And in fact, those kinds of ethical infrastructures are part and parcel of most not-for-profit community-based service delivery. And 3, if they're providing holistic support, and this is a really important point, I think, that reflects and responds to the justice needs of the people in their particular community context. And I think that that was well described today, the sort of unique needs of the communities and how they respond. Needs that are frequently unmet or underserved by the licensed legal professionals available in the community. So that's it in a nutshell. 3 features that we think matter in terms of quality services, and that should be the approach to support the community-based not-for-profit sector in those 3 areas so that they can continue to deliver good quality services. And what I was struck by this morning and what I was struck with throughout the last year was the fact that this exists now. This is happening. I articulate it not as something for the future, even though I guess I call it a proposal, but it's a reflection of what's happening. We're articulating what we see as the 3 features of the great work that's happening in the community-based sector across the province. So our discussion paper includes lists of markers or indicators of the existence of these 3 features. You know, things like what do each of those 3 things mean? Knowledge, skills, and experience, ethical infrastructure, you know, community community context that reflects particular justice needs. We sort of spell out markers and elements of what those things might look like. You have to read the slightly longer paper to get a sense of that. And then we outline other key elements too. So David will say more about this in a moment. But I just wanted to take this opportunity, since a few people are here, to thank all of you who took the time to speak with me in those long sort of interviews. I learned all about the various coffee shops available in Ottawa and several in other areas of the GTA, and including my public legal education colleagues across the country. A lot of people sent me materials and they've informed our work, although I have to say, the paper itself, at this point, this discussion paper has gone through about 25 iterations, and yet so every time I talk to somebody, we make changes. It's become bigger and bigger, and so I say to my, for example, PLEI colleagues, you may not see your stuff here, but you will at some point in some future version of the paper, because it was really important. So I would love to hear from anybody here or out there. If you're interested in this topic, please contact me. I don't know. Anyway, it's pretty easy to find me, I think. And I will pass this over to David to continue.
Thanks. Thanks, Julie, and good morning, everyone. It's a pleasure to be here, and I too really enjoyed the first panel very much, and I think it does sort of reinforce the sense in which, as Julia said, the features of the proposal and the content of the discussion paper sort of is really trying to just draw out what is already happening and articulate it. So. And I wanted to thank Julie for the opportunity to work with her as she was doing the fellowship. It's been a great opportunity for me to go to all the coffee shops I don't get to go to enough in Ottawa and other places, but it's obviously great to share Julie's expertise and all of her contacts with you all. So what I was going to talk about was just 2 elements of the sort of broader framework for the proposal. One thing that you might be wondering, for instance, is, okay, if we suggest not being fixated on the dividing line issue and trying to redefine that in order to give authority to or enable the work that's already going on, then what's the alternative to doing that? Don't we need to address that within the regulatory structure that exists? So I wanted to talk to you about why we think, in fact, the way that the work is happening now and what we're proposing to sort of frame it, how it already aligns, in our view, with the regulatory framework. And then second, We've heard mention this morning of the idea of, that there's good quality help being given and that we want to assure people that the quality is good, even whether or not it sort of aligns with the regulatory framework. So I'm just going to talk a little bit about what our ideas might be around a quality assurance approach to supporting the work. So first of all, on the fit with the existing regulatory framework, as we've heard, a lot of the conversation is about the dividing line between legal information and legal advice. And we know from the training materials that we gathered from many organisations, including CLEO, that this is a prominent part of how community justice work is sort of structured and trained around. And the focus on that dividing line, of course, comes from our perception that the general rule is that anything that falls into legal advice or legal services is something that only licensed legal professionals can do, that is, lawyers and paralegals. Legal information is not regulated, anyone can do that, but if you're giving advice or services, then you need to be licensed. So we had a closer look at those rules, and as you would know, there are a bunch of exceptions to them, some of which cover the way legal clinics work or other particular types of workers like Aboriginal court workers, etc., those sort of specific categories. But there's another exception that really captured our attention and that we think can be understood as giving community justice help alignment already with both the Law Society Act and the bylaws of the Law Society of Ontario. So what is this exception? So in the Act, this exception is contained in a provision that sets out when help provided for legal problems involving actions or activities or services that would generally fall into the categories of practicing law, which is how lawyers are regulated, or would fall into the category of providing legal services, which is how it's phrased for paralegals. What this section does is that it provides a deeming that certain of those activities, if done in certain circumstances, will not be regarded as the practice of law or the provision of legal services. And so, of course, if they're deemed as not falling within those categories of practicing law or providing legal services, then they're not something that, to do them, you need to be licensed by the Law Society. And so one of the circumstances in which this deeming applies is, and this is the wording, is where a person is, quote, acting in the normal course of carrying on a profession or occupation that is subject to statutory regulation of activities by members of the profession or occupation. That's how it is in the Act. In the bylaws, the bit about needing to have statutory regulation is not mentioned, but there is an exclusion for acting in front as a representative in front of adjudicative bodies. Regardless of those differences, the important point is that in our view, when I prepared these remarks for community justice workers in the audience, when you are helping your clients with life-affecting problems that have a legal element, you are helping them in the normal course of your particular profession and occupation. You're all members of helping professions and occupations, and it's part of your normal work to help people with their problems that, as we hear, inevitably involve law. So, as such, because of these provisions, you're deemed not to be practicing law or providing legal services. So what you're doing now in terms of community justice help and the help that you may come to do in the future is already allowed and aligned with the regulatory framework. Ta-da! Congratulations. This seems useful to ponder as a way in which community justice help can be regarded as already supported within the regulatory framework and doesn't require reform of the Act or new rules or anything like that necessarily. So that's one thing that we elaborate as a sort of key element supporting the approach and the features that Julie has mentioned. The second thing that I was just going to briefly talk to was, leaving all the regulation aside, of course, everybody wants to be assured that the help that's being given is good quality help. You want to know that as you're giving it, your clients want that, the Law Society, other folks are all interested in that sort of thing. So what do we sort of think in relation to that? Sort of the quality assurance piece, if you like. Certainly you could have a licensing and accreditation regime such as run by the Law Society for Lawyers, but we don't think that it should be the Law Society that should run that sort of a licensing regime for community justice helpers. In fact, we don't even think that a licensing regime is the answer, whether it's done by the Law Society or not. We think that a preferable approach would be to take an approach of adoption of voluntary standards that are defined by and grounded in the community service and community justice sector itself. And we think that's a better approach for a couple of reasons, or at least two that I'll mention now. The first is that as members of helping professions and occupations, many of you are already subject to licensing or accreditation requirements established by your own professional regulatory entities. Take the College of Social Work, for example. So, why add the Law Society to that mix? Second, the organisations in which you work are themselves already conscious, and we heard this from the initial speakers, of the need for quality assurance and are already participating in their own self-generation of standards, but also a part of broader networks of standards development. For instance, we know that the Ontario Nonprofit Network helps to support good practices. I think it's OCISO or OCASI has the organisational sort of guidelines, support for internal organisation and that sort of thing. So we think that that would be a sufficient approach to take to quality assurance. So those were the two elements that we were just going to elaborate on a little bit for you. So I'll pass it back to Julie, who's going to direct you in terms of having some discussions yourselves.
Thank you, David. Thank you. Okay, so can you wait an extra 5 minutes for lunch? 5 minutes isn't very long, and just think how much better the food will taste, because we'd like you to maybe extend yourself. This is my least favorite thing, but then I always am glad I did it, which is to gather yourself, turn around from where you're sitting to, 5 or 6 people close to you, maybe who you don't see every day, but if you do, that's okay too. But we would like you to engage with one of the discussion questions that we've listed at the end of our paper, which if you haven't read the paper or brought it with you, imagine that. We will still have copies of those discussion questions for you. And how this will work, if some people are listening and other people can just whatever. So we're on each piece of paper that a group will get, there will be 2 numbers. And those 2 numbers will be the same. You can look at the long list of questions, and those are one of those 2 questions with those numbers that correlate with the numbers on the piece of paper. Pick one to discuss. Is that clear? You're going to get 2 numbers on a piece of chart paper. Each group of 5 or 6 will have 1 piece of chart paper. Pardon? Oh. Okay. Michelle. Okay. You have 15 minutes. Okay. 15 minutes, and then we'll just hear a couple of ideas from the audience. Okay, well, I'll finish talking later. you have 15 minutes, please, till you have until 5 to 12. Don't leave.
Okay, I'll invite you to just finish up your conversations and then we'll come back as a group. Yeah. Okay, it's great that your conversations are going on. That's fantastic. If I can call us back together for a minute, just for about 5 or so minutes, we just wanted to wrap up this segment. So the notes that are being made in the room are on big pieces of paper that are sticky. So we're going to put them up around the room and people can walk around and have a look at any of the issues that you've written down or raised on them. And we'll also so we won't talk about everything obviously that you've mentioned, but there'll be an opportunity to share. You can walk around at lunchtime or otherwise. I will ask to get a couple of input from a couple of you if someone's willing to offer something in the few minutes we have remaining. First, though, we don't want to forget the folks on the webcast, so I hope that you've also been able to take the opportunity to have a look at the questions. And we have a question has come through, which is important to address, regarding community workers helping clients. The question I'll paraphrase is that helping clients in community organisations with the legal situations may be acceptable in terms of the regulatory framework and the Law Society, but what if individuals just start doing the same, not being licensed? And certainly I would emphasise that the point of the framework that's being proposed is for embedded community workers and individuals who are working in a community-connected, supported organisational framework and offering help. Obviously, the rules around offering legal assistance, there are some exceptions that allow friends and neighbours to help people in particular situations, but we're not looking at enabling just everybody out there as individuals to help people with their problems. In part, I mean, the exception that I mentioned is about people who are members of or acting in professions and occupations rather than acting in their just personal lives. So that's certainly not something that the proposal is meant to address, and I can understand that there would be concerns if it were. The proposal is also about not-for-profit context of provision of help. We're not talking about profiting, and we think that taking profit and fee-for-service off the table, perhaps cost recovery is another issue, but definitely that brings up a whole nother range of potential problems that we would want to avoid. There's another question about the approach that the Law Society takes towards efforts to use technology to improve access to justice, and sort of generally the legal profession perhaps, or those who are trying to harness technology are worried about that being regarded as unauthorised practice of law, and that is an important issue. And I think I could, from my own knowledge, the Law Society itself is thinking, I think at the moment, about how to think about technology enhancing access to justice, and there's other, the Law Foundation is supporting some research into that too. So I think that there's some awareness of that. So that's a couple of questions that just came from the webcast. Okay, so in a couple of minutes, is there any discussion group that would be interested in sharing one or two of the thoughts that you had about coming out of your discussion, or sort of key issues that you would want to raise? Yes, Gina.
So we had question number 1 about what is missing, and initially we thought nothing was missing, and then we started discussing it. And there's a few areas, and we really like the framework, but we were wondering about monitoring and evaluation. Who is going to do that? How is that going to happen? Is there an opportunity for actually drafting a minimum voluntary standards for those organizations that are setting their own standards? We also talked about the fact that what happens if something goes wrong? Is there something like a Good Community Worker Act that we might want to consider? There was also the question about connection with insurance and mentoring and training. And then we realized, oh my goodness, we're just recreating the system. So we said, so this all has to be done in a way that doesn't recreate systemic paralysis.
Okay, great thinking. And I think, so just to mention, I mean, we won't engage all the feedback because we don't have the time, but some of those issues that you're raising are ones that immediately come to mind. And the purpose of the broader discussion paper is to try to identify and offer some thinking on those to try to manage those concerns and see how those might fit in. So I was going to give for instance, when you talked about insurance and about complaints and that sort of thing, so part of what we would acknowledge in the discussion paper is that many people who are members of professions that have colleges, there are already some complaint mechanisms there, plus many best practices within community organisations is often to have your own sort of mechanism for getting feedback from clients about their satisfaction. If there's any issues that arise, having a mechanism to deal with that. So those are definitely valid issues. And then it turns out there's also sort of practice already around some of those things. So it's trying to bring those two things together a bit. Yes, another input.
I have to respond to something you just said about the people who have colleges. So my name's Judith Wall. I do a lot of health law. I'm now retired, but I worked at the Advocacy Center for the Elderly for 34 or 5 years, whatever. And I was in private practice before that. And I am obsessed with this quality issue because I work a lot within the health system. And I also trained social workers at the University of Toronto for 5 years. But the social workers, the doctors, even Health Quality Ontario seem to ignore the law. And the colleges have been of no help. So when I've complained about forms that are used in hospitals that a social worker has developed, and now they're giving out what I consider as legal advice, is that it's all wrong, and we can't get them to change it. And I've complained to the Ministry of Health for some of that, but the colleges really don't take that up. So it's not a very good supervision body, even over those professions. I work a lot with the community. I've had great relations with people. I love the panel this morning because they're related to it. But this is a big issue on quality. How do we get systems to actually look at the quality? Because I did a research study on forms in all kinds of health facilities in Ontario. We looked at 100 sets of forms. Not a single set was correct. Not a single set. Those are major hospitals, small health facilities. We can't get the leadership to make those changes. So how do we do that? Because it just goes nowhere, and the colleges won't take it up.
Right, okay. Thanks, Judith. I mean, I guess, and totally, obviously, those are serious issues. And I mean, obviously, we're focusing on the way that community-based organizations are helping people with their work in the sort of not-for-profit sector. So I guess it's something to think about. What are institutions doing as they sort of meet with clients and that sort of thing? I'm not sure whether. So take your point on the.
It's the same thing in the community groups where they may have one of these professionals, or we have community workers. I've worked with a lot of them, and they do the same thing because they say, well, the hospital's doing that, so we think it's right. Or the doctor said this, so we think it's right. So I'm talking about the nonprofit sector or in the broader health sector.
Right. So, I mean, I think that the concerns are totally valid, obviously. And I mean, part of it is about fostering better networking and information exchange of both the legal framework and the community sort of based framework. So I think, I mean, ultimately that's part of the answer. And I think plenty of people would say that, at the same time, the Law Society is not always helpfully responsive to issues as well. So all sort of regulatory bodies probably have their own problems with being responsive. The point is more that, do we not do it because the regulators are not operating properly, or do we just find a way to make progress on that as well, I suppose? But definitely, obviously, a very important point. Maybe I'll take one more, and then we need to break for lunch. Yes. Sure.
Okay, I think my voice is loud enough. I am, no? Okay, I agree with the point that you shared. It's the question about the quality. Actually, it's very difficult question to refer to the quality of the legal services or legal advice or even legal information. My idea, legal issue, legal support started because we need to support the most vulnerable people. So we should think about what they need. They need everything. They need advocacy, they need information, they need advice. So I am not sure if there is a standard for the quality of legal issue, how we can provide this. Yeah, it needs a lot of to talk about it. What's the really standard for good quality? And I think our clients, what they need empowerment more than anything else. They need someone to provide them with yes, we are here to support you. This is my idea.
Thank you. And well, let's take one more. You're on your feet.
Hey there. We're also talking about the good quality with help, but ours is coming from the client's perspective, a satisfied client, but we unpacked that, talking about appropriate and timely referrals by the workers themselves. An informed client who understands the options presented to them and the decisions that are made. They might not be happy, but at least if they understand where it's coming from. And that could be linguistically or just like plain language. Making sure that the workers are regularly updated with changes, like Francisco had mentioned, they change every week, every day. Making sure that the information that we provide is accessible to those who need it. This covers everything from physical accessibility to comprehension within plain language, locally accessible, easy to find. Is it on transit? Is there childcare? Are they at accessible hours? Because people work. That it addresses their issues and the intersectionality of those issues. You can't sit through the 2-hour meeting if you are hungry. Making sure that there's websites, paper copies, audio, multilingual information so that they can read it in their own time and digest it in their own way. That it's offered in a way that's understood by the clients with no legal training, because people are coming in to us and we don't have the legal training. We have a little bit more knowledge, but only because we deal with it every day. Also, the idea of a holistic approach. Holistic approach was our last point. Is just that we need to treat the whole client, not necessarily just the particular problem. Probe them a little bit, find out what's really can you not keep your apartment because you can't afford the rent, because you can't keep a job, because.
Right. Thanks very much. So we need to wrap it up there. A couple more questions are coming in online. We'll try to answer webcast questions today or at other times, I think is the idea. Am I passing over to you, Jess? Yeah, okay. So thanks very much, everybody, for your engagement, and we look forward to hearing more.
Thanks, everybody. Thanks, Julie and David, for sharing the research, and thank you to everybody in the room for your collaborative efforts. Just a quick note, we'll be coming around to pick up those sheets. We'll post them around the room. We encourage people to circulate over lunch, see how the other groups came to some of their conclusions. For people who are posting their questions via webcast, what we will be doing is gathering all of those questions. We will collate them, send them to panelists, get them to answer as much as possible, and then we will post those answers on the same website where you can find our downloadable materials. We apologize for the influx of questions that are coming in and not enough time to handle all of them. We'll try and get all of those answers to you via the website. Lunch is now happening. We're going to break and come back at 1 o'clock. Definitely. I will be warning people at 12:55 that we're going to be coming back to this. To let you know, lunch is outside. Simona will direct you guys to form 2 lines around the table. You can actually circulate all the way through. We've opened the doors over here to the side to try and make sure our traffic goes smoothly. Please go ahead and get started. And those of you who are on the webcast will be back right at 1 o'clock. Thank you.
Ladies and Ladies and gentlemen, would you... Ladies and gentlemen, would you please take your seats? The presentation will begin in 5 minutes. Ladies and gentlemen, would you please take your seats? The presentation is about to begin.
Good afternoon, everybody, and welcome back to Widening the Circle, our conference on public legal education and access to justice. For the first panel of this afternoon, we'd like to widen the circle in other ways and explore chatbots, helplines, and the giving of legal information in real time. To do that, I'm going to turn things over to my friend and colleague, Michelle Thompson, who will be moderating this panel discussion. Michelle Thompson is the Manager of Legal and Digital Development at OGEN, the Ontario Justice Education Network, the organization which we both work for. After studying at McGill University and Osgoode Hall Law School, she left legal practice to pursue a non-for-profit centered career, happily, around social justice, digital culture, and communications. Thanks, Michelle. I'll turn it over to you.
Thank you, Jess. Thank you, everyone, for being here. I hope lunch was filling, but not too carbo-loading, that everyone's going to be drowsing off during our presentation. We are here to talk about chatbots, helplines, and other ways that nonprofits are broaching of giving legal information in real time. This morning, we heard a lot about one of the really perennial questions in public legal education and information, which is, how do we all navigate and walk this line between legal information and legal advice when we're carrying on our shoulders the competing concerns of really wanting to do right by our clients, by our audiences, by sort of the person we're looking at in the room, and also being really serious about some of the dangers of being loosey-goosey with some of the rules or what we know and what we don't know. So in this panel, we want to take up another one of those big perennial questions, which is, couldn't we just do all of this easier with technology? And I say that a little bit tongue-in-cheek, because I think every time this comes up, a lot of us have sort of this this hope and this fear and everything put together. And I think at its best, a lot of us are seeing opportunities for technology to give our organizations opportunities to provide information in a way that is accessible to more people, that's responsive, and that is sort of refined or thoughtful in a way that can be hard to do in the instant otherwise. And the more shrewd case may be that it's more affordable, that it's automated, that there's sort of a uniformity of services that we can ensure when we move things to a digital platform. And we are here to talk about a couple of different models of how different public legal education groups are taking on that challenge. What tools are we developing? What successes and challenges are we seeing? What audiences are we meeting, and what audiences are still out there? So to help answer all of those questions, we have, to my left, Fiona McCool. Fiona is the Digital Projects Manager for Community Legal Education Ontario. The primary website Fiona helped develop and manages currently is stepstojustice.ca, which I hope is familiar to a lot of the people in the room. It's a website of reliable and practical step-by-step legal information for people in Ontario, and she also manages social media and live chat services for Clio. Beside Fiona is Drew Jackson. Drew is a lawyer and librarian. He's worked for over 20 years providing education and information on the law. He's a senior legal content developer with the People's Law School in Vancouver, BC. He's keenly interested in making legal information easier to understand and in applying technology to help people learn. And he's here to talk about a chatbot initiative that People's Law School is working on. Beside him, we have Kevin O'Shea, who is currently the Executive Director of the Public Legal Information Association of Newfoundland and Labrador. Originally from St. John's, Kevin completed a law degree at the University of Ottawa in 2009 and a Master of Laws at the University of Turin in Italy in 2013. He was called to the bar as a member of the Law Society of Newfoundland and Labrador in 2011 and previously worked as a Crown Attorney in St. John's. Last but not in any way least is Dave Montague. Dave has been the Director of Information Resources and Technology at Find Help 211 since 2017. Before that, he spent over 15 years as the technology lead for OCASI, the Ontario Council of Agencies Serving Immigrants, familiar also to many of you in the room. Dave's primary drive throughout dozens of online information and referral projects is to improve access to services by ensuring the platforms we create are client-focused and sustainable. A lot of words that we're going to talk about what we mean by them. Great. The first thing that I want to do, just so that we're all on the same page, is give sort of each of you a moment to talk about what your organization does and what the main tool or resource is that we're going to be talking about today for the purposes of this program. All of your organizations do tons of different initiatives, but we're sort of picking one from each. Fiona, can I ask you to start?
Absolutely. So I'm going to be talking about our live chat service that we offer through Steps to Justice. Every day from 11 to 1, Monday to Friday, we are waiting to answer your questions and help you find information on the site. So we've been doing this for a few years now, so I'm going to talk about how it's working and how we do it and what we've learned from it.
Did you want to go ahead and give us some more context
so I
for that?
thought you were going to all go in a row and then come back, but that would make no sense.
We want to hear everything about this right up front.
Because that would be the shortest presentation in history and of no value
We're done.
to you.
Questions?
So, sorry, forgive me. Okay. All right, so this is my little tiny bit of PowerPoint, but it's mostly going to be talking, don't worry. It's kind of visual, so I wanted to give you a little bit of visual to it. So Steps to Justice is the website that we offer the live chat on. And so it's been around for a few years now, and it's visited more than any other site that in Clio's digital ecology, so to speak. So it's a very popular site, and it's growing and growing and growing, as is the demand for live chat. So basically, very quickly, what Steps to Justice is, it gives step-by-step information on common legal questions. It links to forums and checklists and self-help guides. So it's, rather than just like very introductory legal information, it goes right into processes. And it has lots of referral information, which is also something we really try to give people who come to us through the live chat. And we have over 1,000 detailed questions and answers and next step modules in English and French. So there's a lot of content. So I think live chat is also really helpful because it is daunting just how much is there. So it helps us we hopefully can help people find things a little faster. Although we certainly hope the site is one in which people can find things on their own. And the content covers 14 areas of law. So, and always more to come. That's going to increase. So hopefully these slides will be out of date very soon. So again, we offer the live chat assistance to users every day for 2 hours. And when we started this process, we had a researcher go and talk to people in the United States and in Canada and someone in British Columbia who was offering something similar. We did some interviews. We asked them how they staff it, what hours do they have, how much does it cost, which tool do they use. So we tried to do some background so that we could kick it off really well. And we piloted it on a different website that I used to manage called Your Legal Rights, which allowed us to get our skills down before we launched Steps to Justice so that we kind of knew what we were doing in live chat before we launched this new site. And we originally had one operator, so to speak, who also was the person who answered all of our outreach emails. So a lot of websites have legal information, just sort of like, don't ask us any questions kind of thing. But we've always said, if you need information, we can't give legal advice, but we will answer it. So we've always answered 20, 30 emails almost a day on the site. So the person who was doing that anyway was our chat operator, and they actually were located far away and did this in their pajamas and stuff. And they were doing that using the first tool. And as the site grew, the demand grew. Sometimes she reported that she had like 21 open sessions at a time. It was like really stressful. So at that point, we switched to a new tool, and she announced that she would like to retire. And I wept openly. And then I forgave her, and then we figured out a new way to staff it. So we were like, what are we going to do to handle this increased demand? And so smart managers at Clio decided that we would actually staff it with the staff at Clio. And so our organization is mainly made of lawyers and plain language editors, and then a bunch of project managers like myself. So we put the plain language editors, they know the content really well. It's really important for them to know the kinds of questions people are asking and how they're wording those very questions. So we each take a shift a day, and that's how we started doing it. So then we'd have these weekly meetings. We talk about which questions people are asking. It gave us a lot more insight into what the users wanted to know and what they weren't finding, even though we knew it was there. So why aren't they finding it? Different ways to kind of word things. Even though it was hard work and a steep learning curve, it did seem like a better staffing model. And then increased demand, so it started going from 30 a day to 60 a day. And our new tool allows us to kind of put people in a queue, which is better than them just not like wondering where we are kind of thing. So now we have two. We have like one person that does it remotely every day, and then we have that staff person as their second. So again, it gives us that internal knowledge, but it also just allows us that reliable person who's going to do it every single day. So when someone comes onto the chat, our job is not to answer their legal questions. Even if we have helped write and edit the material and we know the answer, we do not that we tell them where to find it. And so that's how we sort of get away from that provision of legal advice thing, because what we're doing is we're saying, oh, we have information on that. This might be helpful. You'll find it here. And then they ask a follow-up question. We're like, again, this is like addressed here. And then if it's not, we make a referral. So it's very important, although the user doesn't think they're asking for legal advice. And I, as a layperson, I think Dave and I are non-lawyers. Everybody else here is a lawyer on the stage. Most of you are lawyers. But I wouldn't think that what am I supposed to put in this box on a form? Right. I wouldn't think that was legal advice. I would think you should just know that, and you should just tell me. So I think, and then we don't, because it is. I mean, that's what I've learned. Anyway. It's not always what you should do. It's literally like, no, this is information on the form, and here's a place you can go to get guided assistance with filling out a form. And if you have questions about that, you can go here. So this is a thing we do all the time. So we use a tool called Zendesk, and that's not very expensive. You pay per operator. So if demand increases and we have to have more and more operators, our costs will go up, but it's not that much. We also, this is what it looks like in the corner of the site. So when you come on, you have a little icon that tells you when we're open, and then you kind of have to read our little disclaimer that we only help people in Ontario and that we don't give legal advice. And they ignore that, of course, as you all know. And then in we go. So they give their email, and then they start asking the question. So when it appears to me as an operator, bing, it's that question. And sometimes they just say, hi. And I have to go, hi, can I help you? Anyway, and so in they go. This is something that you probably wouldn't be able to read in detail unless you were bionic vision. But so I wasn't exactly sure how the setup would be here. But if I remember, this is somebody asking a relatively complicated family law question about how they get along with their spouse. They have a whole bunch of issues, but they're not in conflict. Like, what do? They have to get a lawyer and go to court and so on.
If I could just interrupt to share, just so everyone knows, you can grab these slides off the downloads page on the OGen website. So either right now or later, if anyone would like to go and actually look at how one of these chats is playing out, it is available there. It's on the page. You can go grab it.
And I would love an excuse to be emailed and to talk to any of you about this, so I could force you to ask me for the slides, and then we could talk about it, because I love talking about this kind of stuff. Anyway, so this is an example of someone saying, we get along, we don't want to go to court, we don't want it to be a big fight, but we have all these different issues. So we have a general automatic reply that is pre-written that explains that, thank you for your message, we can't do this, but we can do this. We're dealing with a bunch of people, we'll be with you in a second. That's automated. They get that automatically, but it's not a bot. It's just a triggered message that they get. Then we jump in with, give me a second, and we'll have these things called shortcuts that I've written that kind of say, oh, I'll look for that, just give me a moment. And that allows you to deal with 3 people at the same time without them waiting and wondering if anyone's there. And then we jump to the question, and we use very careful little intros that, again, we've pre-written that say, this question deals with that and may be helpful. So we use language that's not like, oh yeah, it's here, you got it, no problem. I've got it all solved for you. No, it's like, this question deals with that, it may be helpful. Then we follow up with an additional second question about how to avoid, ways to not necessarily have to go to court to deal with your family law issue, et cetera. And then we make a referral to one of our services pages. So for every one of the hundreds of subtopics we have a set of curated services that we feel are the ones people should go if they need more help than they're going to get from legal information. And so we give them that. If the person's in some kind of crisis, and we feel that, and which happens, that someone's having an immediate eviction combined with an income issue, if we can detect that their language skills might not be able to handle the site, or we can see that they haven't clicked any pages, they just basically went to the home page and immediately chatted with us, we can see what they're doing. We can see when we send them a link if they actually go to it. If they just keep asking and asking and asking because they can't really deal with the information, that's extra information and insight for us that they need a referral more immediately. So in that situation, we would probably say, go to your legal clinic, because they're kind of Ontario's first responders when it comes to bundled legal problems. They're going to give that person sort of a better handoff than we can. So sometimes we might also just give them an answer if the question's really self-explanatory, which does happen sometimes, and we know they can get a definitive answer from the question, and they go, thank you, that's great. We don't necessarily give them a referral because it's clear that they were doing a self-serve thing, and the site served its purpose. This is, again, another transcript that you can't read, and on another topic. So I won't get into that, but there's countless examples that I'm happy to explore. And we also wrote these shortcuts, which we write for every possible situation. Just today, one of the operators sitting next to me as I was waiting to come over was like, lawyers and paralegals keep asking us to help them with their work. On live, I'm like, oh, we need a shortcut for that, a polite, properly written response. So I sent, a little response, and we'll turn that into a thing. So these are really quick ways that we can all agree on common language and so on and so forth. So these are just some numbers. I thought it was important to have some sense of like the overall traffic to the website versus the amount of people who chat in 1 month, for example. So you can kind of get a little bit of sense, because it's hard to really know. Like if I say that we had 1,036 individual people that we did live chat with in a month, I think that number's high, but how does that compare to the amount of visitors or sessions to the website? So again, this is just a month, but it's just to kind of give you a sense, like of the 358,000 people, and these are again sessions, which are like the closest you can get in Google Analytics to the amount of like humans that were on your site. And then the amount of chats we did was 1,000. So you can kind of do the math on that. And then underneath that, if you can read it, you can see the most asked about legal topics. And that's like a manual sort of statistic that I crunched just because people at CLEO want to know. And so it corresponds to the popularity of the topics on our website, which is logical. And those are family law first, employment second, I believe, and housing. And so after that, you get into sort of courts and tribunal stuff. I would say the difference would be that there would be more questions coming to our chat about court and tribunals and some of these forms and processes, and probably more traffic to the site and things like income assistance and things like that. So, but generally speaking, the things people are asking us about in the chat correspond to the topics and the popularity of the content. So for me, that's sort of an example of the statistics we get from our tool. Shows you that the average response time is 42 seconds. So people aren't waiting for a very long time. If any of you, have you done live chat like as a consumer on websites? Like, does this come in a size 8 or whatever? Or Rogers or Bell, like, why is my bill wrong again? Yes, I'll hold, whatever. So you may have done live chat for a variety of reasons. And so, you know, you may have a sense of an industry standard, but I think 42 seconds is a reasonable amount of time to wait. And then the average length of each session is 6 minutes. That's quite high. It's not like they're coming and going. So that's a lot of back and forth. And sometimes we leave that open. We can't move on to the next person until we close it, but we don't want to close on people too soon, even though they can come back. But it's just that feeling that we kind of leave them a message explaining that if they want to email themselves a transcript of our discussion, they can after they close it. And then if they don't say anything for a minute, then we close it. And again, we have these shortcuts. So I've written shortcuts that you put little tags. And you know, someone's outside Ontario, for example. We can tell from their IP address that they're from Edmonton, and they're asking me tons of complicated questions about employment law. And so I might see that they're from Edmonton from their IP address, and then I have a little shortcut that I type in outside Ontario, and it preloads. It doesn't send. It preloads for me a pre-written thing that I can then slightly modify a little bit and say, if you're from outside Ontario, but you have a legal issue that, you know, blah, 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 you can call Legal Aid Ontario. Here are a list of other organizations in your province that perhaps you might want to consult. And then we were getting tons of people from outside Canada, really mostly Americans who just wouldn't keep asking us for questions in criminal law. And I'm like, what is this? Like law and order. Anyway, so I went into the back and I banned the IP address of all users who are outside of Canada. I had to do it country by country, so I learned the names of lots of nations, small island nations.
That don't have robust public legal information.
Exactly, that I had never heard of. So it was a good geographic learning curve for me as well. Anyway, so we have hundreds of these, and happy to share those with anyone and anyone. And if you guys have them for your services, it's really great. So again, they're not bots. These are things we wrote, and then they're things that we pull up to send to people, and we can edit them slightly if we need. But they provide consistency. They mean that we all are on the same page about how we want to respond. And we just created a policy for banning users because we just got, it's always like these things happen because you become successful, then you become targeted by annoying people. So I think some high school students in Kamloops, anyway, so people with the name, you know, Ben Dover and so on. Anyway, so we had lots of mischief where people are like asking us questions and it's like clearly nonsense. And we're like, sorry, we can't help you, sorry, we can't help you, sorry, we can't help you, and they keep coming back. And so we now have a policy where we like, you know, sorry, we can't help you, we're very professional, and then we close it, then they come back, then we tell them that we have this policy and that we reserve the right to ban users who are acting inappropriately, and then we can ban them by their IP address. And they can still access steps to justice if they really want to read in Kamloops in high school about Ontario employment law, but they don't fill up our time when we would like to help users with actual problems. So that's something we had to learn, you know. So that's one of those things, if you're looking at live chat, think about some of these features, whether your tool comes with them, because they've been really helpful to us. And I have this operator's guide that now that I have so many people doing the chat, it's more work for me to train people, but it means that I have more of a reason to make sure I have a really good operator's guide. So it has screen captures for like everything, how to email a transcript, all these, and it has little scripts in it. You know, what do you do if someone has a complaint about our content? What do you do if somebody, you know, is suicidal or is talking about self-harm? What's a good referral for this? So on and so forth. So we try to, and then we have the shortcuts, which we update every time. And we just keep that on a shared drive. And every time I update it, I email everyone and say, you know, here's what I've just added to the operator's guide. Please read it. Some of the people like to print it off and highlight it while they're doing their shift. Other people just like to keep it in their noggin. But it's all there, and we update that all the time. And I'm sure you have questions, and I don't know if the format is one where they would ask now or later. But that was the end of my slides, because slides are kind of boring. But I'm happy to talk about anything people
Great, thank you for that. That's a very, very fulsome introduction to the live chat service, which we appreciate. Drew, I assume you have an equally detailed presentation you'd like to share.
No, I don't actually. I've got a couple of slides, but wow, that's quite an active follow-up. Nicely done, Fiona. And I'm amazed that you pierced through the high school Kamloops-based persona that I was adopting. So I'm from British Columbia, and
so it's just him doing it all.
That's right. Yeah, that was not me going under the name Ben Dover, was it?
Yes. Yes.
So I work in Vancouver at People's Law School, a nonprofit sole-purpose PLEI agency in British Columbia. There are a couple of sole-purpose PLEI agencies in BC. We are the oldest, fun fact, oldest in Canada, started in 1972 as a sole-purpose public legal education agency. And we have about 10 full-time equivalents, to give you an idea of our size. When I hear Fiona's description of they have a 2-hour window 5 days a week for a live chat, and they're getting 1,000 inquiries a month, that to me is one of the key drivers for us at People's Law School to be exploring chatbot technology. I also heard Fiona say it's not a bot a couple of times in a way where maybe it was just me, but I was sensing like, you know, bots are bad. For Fiona, and I'll speak to that a little bit, probably a bit more through the panel part of things, but just a little bit more on what we do at People's Law School. We, like many of the public legal education agencies across Canada, focus on our own province, British Columbia, and provide people with legal information and education in a variety of formats, from live classes to printed booklets to one-on-one help, to increasingly digitally. So we operate a couple of flagship websites, our own peopleslawschool.ca site, which I think of in my own head as being like a baby or teen version now of Steps to Justice, growing up to become more robust topic-wise, but follows a similar kind of framework in some respects in terms of its very step-by-step information and really oriented around the problems people have in their daily lives as compared to the legal system as the starting point. In terms of chatbots and what got us going down that path, we do not offer a live chat service at People's Law School, but we do have a Q&A service we offer through our website, which is a form that people can fill out a question, and it generates an email. It goes to our staff, and we provide email information in response, and we now get hundreds of these coming in monthly, not weekly the way you are. But and certainly through that experience, we can see that there's a huge appetite for people to get that kind of one-on-one help from even an education information provider, which is not, we're not positioning ourselves as being offering one-on-one help. We're positioning ourselves as offering information and education that a variety of people can use to move forward with what they're working through. But there's such a disconnect between the information available, which is getting increasingly robust and nuanced and accessible, I think, on the one hand, and the problems people have and the difficulties they have translating their problem in their words into what information would be helpful. And that is, to me, one of the key drivers behind us getting more interested in chatbots. The other context piece here is earlier this year, at People's Law School, we took over a website called Dial a Law, which is, I wince whenever I say dial a law because like nobody dials anymore. It started as a phone service 35 years ago operated by the BC branch of the Canadian Bar Association, and they have operated it throughout the last 35 years, and they decided recently to step away from a direct public legal education, being a public legal education provider, and we said, hey, we would love to operate that service. So we stepped in and relaunched the service as a website, a fresh website. It had been a website, but it's we think, a better looking site and a more accessible one. And it continues to be a phone service, so you can dial or tap your phone and get pre-recorded messages on 130 plus topic areas. But as we took over this service, the Law Foundation of BC, which provided incredible support for us in taking over the service, invited us to do some research in trends on how people are using their telephones and how they're accessing information. And so this became a real key driver in going down this path that we're now on, building a chatbot. So among the research findings that we found was the degree to which texting and messaging have become such a big deal. 9 in 10 Canadians now text or use messaging apps. And texting and messaging is the single most frequent activity people use on their mobile devices. And a significant percentage of Canadians have their own mobile devices. Not everybody, and that's why certainly at People's Law School we're committed to providing information and education in other formats as well. But this trend line is really clear. And then as well, another trend that our research revealed for us was that this concept of chatbots is really taking off. Just a quick show of hands here. How many people have heard of chatbots, the concept? Okay, so a meaningful majority, but not everybody. And then how many people have used or believe you have used a chatbot? Okay, similar. And the reality is they are quickly becoming very widespread in their use, from businesses to help people solve problems when you're calling or complaining about your phone bill, to much more sort of applicable to law type situations like health providers. There's some really interesting chatbots emerging in the health space. I don't know if you've heard of one called Wobot, but it's an example of a bot. This one was developed by a Stanford University psychologist, and it's using cognitive behavioral therapy principles to have a conversation with somebody who's struggling with mental health challenges. And it's pretty impressive. You know, it's not as good as an in-person therapist, but I would suggest it's a pretty compelling use of technology that is reaching people in a different way, and sometimes in a way that is more where they are wanting to meet, if you will. And that's one of the things that at People's Law School we're increasingly trying to do, is use technology where it can expand our reach and reach people where they are. And so British Columbia, like Ontario, it's a very big province. It's hard for us to reach somebody in a more remote part of the province. And so through technology, it's a game changer in terms of our ability to reach people fully across the province, and the numbers of people. And this loops back to the idea of scale, is that chatbots, early days, lots of learning about whether or not they're really going to be that helpful, but the potential is to be able to reach orders of magnitude more people for less resources. And that's a big deal, because when I see those numbers of the service that PLEO is offering through the Steps to Justice 2 hours a weekday chat, the appetite is huge, and the ability to meet that demand is very difficult. And then last couple of thoughts around why chatbots specifically is that one of the powerful things about chatbot technology is that it is multi-channel. So by that I mean a chatbot that you develop can be deployed or used across many different channels of where people are accessing information. So over the web, yes, for sure, but also over messaging platforms like Facebook or over the phone, which is where we started with Dial-A-Law in terms of exploring what would the future of Dial-A-Law be for us at People's Law School. So with our chatbot, which I think there's a couple of slides here. Okay. just to wrap up, a few screen captures to show you how this works, because it is still in development, and we're taking a phased approach. You can see the chatbot's name is TBD, so to be determined. That's how early we are in the development of the chatbot. And we're releasing it initially on Facebook Messenger, and that's a strategic decision around, Facebook's got a lot of downsides, but it is a ubiquitous platform, and it reaches a lot of folks who don't necessarily go on the web. For many folks, many communities of people, Facebook is the internet. Yeah. And so to be able to expand our reach at People's Law School into Facebook as a first iteration, but we'll quickly follow it with other channels, so it's not like we're putting all our eggs in the Facebook basket, if you will. That is a potential game changer for us in terms of being able to reach populations that are not otherwise finding the People's Law School information. So the way the bot will work is that people initially will be offered buttons. So we're building what I call a button bot or button-based bot. And then in a subsequent phase, we'll layer in artificial intelligence, natural language processing, so that people can put in their own words, and helpful stuff, if we're successful, will come back. But here you're seeing a couple of screens from the phase 1 button bot in Facebook Messenger, where someone is presented with some options, and then as they progress through the interaction, they've selected on an option to get information around how to deal with a service provider where they're not happy with the service that has been provided. And so you can see the screen there that says, if you're not happy, some steps you can take. And then we have a framework of what to know, work out the problem, and get help. And that's our People's Law School model. It's a bit like a comparable model to the Steps to Justice model. And so someone in this instance has selected what to know, and there's a chat-like, conversation-like experience that they then navigate through. Tell me more, a bit more back and forth, and at each point, we're trying to keep it conversational, so not screens and screens of information, and then give the user options about which button to tap to move forward through the interaction. So that's a few screens to give you the flavor.
Great, thank you, Drew. That's really helpful. Kevin, maybe you could tell us a little bit about the helpline that you guys run.
Sure, so I don't have slides. I'll just kind of give a brief overview of our service. And I'm coming from a bit of a different context, a province with 500,000 people, sort of different scale than BC and Ontario and other bigger provinces. But we operate a daily legal information line and lawyer referral service. So my organization, PLEI, Public Legal Information Association of Newfoundland and Labrador, we've been in existence since 1984, but we've been running the province's only lawyer referral service since about the early 1990s. And that was a partnership with the Law Foundation of Newfoundland and Labrador, and is really tied to our funding we get from the Law Foundation. That was the reason for our funding from them. So it's primarily a phone line, but it is available by email and in person as well. But as I'll talk about through our discussion, phone remains the most popular option, the most used option, which has been a bit of a surprise to me, but that trend has continued. So we do operate it daily. It's run by staff internally at our organization, and we run it Monday to Friday from 8:30 to 1:30 p.m. So 8:30 a.m. to 1:30 p.m. And that's a bit of an expansion. We were doing 9 to 12 for a while. Our staff capacity increased a little bit, so we've expanded the hours. We also added a Wednesday night option. We have a staff who comes in 6 to 9 p.m. on Wednesdays, which has been really popular. And in fact, a lot of people with legal questions relevant to the province, but who are living elsewhere in Canada, often call in during that time because the hours are more convenient for them with the time zones. So we provide that general legal information over the phone. What I usually say, try to navigate people, point them in the right direction with their legal questions, legal issues that they have. And then we also run the lawyer referral service. So we have about 45 to 50 lawyers on our roster. They register with us every year. We do a re-registration process just to make sure our information is accurate, get them to tick off the areas of law they will practice in and take referrals in. And then our deal with the lawyers is they'll provide a 30-minute consult for a flat fee of $40, tax included. So that's the service, that's the system. We're averaging about over 3,000 inquiries a year, so about just under 3,100 inquiries, so by phone, email, and a little bit in person as well. Of those, we roughly will give about a third of those calls get referrals to lawyers. So they're requesting a referral, or in the course of the conversation, the person decides they'd like to get some legal advice and chat with a lawyer, or sit down with a lawyer. So those trends have been, the ratio I think has been pretty consistent. The areas of calls have been pretty consistent. And what's also been consistent is more people are calling us. Even though we advertise equally, you can email us, you can come into our office, or you can call us. We're still getting mostly calls. So about a third of the inquiries are email. A very small percentage are people coming in person to our office, but most are still phone calls. So it's kind of reinforcing that idea that the people are wanting that person-to-person contact, to actually chat to a live person, and at least as a first step. We do get follow-ups, often repeat clients, and sometimes that follow-up might happen by email, but very often the first contact people want is by phone. I'll just get a little bit into the stats, and I know we'll have some more discussion on it, but I think similar trends to the bigger provinces where there is similarities is the areas of inquiry. So again, roughly about a third of our inquiries are family law, which is not really surprising. I mean, most people coming to us are self-represented litigants. So the areas are, the big ones where you'd think a lot of self-represented litigants would be engaged in. So family law, civil litigation, kind of broadly speaking, but particularly small claims matters. And then the other major area is wills and estates matters. So that could include probate and administration of estates. And there you see a lot. We're noticing a big uptick in self-reps trying to navigate through those processes. And then a whole assortment of other things. About 10% of our calls or inquiries are criminal law in nature, and then a whole range of other areas of law. I might leave it there, and I know we'll have some further discussion, but that's just sort of a general idea of what it's all about.
Thanks, that's really helpful. And Dave, can you tell us about 211 and about Find Help?
All right, so I'm going to do a show of hands as well. Do people know what 211 is? Oh, that's pretty good. So just for those who don't, 211 literally is a phone number that you can call, just like 411, 911. But 211 is social services, information and referral around social services. And in one form or another, in Toronto, it's been around for 60 years. 211 itself as a concept started in the States and migrated here in 2002. So the CRTC and all that short code kind of stuff, they set it up. And so starting in Toronto, you can dial 211 on your phone, and there is a certified, they call them system navigator now, but a counselor who will take your call, do some triage, and try to refer you to the right service. And so, starting around 2008, it's grown out to Ontario-wide, and then slowly morphed across Canada. But so 211, as it says, is a phone-based system, and it has been. I started there a few years ago, and just like you were saying, calls are sort of steady. The 211 calls, and just to give you a sense of the scale, in Ontario, it's about 200 to 300,000 calls each year. And I was looking at some stats around the legal stuff. About 10% of the calls fall under what would be considered legal classification. So that's about 20,000 calls across the province. So the types of questions, or the people that are calling around basic needs, income support, health, housing, mental health and addictions are always the top ones. But legal information was about the fourth, which I always thought was kind of surprising. So and just to give you a sense there, the the platform itself, like I said, it's Ontario-wide. There's distributed models. So there's people in Thunder Bay, there's people in Niagara Falls, Windsor. And so people can get local information. You dial 211 and it routes you to the right place. But I think the reason I was brought here too was this idea of we're a generalist, right? It's not just legal, it's everything. And so on the one hand, that's really great because if you don't, like the slogan is when you don't know who to call, you call 211 and they will get you started in the right place. But when I've come in, and one of the things they asked me to do was, well, Dave, how can we get the calls or the contacts moving in a different way? Like you said, people don't want to call anymore. And as the generations change, people want to interact differently. So the first thing we did, is we brought in chat and email. And when we finally got chat really rolling out, it went huge. We had it sort of just piloted, just sitting around, and we get like 4 or 8 a day. We put it on one of the websites that's a popular immigration website here in Ontario, settlement.org, and literally that one day went from 4 to 100. You know what I mean? Like, so there's a definite desire to have this online interaction. And what we found around chats were things like people wanted to talk about things that they might not want to talk about on the phone, poverty and food banks. So there was this real sense of the anonymity is even more so that way. So the other side of it, though, with the chat is, or for 211, we also have a directory of services, about 60,000 records. And these are literally run the gamut from, legal clinics to health clinics to everything in between. And that database feeds a bunch of websites and people can search. But one of the groups, a group came calling to us saying, Dave, we want to do a chatbot for people experiencing homelessness, and we want to help them find shelters and free meals. And this is the kind of information that 211 collects, and it's hard for other groups to collect. And so what they wanted to do was connect with us through all the little techie bits in the background to be able to feed their chatbot. And we've had, on the one hand, it was quite as a director of technology, I'm like, of course, we will absolutely do this. But then, then you take a minute to realize, well, what are all the other things that go along with this? Because as much as I am a proponent of things like chatbots, I also understand, and a lot of us will, they won't solve every answer. Like it's, high complex questions and all of that kind of stuff. So I'm sure we'll get to that. But so the 211 has sort of, we are on the chatbot train, if you will, but I think it's as a data provider, but also as a quality control person as well. Because that was the thing, we had the person come in and review the chat logs that we do. Like I said, we do about 1,000 chats a month now. And it's just literally with no promotion, no marketing. The fact is if you put these chats on these different websites, like if you took the Steps to Ontario or Steps to Justice and you put it on other websites, it would be 2x, 3x. It's all about exposure. And the same would be true of 211. As soon as somebody sees live help, they're on it, especially with the kind of questions that people need help with in our situation here. So I'm going to sort of stop there. But the idea being that 211 definitely sees a value in the chat, especially, because it can be more productive. You can run 2 or 3 at a time. And the chatbots, personally, I feel that they are inevitable and that you need to be part of that solution, I think, because they're absolutely going to come. They're going to come with for-profits just doing it. And if you're not involved, you're just going to run right over. And I think the service and the client will suffer. So that's kind of where my head's been at on this one.
Sure.
Yeah.
Thank you, Dave.
Yep.
I wonder, actually, just picking up on that last point about feeling sort of the inevitability of a trend towards more automation. Fiona, have you guys thought about introducing more heavy automation into Steps to Justice chat? What sort of considerations has led to your approach, which I understand you have sort of a bit of it in the scripts almost are
Yeah, it's a bit of
an
a blend.
analog.
It's definitely not a bot. And I have like a million questions for Drew's bot, and I'm like, how about messenger and security and privacy and all that? But anyway, I'm not allowed to. You're supposed to ask the questions. But anyway, so with our triggered questions, that's kind of like a bot. It's like you ask something and you get a trigger back. But the pre-written scripts are certainly like we as humans decide which quick little messages are the right ones. So we are scanning and making a very quick decision that this is an employment issue, so we have our employment services shortcut. So we just write the word employment and it pre-populates. So it certainly, the technology allows us to serve people much faster. Like we're able to give them 3 or 4 relevant things in a matter of seconds because we could just read and type a few letters. So, you could say, but it's certainly not a bot. So one of the things that I was, struggling with, because I was trying to figure out if we could have a handoff, because some tools do a nice blend where a bot is who you get at first, and then at a certain point you're given a choice, you know, because the bots are supposed to use AI, artificial intelligence, to get smarter. So the idea is that your bot will get better. And also it could be my own bias because we did test a few bots. And my experience with them has been, was this helpful? No. Was this helpful? No. Was this helpful? No. Was this helpful? No.
Now, do you ask that on live chat?
Well, they rate our chats overall, and they're like 6% of the people who chat with us give us a rating. And I always think those have a bit of a bias.
Sure.
Like you're more likely to rate something negative because you're. But if that were true, then our ratings wouldn't be about 80% positive. So I think, given that only people who complain rate things, I think that's pretty good. But anyway, but the idea of a chatbot handoff, so the idea that you have a few interactions with the bot, and then you have a choice at that point to go to a live chat agent. And that chat agent is a human, and you explain that. So a blended model would be great, because you could sort of have some triage happening, and I imagine you'd lose a percentage of people for whom the bot successfully found them something very straightforward. But I think for a lot of the questions we have, it would be, I imagine, frustrating, that's all. So I think we just felt that we wanted to try to do it with human beings, because we imagined that it would be, that the experience might be frustrating. But at the same time, when I see some of the innovations and interesting ways that Drew's organization is, you know, sending you already a bit of a container. You know, it's like, are you interested in consumer law stuff? Oh, you are, okay. So already you've created a container and you've led me a bit, so that you're not just having my big, giant explanation for 6 paragraphs of my multifaceted, complicated, terrible poverty situation. Like, oh, you asked about, you know, you're hungry. Are you interested in, like, it just seems like my bias a little bit is that they could just be so, if you get that wrong, oh my God. But at the same time, there's obviously some innovative ways to, you know, get around some of that open-ended, giant, empty script of problems. So I like the way that Drew is developing it to guide people a little bit before they're, and it looks like your tool doesn't encourage big, long questioning. It sounds like you're leading them rather than you trying to interpret their paragraph with AI. But I also assume that the chatbot is as good as the knowledge base it searches.
Right.
So because we already had a website with thousands and thousands and thousands of pages of legal information, we would have to have a bot that could crawl that constantly. And that's not necessarily the way they're designed. No. They're often designed, and again, I'd love to be told I'm wrong, but they're often designed at the time you develop your chatbot, you develop your content, and then you develop like what's called a knowledge base or a complicated FAQ, and then you have the bot crawling it, and then you launch both together. So for us to have a website and have a chat, it wouldn't have been technically able for it to be smart enough to be constantly reading and learning from the content. Right. So you may have both solved those issues some other way.
No, I mean, and maybe Drew's the same way, but it's the idea of setting the scope. Like, yeah, when the chat bot when they first came to us with it, the first demos were always horrible, like just you know, just ridiculous, and it would be like simple things like, where is a free meal near me, and then it's like I said, it's as good as the search behind it. But again, it just keeps getting better and better and better. And that's where I think, yeah, being part of the process, I think is really important. And for a lot of the 211 stuff, it's can be as simple as what is the nearest thing near me, like the most relevant service near me. Yeah. Whereas I think legal, and we'll talk a bit about this, I'm sure, but so many of these legal questions are so much more complex. And so I really sort of see this future state where, you know, high needs are still on the phone or in person, but the self-service that people want is what they're going to come to expect it. They don't. Some of them don't want to talk to a person about these things. So, yeah, that healthy mix you talk about. I mean, and that's the chatbot that we've been working or been sort of contributing to has that sort of split at the end. You know, did you find what you're looking for? Yes, no. Hey, call 211 if you still need trouble. So. Right.
I'd like to pick up on something that both of you have touched on, which is sort of the desirability of human contact sometimes and the desirability of anonymity sometimes. Because I actually hadn't thought about this from the perspective of someone who is disclosing information that makes them vulnerable, and how I can completely understand how for one person you want that to be within the relative warmth of a phone call with a human voice, and for someone else it's much more comfortable to type numbers into a bot and get a response. I was wondering particularly, Kevin and Drew, maybe if you guys could both speak to, Kevin, I'm interested in hearing more about why you think the phone line has persisted as the most popular way to use your legal information line. And Drew, maybe after that, you could give us some context on, are you trying to keep or simulate a human touch within your service? What do you think is the value of that, and like what does that mean?
Well, one of the trends we've noticed at the organization, and one of my staff members has been with us for close to 20 years, so she's seen real evolution in the service, and she says to me almost on a weekly basis, the calls are getting more complex, and people are coming with multiple problems, multiple questions, and they're often have been through a number of other agencies, or many of them have had representation from lawyers already. They can't afford a lawyer anymore, or something's happened, so they're now self-representing. But that's the consistent theme, is that the calls are getting more complex. And with that, where I find, and our staff are finding, that a lot of times the legal issue might be just a small part of what people are calling about. And there's really just a need for even the validation that, yes, we hear you, there's a problem. There may not be a good solution, there may not be a lot of options, but we're here to listen. And then I was thinking about the panel this morning talking about addressing the holistic needs of the client. And I think we're finding that more and more as well, that we're not just focusing narrowly on the legal question, which I think we were in the past. Much more was people call in, get the name and number of a lawyer, and go on their day. But now people have the legal issue, but it's also maybe tied to a housing issue, to health issues as well. And we're able to offer some referrals to other community agencies and other supports. But I think the need is there to try and address much more the holistic needs of that person. And I think that's where you need that person-to-person contact still. And even if it starts with an email, there may be a follow-up phone call, or at least, like I said, that initial telephone call to talk to a real person and get that validation that, yes, we hear you, there is a problem.
Drew?
Sure, so a couple of thoughts. One around people offering help as compared to technology offering help. I'm certainly an enthusiast. If we can have people help, that's better. I can't imagine almost any context where I would be advocating for, no, let's have technology solve this instead. It's about the gap. We heard about it this morning in a different sort of context around licensed legal service providers not being positioned to help this huge body of folks. And so community workers can help step in and have stepped in to help fill that gap. And in a similar kind of spirit, I see technology as having a role in helping to bridge the huge gap. In terms of the specifics of a bot, one of the things we're learning about as we move through this development process is the research so far is showing that people want to know whether or not they're interacting with a bot. They feel deceived if they think they've been interacting with a person and they discover at some point in the interaction that it's not a person. So we don't want to be hitting people over the head with it, but we're right out, the first part of the interaction is, hi, I'm so-and-so, to be determined. I'm a bot. So being clear right up front that it is a bot.
People ask us all the time, are you a bot? And we say no, and they don't believe us. And it's kind of funny because
luckily a bot would respond.
Your responses are coming so fast.
I know, they do. They don't believe that we're real humans. So I know what you mean.
Yeah. No, that makes perfect sense. I mean, one of the other things that would be silly not to talk about in this context is the question of accessibility. Who is able to use what tools? And I was wondering, just out of curiosity, if we could go down the line and in 10 seconds, who is your key user? Describe the most common person who is using your service. What's their literacy? What's their level of education? Is there demographic information you know? What are they looking for?
Wow. Well, and because I work at Clio, I want to give an answer that's incredibly precise at exact grade reading level, and I can't know that, whereas the editors would know exactly how they've written their publications, and they would be better versed in this than me. But I would say that in order to use the service at all, there has to be a certain, I think to use the site, though, there has to be.
Sure.
So I would say, what's our reading level for Steps to Justice? I have a show of
Sixth grade?
Grade
Eighth
8. So, we assume a grade 8 reading level, and that's a little bit higher than the sort of traditional print publication standards for Clio. So to be able to use Steps, you have to have a little bit of education and so on. But so certainly demographically, I can tell sort of like where they are in terms of the city. I don't have that kind of information about age or gender, nor would I ask.
Sure.
But yeah, I would say that sometimes we can see that we need to make a handoff right away because they're not clicking on any links, and the first thing they want to do is get some help.
Right.
But for the most part, we can see that they're following the stuff we're sending them, and they're thanking us, and they're leaving, and it increases the quality of their visit, I would say.
Great. Drew, do you have a user in mind that you're sort of designing for with the bot?
Yeah, so at People's Law School in British Columbia, we're a sole public legal education provider province-wide. So we're not focused on a specific community. We're trying to reach as many British Columbians as we can. We set grade 7 as our where we work to get all of our information to that reading level. And then we also try to put a large part of our focus on what the research shows to be the most common everyday legal problems for significant parts of the population. So the research consistently shows consumer problems, money and debt problems, and work-related problems to be the 3 top cluster areas. So we put a lot of our energies into those 3 without ignoring others, of course. But one of the lenses we try to bring to it is, to what degree are the areas of problems not being met by other legal service providers and other options? And consumer continues to flash there, because the cost-benefit analysis to get a lawyer or a licensed legal professional of any kind involved in a $300 dispute with a cell phone provider is just a non-starter.
Right. Great. And Kevin?
I think our typical user it's someone who has a legal problem and they have some barrier or barriers to accessing justice. And they're a mix. So it could be someone who's in rural parts of Labrador, and there's limited internet access, limited internet service there. It could be financial in nature, it could be literacy. There's a whole range of different issues. So it's figuring out can we have a range of tools to help address those barriers. And it's not to say that we only do the phone line, only do person to person. We have online materials as well. We have an online family law forum builder that we developed in the last couple of years. But I think it's having a range to address those different barriers to accessing justice.
Sure.
For 211, the phone service, it's such a wide gamut of services that we can refer to. So it's sort of the typical nonprofit mix of gender and age. But the chat, we've been trying to, we put it only on that one site right now, the settlement.org. And like I said, it just went through the roof compared to what it was. So it just shows, and these are mostly newcomers with language issues. And so there was this idea that it could be used by literally anybody. If people are trying to just get through even their own language barriers to use this service, that this could be a very popular service and a very useful service. So the one thing we would like to do, we get a lot of stats on the phone, but we don't really get a lot of stats, by demographic stats from the chat, not yet. So I can't say who's using the chat, but if newcomers that are, in Canada and across the world, as you know, I don't think there's the barrier to that kind of entry there's always barriers to internet access, but if you have it, the barrier to chat, I think, is quite low and open to everybody. So.
Great. There's so much that I would love to ask all of you. I'm mindful of time, and we have a couple of good questions coming through over the live chat, which it feels like we should pay special attention to them, given the topic. We have a great question about how LGBTQ plus friendly the language used is, including with respect for title, gender identification. We have a question about accommodating linguistic abilities within bots and making adaptations for those. I don't know if any of you would like to say something to that.
I could about the LGBT plus one. The group that came to us was very much a sort of a tech-first group. And so they would have things like, just some of the language was obviously built not from being part of the community at
Right.
all. So we sort of worked through that. Like some of the choices you would make, it would be like your age, and then your trans, things like that. It just wasn't great. But then it got to the point where they wanted us to, on the other side of it, to identify organizations that identify themselves as trans positive, all that, so that they could provide services that were trans friendly. And so there was a real emphasis there, and it is possible to do that. So like the services that we have in 211, you can mark them as all sorts of different ways. And so I would say that was felt to be quite an important thing. So that part, the gender, and because if people want to go to a shelter, they want to go to a shelter for how they identify.
Right.
So yeah, definitely, I think that needs to be upfront because it wasn't for this group, and they kind of had to go back and rebuild to a degree.
Sure. Would you like to, Leah, would you mind just helping with the mic there? You got it?
Good afternoon, everyone. First off, thank you very much for coming out today and doing these talks. My name is Raymond Hathaway. I'm a licensed paralegal operating here in the province of Ontario. I've got two questions, one for Fiona. The form system that your employees use, when somebody comes through the chat, you say that they can just enter in a couple of letters and it starts to draw the information forward. Do the users that are accessing the website from the outside also have that same system access, or is it different? And the second question I have for the whole group, because I figure you guys are kind of on top of this stuff, is how close are we to having an AI advocate at this point? Go ahead.
Fiona,
I just want to make sure I heard you because I don't have the best hearing. Did you say that does the information that we as operators have to provide them identical to what they could get from the site? Is that what you
I
mean?
think it's talking about the quick replies that would go.
Or do you mean?
So your staff members are capable of entering in a couple of keywords based on
Yeah.
the information that's received on the chat, and it starts to populate the information that might be usable for that.
Yeah.
If I was to go onto your website from the outside, not being a staff member, is it the same system? Like, am I able to access it as quickly as somebody who's an employee?
Right, so no. So this is just like our website is all public information, of course, and it's done through a taxonomy of legal topics and subtopics, and it has a really good search, and hopefully you can find what you need. But our search uses a special tool. The chat tool allows us to have what are called shortcuts, and those are shortcuts that we can create them based on being able to just enter a few little words to pull it up, and then it allows us to have a carefully worded referral. Like if someone asks us about wills, we don't have at the moment any information on steps, although it is going to be available soon. When you were saying that's a big area for us, we don't have it yet. So instead, if someone mentions anything to do with state law, we just type in the word wills, and then we've pre-written a specific thing. Although this information is currently being developed for now, go to this website, and we send them to a very specific section of Justice Ontario, which is the MAG website, and then we may follow up with a referral, generally to our version of your service here in Ontario to find a lawyer. So I don't know if I'm answering that directly, but certainly the tools that we use on chat are just shortcuts to help us help people faster. But we don't have, with chatbots sometimes, again, what I was talking about, that knowledge base, that the chatbot is searching a knowledge base in order to give answers, and sometimes the user can do that as well concurrently, but that is sort of different. So ours is just a little applet that pops up between 11 to 1, and the rest of the time you are encouraged to email us. So we get, I don't know exactly how many, but like 40 or 50 probably emails a day when it's not open, which tells you how much people would probably like it to be open. We did have evening hours once, way, way back when we started, and they were absolutely dead. And our website isn't used very much in the evening. I'd be curious if yours are. 211, I don't know if that's something that people are asking for at like 4 in the morning, but.
I mean, it's 24/7,
yeah.
And the chat goes from 7 a.m. to 9 p.m., and it's pretty steady. But there's obviously a business day.
Right.
But actually, I would say the chat is more evening oriented now.
Interesting.
I think, yeah.
And I don't know if that would be true of legal information.
Yeah.
Sometimes I say, like, when I go to give you a referral, if you're in a family law, and you're in the middle of some hellish form, and I'm trying to help you, and I send you to a few things, and then I refer you to a FLIC or a Family Law Information Center, and they're all closed at 6. Everything I send you to is closed. If I'm doing that at 8 p.m., is that more frustrating than me sending to you at noon when you can immediately make that call?
Right.
I mean, sometimes our service is a bit tailored to the hours everybody else keeps, but that may not be best for the user. that might just be the way the thing is organized. But did I answer your?
You did, thank you.
Okay, good.
And just to reiterate the second question, I don't know how many sci-fi fans are here, but it'll give you a clear illustration if you know what I'm talking about. Fifth Element, in it, there's a digital lawyer. It's a robot lawyer, handles everything, has all knowledge. How close are we to that type of advocacy?
I'll take a stab at that. So I don't think we're there today, certainly. I think things are moving pretty fast, but what I would say is this, that any reasonably helpful chatbot that is using artificial intelligence needs to be trained a lot, like a lot, to get variations on how people phrase things. And the best ones I've seen are in very discrete realms. They're not, like with law, it's so complex, both the whole range of problems, and then as we've been talking about in different sessions today, the layers to any one person's situation. And for a bot to effectively unravel that, I can't see that happening for a while. That said, it's pretty remarkable how fast things are moving, so I wouldn't want to make any pronouncement that it won't happen like in my lifetime or in the next 5 years or anything like that. It's moving quickly.
We do have increasing examples of AI being put to work in every corner of the legal profession, including everything from suggesting bail terms to judges. There's a pilot project around that, to doing first stab at client advising. So yeah, thank you for the question. That's a really interesting horizon. I've already pushed us 6 minutes into your break, for which I apologize deeply. Thank you to everyone here. This is absolutely fascinating to hear about all of your projects.
Thank you.
And to echo Michelle's point, I just will remind people that, of course, if you still have questions online as well, too, we will continue to take them down and send them to our panelists. It's obviously a very popular topic. There's a lot more to be said. So thank you very much to our panelists this afternoon, to Dave and to Kevin and to Drew and to Fiona and Michelle. Thank you so much. Sorry guys, we're going to keep your break a little bit shorter. We're going to come back at 2:15 to keep us on schedule for today and make sure that we don't make anybody stay late. So you now have an 8-minute break. We'll be back in 8.
Ladies and gentlemen, would you please take your seats? The presentation is about to begin.
Making it sound like entertainment. I don't know if it'll be that entertaining. Well, not my part. I'm pretty like stale and serious. So.
Hello, testing, testing. Hey everybody, we're gonna get started now so we can all wrap up early and go trick-or-treating in the rain. Okay, so my name is Avery. Hi everyone. I'm from the Law and Design Collab. Thank you so much for having us here, Julie and Jessica. Today we're gonna talk to you about UX methods and how they can help enhance PLEI. So just a little bit first about this organization. So we're a volunteer-run nonprofit group based in Toronto and Waterloo. And what we do is we engage skilled volunteers who are not lawyers, so people doing other things such as UX and design, graphic design, marketing, and we get them to help out on improving legal information products. So our group is focused on taking existing products, so all the great work that you folks produce, and trying to amplify that using these different skill sets. So I'm going to introduce today Sam Horodezki. He is a member of our UX team. You can see his bio in here, but he's been a thought leader in UX management with over 20 years of experience in enterprise US companies. He's around the circuit in Toronto giving talks at UX conferences and also has his own consulting company. And he is MS in cognitive science and holds patents, 6 patents? Jeez, okay. Alexis here is also a lead of our UX team. She's a product designer at a Toronto-based startup, professionally educated in psychology. She's self-taught in business, marketing, and web design, and she's been running her own business for 2 years. Okay, so I'm gonna get out of here, and we're gonna distribute these little handouts, because there's gonna be an interactive portion to keep everyone all engaged. Thanks so much.
Okay, so for today, there's going to be hopefully a brief agenda. So we have design's role in legal content, what is UX or user experience, a brief website exercise, just to check if you're listening, usability heuristics, design thinking, which is, the behind the scenes of design and the process there. Design resources, so takeaways you can take and reference for best practices, and then a brief overview of all the work that we've done and accomplished at the Law and Design Collab. So let's start with a simple question. Can anyone tell me what legal websites are here to do? I'm gonna just do hypothetical because I might not be able to hear you from back there. To educate the reader. So much time is spent curating the proper legal content, formatting, language, making sure all the details are in place. It then becomes critical that just as much time is spent on the rest of the communication tool, that being design. So how is design a communication tool? In the simplest way, visuals can help support the message in your legal content. A graph can illustrate a point, a picture can relay what you're trying to say, and tables can easily show the reader how information is categorized. But design is a communication tool in many more other ways. For example, a well-designed page can help readers find the legal content they came looking for. They can understand what they're looking at. I mean, how would you do that without any headers? Sometimes there are small actions that need to be performed on a website, like making an account or filling out a form. Users need to be able to do that with ease in a way that feels like second nature. Good graphics, logical charts,
All that helps a reader feel at ease and digest the content they are browsing. So, then you can say that design becomes a platform on which you can present your legal content. Design can help lay out your legal content in the most eligible and accessible way to the user. So, I think we're ready to cover something more confusing, and that is, what is user experience exactly? User experience is a branch of discipline stemming from designing for the web. In particular, it accounts for which interactions happen between an interface and a human being. These experiences that occur before, during, and after a human interacts with the digital interface is what a user experience professional is responsible for designing. You can then break it down further into two parts that have to be accounted for in order for a human being to have a good experience. That's visual design and information design. So what are some of the elements of visual design then? Visual design is more obvious, easier to spot. It is appealing to the eye for mathematical reasons. A balanced mixture of pleasing geometric shapes, compositions that evoke emotions, and adequate use of white space all come together to create a visually pleasing design. It's harmonious, if you must put it that way. So as an example, this is housingcourtanswers.org, a New York-based legal website. You can see here that there's plenty of breathing room. Your eye is drawn to critical information, which is the purpose of the website. For example, the headers. I'm a tenant, I'm a landlord, I'm an advocate. These are pathways that can be taken, and that's very easy to spot for the reader on the website. There's also good use of graphics and color to set a tone and support the information that is being relayed by the header. Below, where there is a cutoff point, there's a great use of boxes to categorize content. As you can see, they're popular topics. So a user would be able to distinguish that these topics are separate. Another great example is justfix.nyc, another housing website for the New York audience. The graphics support the content next to it. You see that it's a digital tool. Notice your eye is instantly drawn to the blue button, which is important because that's where the user can take action, like search my address. And then there's fight back, which is kind of aggressive if you ask me. Okay.
All right. Hi, guys. I'm Sam. So both Alexis and I are UX designers, and I'm very passionate about my work, and I believe that this stuff can really be applied to the A2J space. So I hope that by the end of the presentation you get just a sense or a taste of what our field is about. I'm trying to give you as many resources as possible for you to follow up, but that's really what the next, say, 40 minutes are about, is getting you a feel for what it is that we do, and for a few minutes you're actually going to try doing it yourself. So first we're going to look at where we stopped was what is visual design and then what is information design. So I'm going to talk about information design. And I deliberately picked something very topical, and something, it's actually, not only is it topical, but it's the sort of thing where you see information graphics all over the place. So I'm going to go through some information graphics and just give a bit of a critique of it, and you'll see kind of what I'm talking about when I say information design. So can we see it? No, not yet. Okay. All right, so here's the first one. And just to be clear, I'm not trying to make any statements about who won or any politics. Actually, the U.S. had a butterfly ballot 15, 20 years ago, which, was hugely impactful in the design space. But anyway, my point is, you'll see, I'm going to be critiquing the, not the winners or losers, but how it's presented. Now, I think in this one, what really stands out is it's very obvious who got the most votes. So you really cannot miss that. And that's a really good thing, because that's obviously why people come to look at it. Now let me just see what it looks like for you guys. Okay, well, you may be able to see some of the, one issue for sure is, so it's really clear about what's happening here, and if you want to see the results here, it's also really clear. But the rest of the space is used in a very, you can see a lot of white space, and then some very tiny fonts. And so this is actually kind of a good exercise, and you can hardly see it because there are a lot of people over 40 who are looking at their computer who also cannot see tiny fonts. So, you know, while the information here might be very useful, it's actually quite difficult to process. Now, this is quite, I guess I should just go. This one is quite different, even though it's presenting very similar information. So first of all, it doesn't nearly pop as much in terms of who got the most votes. But what it does do, which is actually important, this bit about liberal minority, so it actually tells you the result of the election. So if I just go back, you can't tell by looking at this what actually, it doesn't indicate in any way what the actual result is, which is a pretty big shortcoming for an infographic about the election. This is from the Globe and Mail, by the way. And this is from Global News. Now, so, and then it does give some information also about what what the maximum, what number of votes you need for a majority, so that's very useful. But this bit here is a lot less clear, right? So this number 157, which is really the important number, is really smushed with all this other stuff. Another point here is look at this bottom row. It's got all zeros. The reason it has all zeros is because the election is over and nobody's leading or behind anymore. So what that means is the row is kind of useless. And you'll also see that in elected, that this number and this number are identical, 121, 121, 32, 32. So bottom two rows are totally useless after the election has actually happened. So what that means is they just didn't think about, oh, okay, we're using this during the election, but they didn't remember that it was going to be there after the election. And so really this needed to change for the post-election results or be designed differently. And there are ways of designing it differently so that this problem wouldn't happen. So I'm going to continue to talk about this one a little bit. So this is another part of this infographic. And what you're seeing here is that underneath, first of all, you get to pick the riding that you're interested in. And there are actually some issues with that, but I won't go into it. So I just picked something totally randomly. Now, I don't actually know this area that well, the Don Valley area, but what I can tell you is that this graph is not all that useful, that map, right? It's showing like a square, I mean, it must be, it is that area, but you can't really see the context. And look how much space it's taking, right? So you've got this map that's taking up all this space, and it's practically useless, even if you're, if you're in the Don Valley area, presumably you know what the area looks like. So I think there was some good intentions here, but one thing they clearly didn't do, and the devil's in the details, is look at the zoom level. If they had just changed the zoom level to be much higher, right, not at the Canada level, but maybe at the Ontario level or the Toronto level, then you'd get some more context that would be more meaningful. But regardless, the most important thing here is clearly this result here. That's what this is all about, is this. Now, that is quite prominent, but still it's overshadowed by this large graph that's showing where you are. So again, what I'm trying to show you is that information design is about making relative priority decisions about the information, and also making decisions about what type of information should actually be there in the first place. Now I'm going to show you what my favorite, not like I did an exhaustive search of all infographics used by all the media, but something that really did speak to me. This one is from the Globe and Mail. So something I don't like, I'll contrast this to, is the maps that show like the map of Canada and then show who won, because the thing is, we're such a dispersed country that in the Yukon and the territories, right? It's just, you just get a sea of red, or I think one of the ridings was NDP, so then you get a sea of orange. So you can't really, and then even in Ontario, it was really quite striking. In Ontario, as you might expect, the rural areas voted generally conservative and the urban areas voted generally liberal, but in terms of space, it looked entirely blue, right? So you couldn't actually tell by looking at it what the results were. So this is a really different way of looking geographically at the results, and I think this is very powerful. Now, most likely you can't actually see the names of the provinces, but that's what's going on here, is it shows you the name of a province, and then it's got colors for that, and so it's very easy to see the breakdown, very easy to see what's going on. So actually, before I move on, I forgot to point something out. Someone spent a lot of time on this this infographic, so I very much doubt that you noticed this. I did not notice this even when I clipped it out and put it in my PowerPoints. It was only this morning I noticed. This area here, notice that this is red, and that this is blue, and then this is light blue for the Bloc Québécois. So this is actually supposed to represent some kind of percentage breakdown. The thing is, it's completely hidden. So it's a good idea. It was a nice try. But again, I mean, I think a vast majority of people would not have noticed it, and so it kind of missed the point. Okay, so now I think I'm ready to come back to what are the key components of information design. And I've really already talked about them. The first component is literally what information do you want to convey? And you would be surprised about how difficult that is. And I think, you know, in the legal space, it's even worse because the information is so complex and there's so much of it. But deciding what information to include, and more importantly, what information not to include, is really critical for getting a good information design. If you mess that step up, it doesn't really matter what the remaining steps are going to be. Oh, sorry, back. Then the next one, so that's sort of principle number one. Principle number two is then you have to get a relative profile of the information, right? So what I was kind of harping on over there was about that the map was too much and it was in the wrong zoom, and what is the relative use of space and proportions. So anytime you design anything, you have to decide what are the really important things and what are the lesser important things. And if what you think is that everything is equally important, then you just get one big blah where you can't really tell what's going on because all the information is treated equally. So an absolutely critical part of any type of design where you're conveying information to people is making those difficult decisions about what's primary information, what's secondary information, what's tertiary information. And in some cases you might decide, actually, you know what? I thought I wanted to include this information, but I'm not going to because it makes it too messy to see other stuff. And then finally, the third sort of point about what are the key components have to do with the form and the form of the thing that you're showing. And so we saw three different, very, very different renditions of the election results. Again, my kind of favorite at the end was that one at the end. But the map is an example of a sort of poor choice of form. They really used a lot of space to show a map where if they wanted to indicate geographical region, they probably could have done that with using a lot less space and using a totally different control if they wanted. So we're going to talk more about some of these controls after our exercise. Yeah, I hope you enjoyed that tour through the election results. Here's Alexis to do the exercise.
So for the design exercise, I think, did everybody receive a white piece of paper? Yes, okay. So there is a website link on there. So if you click it, just go to the home page, that's fine. And maybe reflect a little bit on what we have discussed here in terms of visual design and information design, and what you think good and bad is. There is no right or wrong answers, maybe. And then afterwards, within say 5 to 7 minutes, we'll take that up and maybe get some responses from the audience. Okay.
One last thing, we were thinking you might want to team up with your, the person to your left or to your right to make it a more collaborative exercise. That might, just a suggestion, it might be more interesting that way.
Oh, yes, and for anyone that does not have a desktop or a laptop, you can use your phone. I don't know how accessible this website is on mobile, but just, so you have it in front of you.
Okay, so it's 2:38. We'll give them about 5 minutes.
All right, how's everyone doing? Did you guys make a long list? What? Oh. Okay, I hope everyone is finished. We're gonna get right back into it. Would anybody like to volunteer some of their answers?
You can raise your hand, and Francesca and I will bring the mic to you.
Don't be shy.
Hey, so just from my own training, we're told to use video on main pages. So on the front page, I would have gone with video, not photo. Also, the photo's not really related to any legal question, and we looked it up. It's not the flower of Nova Scotia up there. If anybody wants to correct me on that, that's fine. So it's not relevant. Need to increase the font in a few places, including the section about seniors, which is farther down on the page than the one that's displayed there. Search box is generally on the main page, but I see it's just like a click there to search. It should be more accessible. It's repetitive in a number of areas. I have a legal question in a couple of spots, and welcome to Legal Info Nova Scotia. It just seems like they're trying to fill the page with stuff. And yeah, that's about it.
Well, thank you. That was a very good and detailed answer. Excellent. Anyone else? Oh.
Hello. Our group had a couple little things.
Okay.
One thing we noticed, the sidebar, the blue sidebar, we were looking at on mobile, and it's actually, I think we kind of preferred the user experience on mobile to desktop, but this sidebar, when you scroll down, let's say you go to a more in-depth information page, it's fixed. And so it doesn't move as you scroll down, which could be intentional and a good thing, but the problem is on his particular laptop, he can't ever see the bottom. So he can't see anything under the green call us bar, no matter what he does, unless he completely changes his settings. So he would never see that they had chat at all, or the option to email, even though that's repeated over here. But I'm just saying it's an interesting, it's almost like it's frames or something. I'm not exactly sure how it was done, but it's an odd choice. So that was just one thing. And I like the simple kind of plus to expand some of the topics, but I would say that the taxonomy of topics is a little bit of a fruit salad, like it's apples and oranges. So it might be nice to kind of work on the collection of topics and refine them a little bit, but that's not really a design thing. And the other thing was, I noticed this site constantly encourages you to call. And that's not a criticism, because if the organizational objective is that they really want phone calls, but generally the reason we want really good websites is because we can't meet the demand for all those phone calls. So I noticed, like, especially on mobile, you might not really notice the I have a legal question thing, but you really notice three places encouraging you to call. So again, if that's a good thing, because their population would be much more dependent on the phone and that would immediately give comfort, then that's not a criticism. It's just a note that there's lots of things on this site that tell you to get the heck off the site, which is odd. So
yes, no, you don't want to take users off the website. That's a no-no. Thank you for that. That was very good.
Colors. So the stuff on seniors, I'm 67 years old. I can't see the green.
Okay, we have an accessibility issue. Okay. It's a big one for sure.
On my mobile, there's no back button or to switch pages. I have to go all the way down to the bottom. There's one that says an arrow that takes to the top. But every time I try and use the back button on my mobile, I go back to the main URL. Are you looking for this web page?
Okay, navigation issue. All right.
I'm on my mobile, and it doesn't actually say contact us. It just has a little envelope, and to me that would be email. So I click on it, but it tells me we're not available to chat. So I didn't know that was supposed to be a chat. It also says that you can email us, but there's no link to an email on that landing page.
Okay, so we're having a bit of a break in the flow there, as well as visual communication.
I haven't gone through the complete website, but I'm not seeing any pictures. I'm not seeing any people, any faces. I'm just seeing a flower.
Okay, yeah.
I'm seeing a lot of text, I guess is what I'm saying.
Yeah, it could definitely maybe benefit with some people on it, since it keeps encouraging to call. So there's clearly an organization. Okay. Oh, one more. Okay.
I have a lot of things to say, but I'll try to pick one and say that the cognitive load is very high. And someone looking for legal advice, that's the last thing they need. It needs to be, thought of in terms of the user and what are their needs. What was the thing you said? What is the information you want to convey? I don't think it's well organized, and it's not a nice conceptual map to filter you in easily. Too much cognitive load.
Yeah. Thank you. Thank you. Those were all excellent answers. Go ahead.
All right, that was great. Definitely a lot of comments touched on this point of what information should be then, what's the relative priority of it, in particular the phone number, and then also obviously looking at mobile versus desktop. It's kind of a different animal. So nowadays you actually have to design it twice. That's the way it is. So now I'm going to teach you actually a bit more about specific design issues that come up, and I'm going to teach you something called heuristics. And what are heuristics? Heuristic is a rule of thumb, just a fancy word for rule of thumb. And interestingly, in the 80s, sort of a seminal paper was written on this, and there were 500 heuristics at the time. And that was before we really had graphical user interfaces or mice or anything like that. Now, there's a group called Nielsen Norman, and I'm going to talk a little bit about them later, but they have for sale something like a book that's got, it's either 5,000 or 10,000 heuristics. So, I mean, part of the job of being in design is not just memorizing a bunch of heuristics, but it's actually trying to reconcile how they interact together. So again, that's where I'm just trying to teach you some of the most basic stuff, but often your own requirements, such as the complexity of law, come directly into conflict with these heuristics, or the heuristics conflict with each other as well. Okay, so this is really important for websites, which is the Z pattern. And this is sort of like 101 for layout, which is that the way that when people look at a website, their eyes follow a Z pattern. And consequently, the first thing they're going to see is at the top left, and the last thing they're going to see is at the bottom right. And so people generally, their kind of attention fades around, well, like, oh yeah, I've got the wrong thing. Around here. So that tells you something, and the reason this is, I think I clicked that by mistake, but anyway, the reason I call it the danger zone is that a lot of people are tempted to put important information there, but unfortunately, it's a little bit past where people, in general, have the attention span to look at. So it's definitely not a good place for really central information. Probably the middle of the screen is where you want to, I mean, as it stands today, the top left is actually almost always reserved for the logo. That's just a convention. It's not always the case that the most important information, that the logo is the most important thing, but another heuristic, which I actually am not talking about, is consistency. And any site you go to basically has a logo at the top left or top right. Okay, moving on. Oh yeah, not quite. So how do we even know about the Z pattern? This is a heat map that was, now some of you maybe who work in digital properties may be familiar with heat maps that have to do with the cursor or the arrow, because I guess Google Analytics and various tools can track where people are rolling over. But that's different than tracking what they're actually seeing, and that's what this is. This is eye tracking. So if someone comes into like a situation, like a room, and they put on this fancy paraphernalia, and then they watch, all they do is look at websites, and then you generate this heat map based on that data. So it's a little bit difficult to get, just like you and I can't get this data. But I mean, this isn't a perfect Z, but it shows you the idea. Okay, prevent errors. Really important. I mean, all of them are important. The thing is that the job of the user interface isn't just to show you what to do, it's also to prevent you from doing really bad things. So, and the more, you need to put the more in, the more catastrophic the error could be that someone is making. So if they're capable of, deleting a record permanently, then the design you're going to do for that is definitely less than if someone's just deleting something temporarily, or they're just moving around, or if they're turning something red, and who really cares if it's red or not. So a perfect example of this, but most of you, many of you are familiar with Gmail. So this has an undo function. What you're actually seeing is the state after I have just deleted or archived something. And so you've got this little thing down at the bottom left. Sometimes it appears in other places. So that's an example of, depending on how catastrophic the thing you just did, the bottom left is not a particularly high importance area, so it's a good place for it, but often you'll see errors like this at the top center, and top center is a good place if you've, for undo of really important things. So, and in general, having an undo function is quite critical for pretty much all digital properties, and that comes to this back button, which I think there were some comments that the back button may not be working on the site that we looked at. I don't know if that's true or not, but the back button certainly is central for navigation, because it's a version of undo. Oh, I didn't really want to go there, now I need to go back. Okay, recognition over recall. So this gets a little bit technical into like how we think. Actually, both of us have degrees in cognitive psychology, and that very much influences how we go about designing things. So what is recognition versus recall? Recognition is being able to look at something and tell whether or not you've seen it before, but that's different than just spontaneously being able to come up with something. So the example I have for this, just in keeping with the political theme, is who is the Prime Minister of Canada would be a recall task, right? Because you actually have to generate the answer. And is Justin Trudeau the PM of Canada would be recognition, because you're giving them the answer. Now, this kind of thing happened all the time when I lived in the States. This was actually when Harper was the Prime Minister, and I had people come up to me and ask me if Trudeau, meaning the previous Trudeau, was the Prime Minister, or ask all sorts of names. Anyway, I can tell you that they are much more likely to get the answer right if I said, well, do you think it's Stephen Harper, than if they had to come up with the answer. Now, an example of this, before I go on to the example, in general, and this is also a little bit nerdy, the human brain prefers to have context. It does really good when, the more context that you put into an area, any area, the more likely the brain is able to compute it. Now, one of the things I did when I did a thesis early on, this was 20 years ago, is I worked with syllogisms. This is a logical problem. So an example of a syllogism is all A are B, all B are C, and then you ask the person, well, what follows from that? And of course, I mean, it's actually pretty straightforward, but it's very abstract, and it's all A are C. But if you do, and so the thing that I was studying, I can't say I came up with this, but the thing that people were looking at is what happens when you make these real world. And so just an example would be all cigarettes have tar, all tar is dangerous, all cigarettes are dangerous. Now that leap is very intuitive, very obvious, because it's got context in it. So again, well, I'll just show you the example here. This is an example of context. This is in Microsoft, and they do this for Word too. Anytime you want to open something, they actually give you a set of things that you might want to open. Now, you may not want them, but it's at least giving you the opportunity. Programs have gotten much better in the last 10 years about doing this. Another really common one is anytime you have a search bar, you're going to want to give potential results. It's called type ahead drop down. Google does it, of course. You start typing, or Amazon, you start typing, and then it gives you a bunch of results. So giving you those results is a way of giving you context. In Netflix, you never see a screen where it's just got one movie. It's always showing you all sorts of other things you might be interested in. And that's how they give you context for watching their library. Okay, sense of place. There were definitely some comments about that in the exercise. A lot of websites and other tools, it's very easy to get lost. And I call this wayfinding. Wayfinding is actually very important, because if you go somewhere and then don't know how to get back or don't know where you are, then you're going to be very confused. You're going to have the sense of confusion, which really, the more confused you feel, then it's frustrating. We've all had that sensation. So the example I'm showing here, you've got these little chevrons. I'm not necessarily endorsing this design one way or the other, but
Please use the mic just in terms of the live stream.
okay. Oh, there's no live stream for us. So if you go, I think the idea is if you go to page 1, then this will be lit up. It's really hard to see, but this page 3 is lit up, so the idea would be that this is actually page 3. The point is that if this worked kind of the way that I think that it works, it shows you the number of steps that you're looking at and where you are in those steps. Another example, that is really important is breadcrumbs. This one I probably don't need to point out. Breadcrumbs are something that are also super common, and for any of these legal websites, like Clio, for example, Clio's, I'm forgetting the name of it, but Steps of Justice, you know, you can get very deep into the information, and I'm going to be showing you another example. So having some kind of pathway that shows you, well, this is how I got there and this is how I get back. It's not just important for legal sites. I actually was just looking at a client's page this morning, and it had exactly the same problem. Like, you logged into the website and you just like had absolutely no idea what was going on. I mean, I didn't attract to any place on the page, and then when you click things, you didn't know how to get back, and then the back button wasn't working either. So very frustrating. But this is super common. So breadcrumbs actually are very important. Most people, questions will be after. Most people like breadcrumbs and use breadcrumbs. They're not the only way to do something, but I'm just using as a relevant example. And then I think I've already made the point about wayfinding. I mean, your tool, your digital tool, or your digital website, or your interactive, you know, device, whatever, sense of place and having a sense of navigation is absolutely critical. And the more complicated that it gets, the more critical it becomes, because otherwise you get that sense of disorientation. Okay, this is the last heuristic, although as you know, there's more than 500 of them. People make this mistake a lot, so that's why I felt like compelled to do this. There is a big difference between the learnability of something and its long-term usage. So, and people confuse those all the time. So what I mean by that is the very first time you see something, your brain is processing it, and you come to some conclusion, either you know what to do or you don't know what to do. However, as you use it over and over and over and over again, your brain doesn't do that processing anymore, right? It's got the context, it knows what's going on, and so it doesn't need to think about it every time. And so if that thing requires lots of clicks, or it doesn't allow you to do the thing easily or efficiently, then over time you're going to get frustrated. So there's actually a difference between intuitiveness and efficiency. So, and often they're actually diametrically opposed to each other. So an example of something that's very efficient is a command line interface. They're called CLIs. And this is something that, you know, people were using 40 years ago. But if you don't need a graphical user interface, you don't need a mouse, you don't need anything if you've memorized all the commands. And then it's really quick to do anything. And actually using Linux or some of these things, you can do incredibly powerful things. And some people in the research world actually use a programming language called LaTeX to make their own documents, which I think is crazy. But for them, it gives them the power, and there's like no GUI at all. It's completely programming. But there's, like I said, they're actually at odds, because a command line is an example of something that's very efficient. Another example is a shortcut, like Command A is all, or Command Z is undo. But you aren't given birth knowing that Control Z is undo. You come to learn it over time, right? And you don't necessarily know that. I use Control A all the time. You may not know that Control A is select all. The point is that these are learned behaviors that make you get better and better, but if all I gave you was Control A, you'd never figure it out in the first place. So these are things that are always in tension with each other, and when you're doing something, when you're making a product, you have to resolve where you want to be on that spectrum. Do you want to be mainly for people who are just looking at it for the first time, or do you want to be looking at the complete opposite end? Now, a mobile device is actually a perfect example where the thing that's most relevant is how it performs over time. And I'm talking about like buying an Android device or buying an Apple device, because you're using it, 20 times a day, and then you multiply that over years. You get very large numbers of how many times you're using it. So actually, its immediate intuitiveness is less important than its long-term viability. I think that's, okay, yeah, that's the last heuristic, and there will be time for questions if people want to ask more about those. Now, we would be remiss if we did not talk about design thinking. Alexis and I were talking about this, and I know it is possible that 10 years from now, no one will be talking about design thinking anymore. But it is very buzzworthy right now. So most time, anytime people think about design, they immediately go to design thinking. And I encourage you to Google design thinking. I want to teach you, the main thing that I want to get across here is that doing design is not about memorizing a set of principles, although you do need to know the principles. There is a process that goes with design. And the reason it's called, the reason someone created this thing called design thinking is they co-opted the process that designers have always used and now are applying it to all sorts of other problems. Now, but the process itself is excruciatingly simple. So when you're doing anything, when it comes to design, your first phase is going to be to do research, to understand the space, and that's where you might do some of this information about, some of this stuff about trying to figure out what information you want to put in, what information is relevant and less relevant to people, any statistics you have from Google Analytics. That's what the research phase is about. Often, I mean, when I do anything, I'm always looking at the competitors to see what the competitors are doing, just to get insights into how I might do something better. Then there's the design phase, and the design phase is the part where you memorize all the heuristics and then figure out how they collide. And just like I was saying, you often have to make trade-offs to decide, okay, is it going to be more intuitive, or is it going to be more efficient, or where's it going to be, or is it going to be more visual, or is it going to be less visual and lots of words? I mean, again, if it's a legal website, sometimes words are necessary. But then the really important part is the test part. So you design it, but then after you're done designing it, you test it to see if it's working well, and you're always going to make mistakes. That's just the way it is. You can't be perfect every time, and so then you definitely want to build in the loop to test things. And you can do this even for just brochures, right? I mean, you make your brochure. You're going to do research about what kind of information is there and what should be in a big font and what should be in a small font and what shouldn't be there at all. You're going to do design on it, especially visual design, and then you can easily test it by asking either people who you expect to be the audience or just your colleague to see if they understand what they're looking at. So this really, if you've ever heard anything about design, you've probably heard about design thinking. This at its essence is what it is. I felt like I really had to address it. But what is important about it is that it's a process, and you basically take skills and you meld this process on top of it, and that's kind of what user experience design is, or what designers do. Okay, so now we're at the part where I'm going to show you just a couple examples, now that we've looked at a few heuristics. So yeah, this is like my favorite bad one. So the one interesting problem actually about this one is it looks like they haven't updated in like 15 years. And the reason I say that is, look at the boundaries. It doesn't go past, we have white space here and white space here. It doesn't even expand. So that makes me think that they were using, an older version of HTML and that they didn't, bother to update it. But there's a lot also not to like on this website, just when it comes to the information design. They don't use maximum use of space because they could have more of it. But when you go look at that Z pattern, you're going to encounter all sorts of stuff. Look at this. There's several navigation areas. There's this up here, along with a search, and then these are the breadcrumbs. So I guess that's not really. There's just a lot of functions. If you look and count how many things are going on, there's a lot of things going on. And then the other point is that the visual design also, it looks like they never really got to the visual design aspect of it, so it's not aesthetically particularly pleasing. So yeah, we thought about giving this one to you as the example, but in the end we actually decided we wanted something that had improved visual design, so you wouldn't just start talking about the visual design. Now here's an example of a good one. Wrong thing. Yeah, this is very confusing. Now, what I really want to point out about this one, I actually do have one pretty nasty thing to say about it, but I'll get to it. But what's really good but the good part about this is that sense of place, the wayfinding. So look how clear it is where you are. There's separation and divorce here, separation and divorce here. Then it's clear that you're do your own contested divorce and then joint application. So. The sense of place is very, very strong. Again, they're using this area over here, which I said, shouldn't be for super important things. This is basically support. The navigation, the wayfinding is support. And it's not the only place, because the main one is right here, and then of course this is telling you what you're actually doing. So then there's this whole area here which actually tells you how many steps there are for the thing that you're doing. So that's the, they really have managed to capture, again, a fair amount of information in a small amount of space. Now, the nasty thing I have to say about it is actually related to accessibility. The visual design is very good, but notice how there's so much gray on white. Gray on white is a bad thing. It's a good thing when you're just doing visual design, because it's actually, it makes it look good, but it's very hard, again, at the 40 and over crowd, to really tell what's going on. So, and the font is also, there's really no reason it needs to be this small. It really could be quite a bit bigger. So, I mean, fonts are getting the font right is really, really difficult. But again, having a small gray one is probably not the way to go. Okay, so we're at the end of my part of the presentation. I do want to give you some resources that you can take away with you. So one thing that's really awesome is called that's part of the Stanford Law School. You can see it says SLS at the top left. It's something called the Legal Design Lab. And these people are big time into design thinking. And there's a lady who's the director of this program called Margaret Hagan. She's incredibly productive. She's just putting out all sorts of stuff there. And so if you go to this website, which it's got a really unfortunate name, it's like, if you just type in Legal Design Lab, you'll get this. I believe the name is Legal Design Tech. I think it's legaldesignTech.org. But main point is there's tons of stuff on here that's specific to design and law. So I definitely recommend that you check that out. Another one that people in my profession commonly use all the time, no matter what area they're doing, is Nielsen Norman's website. The address for this is nngroup.com. So that stands for Nielsen Norman. Now, Nielsen and Norman, that actually stands for Jacob Nielsen and Don Norman. Those are two people who were very early leaders in the field. And what this group does, obviously they're trying to sell their very, very expensive consulting services. And so they do a lot of free research and then write up the research to sort of draw you into use so that they establish themselves as experts. So there's tons of articles on everything. And in fact, I adopt the 5 heuristics I gave you. The very first thing I did is go to this website to find their top 10 heuristics. I didn't use all of them. I made changes of my own, but it's always a go-to resource. So again, nngroup.com, highly recommended in terms of getting information. And then finally, this is the book that actually inspired me to go. Am I doing the wrong thing again? Oh, there we go. This is the book that actually inspired me to go into UX design. It was written in 1988. It's an oldie but goodie. It's written by Don Norman, who's the second half of Nielsen Norman. And it's a book that, it doesn't really talk about computers, it just talks about how to design things. It's extremely, extremely accessible. When I used to work for a company, I actually would just order like 20 copies, and when I went to a thing like this, I would actually just hand out copies so that people read them. It's really a terrific book, very engaging. Every designer has their own favorite, so certainly not everybody gives this one, but this for me is the best way into understanding the thought process for design. This is certainly an early precursor to what we call design thinking today. And I think that's it from my portion. We still have a bit more, so I'll ask Alexis to come back.
Yeah, just to touch on, that's my favorite book as well. I read it for the first time 3 years ago, I believe, when I was designing websites. And I was reading it on a plane to Europe, and I told the person sitting beside me all about the book, and they were very happy to hear about it, I think. So I believe, Avery, did you want to come up here and talk about the past work that we've done?
Okay, thank you so much, Sam and Alexis. Really appreciate you walking us through some of these great principles. And just want to say, we didn't mean to pick on Nova Scotia for the example. Like Sam said, we wanted to find something that was kind of middle of the road. You know, had a lot of good elements, but also elements for improvement. And I think that is kind of representative of a lot of websites in the sector, right? Because we're all kind of extremely constrained for resources. And you know, part of the whole purpose of creating this group was to kind of recruit people with these skills that are so often found in the corporate sector, and to try to, you know, get them to advise us and give us some tips. So I just want to talk about some of the projects we've done to date and what we are doing now. And the first one is this Steps to Justice mobile website redesign. So if you've ever visited Steps to Justice, I personally use Steps to Justice all the time on desktop. Okay, so if you try to use it on mobile, there's some issues. And so what we did is in consultations with Clio, we identified some of these issues, and then we redesigned it and tested it. So we verified that certain elements are better than others. So that's one kind of, clicker, right, sorry. There we go. Another project we did is we collaborated with UVic, ACE, and Calibrate Solutions to take a research paper about the costs of family law disputes, which is kind of poorly understood by the public. And we turned that into an interactive storytelling website. So you can actually get to know the people and make decisions with them and see the consequences. This last year, we redesigned Ontario's standard form lease. So every residential lease is supposed to use that. There aren't really consequences if you don't use it, but that's another story. So we created a digital product to remodel that entire process to make it much more accessible. And right now, we have just started a new project where we want to create an interactive public education website related to the bail system and the problems with it. There are piles of reports kind of reiterating the same themes, and we were wondering, you know, how else have people tried to communicate this issue? And that actually is a video game from California, which you can play online. So anyways, not saying we're going to do a game, but it's just an example of some interactive media. So thank you so much. We'd love to take your questions. I believe we have 10 minutes for questions. So thank you again for having us.
I believe there was a question in the back a while ago, no? During the heuristics? No? Okay.
It was a spelling mistake we noticed on the slide.
Oh, the breadcrumb thing?
If you go back to what you were talking about on that, to said it's the one you didn't turn around, and it said breadcrumb.
Yeah, no, I do know about that. It was very, very funny.
At least the slides are accessible, right? Excellent. Any questions at this time? No. Okay. Wonderful. We left you speechless. Okay.
Oh, we got a couple here. One over here.
Oh goodness.
No, we got it.
Okay.
Yeah, so I just wanted to bring up the issue of universal design and just ask anybody really how prominently that's featuring into the work you're doing. Is that becoming the sort of major thing that people like myself would really hope that it is?
Sorry, could you please clarify, what do you mean by universal design?
Okay, so to introduce myself, so my name's Ben Fulton. I'm a recent call to the Ontario Bar doing mostly human rights law, and I am blind. So I use a screen reader, usually JAWS, to interact with everything online. So, I mean, things like whether or not the button has been labeled at the HTML level. So, you know, the visual user is going to see a button, and there might be like a heading up near the top that indicates that this button is going to take them into a place where they can calculate, you know, their severance pay from an employer or something legally related. However, when you're interacting using a screen reader, you're kind of reading element by element, and this, you know, heading severance pay calculator might be like, you know, 6 or 8 elements away from the button. So when you get to the button, my screen reader says, unlabeled button. Well, great. So how is that accessible to me? So, I mean, I guess That's kind of what I mean by universal design.
Oh, yes. So thank you for clarifying that. I believe those are best practices. I've taken coding myself and I remember learning this, but Sam, for the at the beginning, for the beginning projects, do you remember if that was something that was?
Well, we never actually, it's a good question. The first project, we didn't implement anything. So I'm trying to think about how to, so universal design is actually not super straightforward in the sense that there's a lot of there's all sorts of accessibility rules and guidelines, which then go on top of those heuristics that I was already talking about. In some places in the world, there's actually government mandates that I know this to be the case in the UK, that actually all software needs to comply with various accessibility standards, and often that is both for people who have, who are visually impaired, as well as for people who have arthritis and can't really type. So, and use of mouse is highly frowned upon in some, for people developing carpal tunnel syndrome. So, accessibility is a really big field, and I guess I don't know what else to say about that other than, yeah, go ahead.
Yeah,
Avery.
I'm going to, sorry, folks, I'm in the back here, but I was going to jump in. Hi, Ben. We've corresponded by email. It's Avery from CNIB.
I thought your voice sounded familiar.
Anyhow, okay, so I wanted to say there are really great resources in Toronto related to universal design. So there's a group called ALLI. It's A11Y. If you look them up, it's an international organization of volunteers who are promoting accessibility and digital experience. There's also OCAD University, Inclusive Design Research Center, and it's run by a woman named Yuta, can't remember the last name, but she's amazing. She worked with Microsoft actually to help them develop their universal design principles. So it's definitely, I think, a force, and there's a lot of, I think, consulting companies as well in Toronto that are trying to promote this. But I think, for the audience here, just keep that in mind. I think Ben makes a really a very important point that, we're just struggling to get websites up, right? But while you're doing that, you have to kind of try to make sure you're using best practices for accessibility.
Yeah, I mean, it's definitely well known what to do and how to do it. I'm not personally an expert on it, but the issue is it does add cost and time, and just as Avery says, sometimes you're struggling just to get anything up. So that's where I do think actually regulation is probably the best. So I don't know what Ontario does. I know that, I've actually used the Ontario procurement website, which is fully accessible compliant, but is completely useless for actually everybody. So it's kind of like, and what I mean by that, the usability overall is really terrible. So it's actually very difficult to figure out what's going on, but they have they have everything, they have high contrast views and things like that. So I guess, yeah, it's definitely an important thing, but I think my personal belief is that the only way that all things will become universally accessible is if there's regulations that basically make it happen.
So I would, I'd encourage people to, when you're building your websites, invest time in accessibility. Even if you don't have the money to do it, you can always call up some of these universities. They'd love to send you students to help advise you on that.
Yeah, I would say like where I work and in the private sector too, it's very much prioritized. Designers talk about it all the time, and that is communicated to product teams. So hopefully this trend will continue to spread. Thank you. There was another question?
Hi. Actually, my comment was about accessibility as well. We're currently in the midst of redesigning our website and working with a web designer, and we want our website to be accessible because we work with people labeled with disabilities. And I find it really interesting from some of your comments around design, because we were focusing on the design, and then there seems to be currently sort of a tension between design and accessibility, in that the design aspect hasn't quite caught up with accessibility, because the rules that we have to follow, like for example, a couple times, can we make that lighter or more transparent? No, you can't do that because of accessibility.
Accessibility issues, yeah.
So, it's been a real learning curve for us, and, I wish before we went down this road, there was actually sort of some sort of education session like this that could teach us about website accessibility, because it seems to be from the design, it seems the accessibility comes second to the design, and it is taking us a lot more time and money than we had hoped.
Yeah, I'm very sorry to hear that there's a scope creep situation. It's quite common, unfortunately, with the redesign or development of software.
Yeah, I actually don't think that they're in tension with each other.
Yeah.
I think it's just about knowing what to do. So, I mean, as the gentleman mentioned, that, so for people who are visually impaired, you need to put in tags. I don't remember the name of the tag, but in order to do that, you have to be aware that the tags are there, and then make sure that it's designed for. So actually, there's a lot of rigorous designs for like how to name a tag. And actually, I've read some interesting stuff on it, and I would never have believed how much time you have to put in to just get the correct tag. Now, when it comes to visual design, there are some people, so we mentioned web designer, there are some people who are just completely ignorant about contrast issues and font size issues and things like that, or their sense of aesthetics trumps that. So in that case, it's about finding someone who can be aware of both things.
Okay, we got one more question here. This is also on that whole train of thought with accessibility. It was already mentioned that these days everyone's got to have a version for desktop and a version for mobile. I mean, from what I'm hearing, does there actually have to be a different version for accessibility in order to be able to have something that's usable for people that are dealing with particular challenges?
So I would say that most websites that are coded now, the design is fluid because there's so many device screens that, screen sizes that you can't, it's counterintuitive to do like a mobile site and then like a desktop site, because then you have to wonder about tablet sizes and all of that. Accessibility is discussed from like where I've been in terms of, what's the menu and navigation going to look like on a phone where the screen is much smaller, and how is that going to transform as the device and screen size shrinks. I'm not sure if that answers your question, but it is, accessibility is part of the thought process, for sure, from my experience.
No, I'm just wondering if there's, basically, are there examples of websites where you have a version that has to be designed to be accessible because the one that's for people who, let's say, are not visually impaired is different because they're using, they're looking at the screen. But for people who can't do that, then there actually has to be a different kind of design. Is that?
No, it's all kind of designed and it's more about the code because screen readers pick up words, not so much the.
Sorry, I wanted to respond to that question. So I also work at the Canadian National Institute for the Blind, and they have kind of a lot of best practices. One thing I draw attention to is the policy framework. I think Sam alluded to that about regulation being very important. If you do a Google search about lawsuits related to accessibility of websites, you will find a lot of lawsuits in the United States. Our AODA does not give people the power to sue on the basis of noncompliance with AODA. So I do think regulation is probably the most important, legal regulation is probably the most important thing that we need. But so I think it's always a kind of a trade-off between time, resources, and expertise there.
Some sites have to directly answer, some sites will, for example, include a high contrast mode. So that's not redesigning it separately, but it is adding a feature. Just like adding these tags, it's not adding another website, it's just adding more stuff in the website.
Okay, one last question here.
Thanks a lot for the presentation. It's really interesting. I guess I'm curious, so we can sort of apply the design principles to law-oriented websites. Is there any, have you noticed any sort of backward or movement in the other direction? So is there anything distinct about law-oriented websites in your view that then need to be informing the design in some way? Or is it all just you can apply the principles to any type of context, law or others?
Yeah, I think there's, There's a couple answers to that question. So I think first, the Stanford Legal Design Lab, they've produced actually books and guides and I guess websites about legal design specifically. So I wouldn't say they're really that different, but they are kind of use much better worked examples that are much more relevant to the legal sector. So they've really thought through these issues. They've published papers. Another group is the Harvard Access to Justice Lab. They actually do empirical experiments about visual design. So that's another interesting resource. I think I mentioned some of the universal design resources, but I also recommend the Microsoft's inclusive design resources. They really kind of give you that kind of intellectual framework to think about what does it mean to be inclusive. Yeah, thank you so much, everyone. We're gonna pass it on to Amy.
I just want to say a quick thank you, of course, to Avery and Alexis and Sam for the session and sharing with us some of the things that we need to be thinking about when designing websites and tools for specific audiences. We're going to bring Amy Salazin in. We're going to be bringing her in from Ottawa, actually, to talk a little bit now about how to evaluate those resources and things that we should be looking for when making sure that these newly designed resources are actually doing what we hope that they're going to be doing. So Amy Salazin is an associate professor at the University of Ottawa Faculty of Common Law. She received her LLM from Yale and her JD from the University of Toronto. In addition to legal ethics, Amy's research focuses on gender and the law and technology, and civil justice reform. So are we able to bring Amy online?
Hello. Hi. You're good?
We're good.
Wonderful. I see my large face, and I wish I had PowerPoint slides, but unfortunately it's going to be my face and then maybe some kids' Halloween decorations in the mirror there. Thanks for having me. I see my colleague David Wiseman in the front row. Hi, David. Nice to see a friendly face. I'm sorry I'm not able to be with you in person, but I really appreciate the opportunity to speak with you today. I'll be looking at some notes as I talk, so if I'm not making eye contact, that's why. In contrast to what I understand some of the previous speakers, I joined around 3 p.m. I'm not a technical designer. As you heard, I'm a professor who has an interest in access to justice and technology and how people can get legal services easier. So what I'll talk about today is some research I've done with others, particularly Jacqueline Burkell from the Information Studies Department at Western, about examining complexity in legal forms and how to make legal forms less complex. So the focus was legal forms, but I do think, and I certainly welcome feedback, that to the extent that any of the tools you're developing are interactive, that some of the insights may be helpful to you as well. So don't want to take up too much of your time, but maybe I'll just give a bit of background as to why we did this research. So we were motivated to do this research for reasons that many of you will be extremely familiar with in the room. The knowledge we have that in personal plight areas of litigation, so things like family, housing, small claims, perhaps, we were really seeing a large portion of people being self-represented. So people that need to litigate, need to engage with the courts, but don't have lawyers. And there was multiple studies, interviewing these people, interviewing court staff, lots of anecdotal knowledge, that non-legally trained people really find the court forms overly complex. A big barrier to them being able to access the justice system and seek resolution for their legal needs. One thing we noticed, and it was about kind of 4 or 5 years ago when we started this research, was even though we had a lot of confidence that the public was finding these forms complex, we weren't necessarily sure why. There wasn't a lot of data on exactly what was making these forms create barriers. And so we wanted to do some research to try and unpack that really at a detailed level. And in terms of how we chose to study this, we used a broad lens of functional literacy. So this may be something a lot of you are familiar with in the room. I'm not sure. I'll give a bit of a background. So in short, what functional literacy does is it tries to give a more contextual assessment of literacy. So it's not just looking at the document or person in isolation. So, it's not saying, well, this person has this reading level, or running your document through a reading level processor. It's really looking at how the the individual and the document interact. So if there's a task in the document, how difficult is that task for a person to complete? So again, it really is looking at design when something's interactive. So for us, it made a lot of sense with court forms. If you want to understand why a court form is difficult for people, we need to understand, not only does the public understand the words on the paper, but do they understand what they're supposed to do with the court form? So to take, a simple example of why functional literacy can provide, we thought more insights, you take a word like address. So many people, most Canadians, most members of the public probably understand that word in the dictionary sense, but they may not understand if they see a blank for an address in a court form what they're supposed to do. Is it clear it's supposed to be their own address? Is it supposed to be the opposing party's address or the court's address? And even if it's clear about which address is required, the complexity is going to depend on how difficult it is to locate the address needed. So for example, we found in a lot of court forms, they ask for court address, but for an individual to get that information, they'd have to cycle through a lot of different sources of information to know what to put in there. So a functional literacy approach, deploys very specific technical techniques to identify these types of task-related challenges. And so a lot of it's intuitive, but what the approach can do is really make it a very disciplined, analytical approach to measuring these things. So it looks at things like overall document complexity, so organization and structure. So what type of information is being requested? So again, to use a form as an example, it may be easy for an individual to put their name down, but if you have, for example, a small claims court form that says, tell us what happened, that's a lot more abstract and requires them to generate information that may be more complex. What type of known kind of cognitive processing strategies are needed? So again, how many different sources of information does an individual need to cycle through? Is there terminology that's confusing for an individual? So it measures those types of barriers and levels of complexity. If there's math involved, we know addition's easier than multiplication. So in some of the family law court forms, that comes into play. So it measures those types of issues. I heard in the question period a lot of questions about accessibility. The models that we've seen for measuring functional literacy don't go to those elements. We know there's going to be language issues as well. It doesn't go to those elements. So it's not by any means a perfect solution, but it does provide us, I think, a tool to really look, again, in a very analytical, dedicated way of what's making interactive forms complex. We also saw this type of model or framework being promising because it opens up to us more in terms of responses. So traditionally, measuring literacy, there might be two types of responses. You're going to educate users to help increase their literacy level, or try and decrease the reading level of a particular document. The first approach isn't necessarily completely practical in terms of the resources it requires and what it might require kind of a societal level. The second approach, when you're improving reading level, that certainly can generate some benefits, but it's not going to take into account all the sources of complexity. So by this type of analysis, we felt we really could isolate particular types of problems or trends we saw generating problems and help provide direction about how to optimally design documents. So we were interested in using this approach to look at court forms, and we did 2 studies to do this. The first study, we used an instrument that was developed by Julian Evitz and Michel Gauthier, titled the Literacy Task Assessment Guide. Very detailed guide, it's 40 pages. I won't be able to kind of go through it in full. But basically what it does provides you an evaluative framework by which you can look at a form, so each line in a form, and assess a numerical value as to how complex it is for an individual to fill out the line. And then you can measure this, assess complexity against, what we know about levels of functional literacy in Canadians, because there's been studies on that. And so we did look at 4 different forms. We assessed 282 tasks. We had some research assistants help us. It took 150 hours, so it's a very kind of labor-intensive process, produced over 100 pages of raw data. And from that, we were able to publish kind of multiple numerical and statistical observations. And it also allowed us to descriptively identify trends found in forms. So many things probably won't surprise people in the room. Some of the trends we saw that led to increased complexity were tasks that required users to generate information using expert knowledge, expert legal knowledge, required them to interpret complex legal or vague terms, required them to cycle through a lot of different types of documents or information, engage with kind of broad descriptions or unclear requests that could lead to incorrect answers. So we did publish a paper, from the study, and if anybody's interested, feel free to contact me or Google me, and we can connect you with that. Another source of complexity we found, surprisingly, was that the guides that were supposed to help users fill out these forms ended up actually being a major source of challenge. They tended to be very complex, oftentimes provided different terms than were used in the forms. They weren't structured in a chronological way. So we also looked at those guides as creating increased complexity. And it's actually amazing, how many very basic problems we found, whether or not it was using unclear abbreviations, not defining terms, incomplete instructions, and again, the guides as well, being organized in a way that wasn't necessarily optimally helpful. And so we generated some conclusions from what we saw. One of them was one way to potentially reduce some of the complexity that we saw lied in using kind of dynamic electronic forms, smart forms, that could really integrate the forms and the guides together and provide kind of tailored just-in-time information to users. So again, probably not surprising to people that think about design. If you can, instead of providing someone like a 20-page form, you can provide them those parts of the forms that they actually need. If you can provide them pop-up definitions of the terms instead of them having to flip between guide and the form, that can be helpful, those sorts of things. So that was a very quantitative type study. And the goal wasn't to say, okay, line 10 in form X, that's a level 53. We weren't saying that, we were providing those kind of scientific observations, but we were really trying to identify trends and the types of things that people were having problems with. And also looking generally at which forms created more problems for people. But we wanted to move kind of beyond a quantitative analysis and do a study with human users to see, it's all well and good to use this mathematical tool. Is it really born out of what people experience? And so we did a study of one court form, a landlord and tenant form, with human participants. We did hypothetical scenarios and went through the form. And the main thing we were measuring was, did these human testers experience the task that we identified as complex as well? So we did it kind of validate the first study. Largely, we found that to be the case. The results mapped fairly well onto the first study. We did find some discrepancies that were interesting. In particular, and again, it was a landlord and tenant form, we did find some technical and legal terms that the human users found complex that weren't identified in the first study. Particularly the term remedy ended up being a huge stumbling block for a lot of people. Another thing that surprised us was the paper-based form had a blank for direction for people when they filled out their street address. And many people thought that was actually asking for an actual direction of their apartments. They got very confused and frustrated by that. Instead of something like, what it meant to prompt people to fill in was something like Wellington Street West for streets that have directions in their name. And so why, what did that tell us? It told us, probably, vis-a-vis the remedy issue, we were having law students do the first study, and, their pre-existing knowledge probably impacted what they identified as complex. The direction thing was interesting because that didn't, derive on legal knowledge or not. It may be that because those people were actually having to try and fill out the form with hypothetical scenarios that generated that issue as being identified. Whatever the source, it did tell us that, even though we can say with some confidence there's value in using that functional literacy approach, you really do need to couple it with robust user testing as well to be able to be confident in the results. So that was all in the paper-based world. And now we're moving in a new project to see what insights we can generate using functional literacy in an electronic world. So again, still in the world of court forms, legal forms, we're at the beginning of a project funded by the Law Foundation of Ontario, where we're partnering with CLEO to look at the family law guided pathways. And so kind of two goals of this research, seeing how, one of our conclusions from our previous studies plays out. We concluded that, electronic forms can potentially remediate a lot of the deficiencies in paper-based forms, seeing to what extent is that actually true. And then also looking kind of at what types of either transferred complexities may still be present in the electronic world, maybe what types of new complexities would arise for users trying to complete tasks. And we're going to use that by analyzing data from actual users going through the system, and once again, taking human subjects through kind of hypothetical scenarios through the guided pathways to try and generate those results. So that's it in a nutshell. It's basically trying to use a methodology to determine why tasks are complex. So that element of design. And can you design things in a way that makes things easier for people? And the legal world, I think, is an interesting question as to, what complexities can you remediate and what, may remain the same given the nature of the legal context in which people are operating. That's something we're looking at as well. And, we are seeing more governments moving to these types of interactive forms. So I think, it is important to have a sense of, what works for people, what doesn't. And this is one method of assessing that. Again, doesn't assess everything you might potentially want to know, but I do think it generates some interesting insights. So I welcome any questions people may have with respect to that. There's a paper on each study that are now publicly available. I also welcome kind of feedback as to what you think, where this might be useful in your work or where you think there might be some shortcomings. So, and in your hands, if we have time. I'm not sure how much time we have.
Amy, thank you so much. I think that was really useful following up on the previous session, and I actually think the room doesn't have any questions.
Okay.
Thank you.
Either a really good sign or a really bad sign, so. Our end of the day sign. Well, I don't know to the extent my name is available, but if people want to email me, if they have any input on this research or interested in hearing more or giving us feedback, we really welcome that. And again, thank you for welcoming into your room. And with that, I guess my time is up. Have a good day from Ottawa.
Thanks so much. We're going to take a 15-minute break before we reconvene for our 4 o'clock session, which is going to take a bit of a different format. Julie and I are going to facilitate more of a community forum discussion, and it will, we'll present a tiny little bit at this, but we're really hoping to ask more questions than answer them. We're hoping that people in the room will be standing up and answering some of the questions and sharing their knowledge in this space. So let's take 15 minutes and reconvene back here at 4 o'clock. Thanks.
Ladies and gentlemen, would you please take your seats? The presentation will begin in 1 minute.
Made it. And we're back. As I mentioned before we left for break, this last session of the day is going to follow a bit of a different format. Julie and I are going to put to you guys a couple of questions, and we're really hoping that this is an opportunity for us to do the asking and the people in the room to be doing a little bit more of the sharing. We're hoping to come a little bit full circle from where we started at the beginning of the day. And for the next 45 minutes of today's program, we'd like to discuss another channel that people who are experiencing legal problems often turn to for help. This would be family and friends. Now, I'm sure this doesn't come as a surprise to many of the people in the room, but studies suggest that people with legal problems often turn to family and friends for help before going elsewhere. And honestly, this makes sense, right? Family and friends are often our go-to when we have any sort of problem. And as we discussed earlier in the day, people don't think about these as legal problems. These are problems. So it makes sense that people are going to family and friends on legal issues as well, too. So for the rest of today's program, the next 45 minutes, we'd like to explore this topic a little bit more. So what does help from family, friends, and neighbors look like? What are some examples of this? What do we think about it? Is it a good idea? Do we have some concerns? And then, of course, depending on where you land on this, are there ways to discourage this form of help or ways to support it? So I'm going to turn things over to Julie to talk a little bit about some of the Law Society bylaw provisions that touch on this, and we're hoping to throw it open to the room, and especially to our friends who are coming from other provinces and territories. If you want to weigh in and talk a little bit about the experiences in your jurisdictions, that would be awesome. Thank you.
Yep. So unfortunately, my colleague David Weissman isn't here to give his law professor take on the. Oh, he is. Okay. Well, good. He has to leave early though, or else he'd be up here. Okay. But I would check it in with him. So we do know what the Law Society bylaws say about the help that family, friend, and neighbors are able to offer legal problems without engaging in the unauthorized practice of law. People don't have that before them, right? We didn't get it from that. Okay. So I'll tell you what that is. And I will read slowly. Oh, we do have it.
Yeah, it's coming up.
That's what I thought. Okay, but can you see it?
It's a little small.
No. Okay, well, I can, but okay. A person can provide legal services to a family member as long as that advisor does not themselves practice law and does not receive any compensation or fee for that assistance. I'll tell you in a minute what is meant by legal services. The same goes for people helping friends or neighbors, as long as the advisor doesn't do so for more than 3 matters a year. Okay, so that's for friends and neighbors. In terms of the type of legal services they can provide, they can only provide the same services that a paralegal currently can provide as a licensed paralegal. And that means they can provide legal advice and representations in certain type of specified matters, but those would include most tribunal proceedings, small claims court matters, and some minor criminal matters. So, as Jess said, today's theme is widening the circle. And of course, family and friends and neighbors are certainly part of our closer circle. So we'd like to hear from you about the experiences you have in this area in terms of, what are you hearing about this form of help? What do you think is happening in this sphere? And Jess, did you want to ask the first question?
Yeah, well, why don't we keep it as broad as that to start and talk about if anybody's willing to share their experiences with what does help from family, friends, and neighbors look like, if people are willing to share any particular examples. We will push the envelope a little bit and talk a little bit more about how we might broaden this a little bit more with technology. Has that changed a little bit about what that category might include? But does anybody want to start off by sharing something?
Two over there. Yeah, do they need to use the mic? They do need to
Oh,
use
sorry, yes, please use the mic because this session is being webcast, and so we want to make sure that those online can also hear. Thanks, Avery.
Yeah, no, thank you. So just kind of, I guess, I think every lawyer in the room is going to have a million stories of times people ask for help. The thing that I think I do most is like legal life skills. So kind of clioconnect.ca, there's this amazing curriculum on legal life skills, which most people lack. It's just getting from the problem to going to see a lawyer. That path is often hours and hours of work. So I'll write memos for my family and friends on what they need to do, what the issues might be, that kind of thing. Just structuring it logically, I find that's a huge task people need help with.
Was there another comment back there?
I think we got one right there.
Yeah, another. She was too. Did you see the?
I would say that technology changes this whole area of family, friends, and neighbors, because if you're looking at things like guided pathways, which are designed to prevent people from making assumptions or making risky judgments about what somebody should do, I think it reduces that risk. So, I mean, anybody can go to My Law BC and go through a guided pathway. I believe a lot of people, who knows how many, ask family and friends, where can I go for help? They might find that, and they may even sit down with a family member to look at it. So I'm sure it happens. I'm not aware of how often, but yeah, I have no doubt.
Just from personal experience, it's Raymond Hathaway, paralegal. What I generally do with friends and family is refer them out to another professional so that there isn't a conflict of interest. I will, similar to my friend here, provide assistance in a memo or helping them basically make it a faster process, helping them define what they're going to want to say when they are in front of the lawyer. So that it's easier for the lawyer, but also easier for my friend or family member, and obviously it saves costs. So I typically, if one of my colleagues asks me whether they should take on a case, friends and family, I try and shy away from it myself, but then I also do support that person by bringing them in touch with somebody at a legal clinic or one of the services that they require. So I don't just drop them, but I make sure that they're well placed, give them a heads up about what they're going to be facing, how, common pitfalls, how to save time, how to save money, and then they generally really respect that. They also get a better bill for it versus, going in there and telling their whole story. And so far that seems to be pretty good.
Okay, so that's for the paralegals. So is that also for lawyers? I've been a lawyer for 41 years. I didn't even know that was a rule. So I'm embarrassed to say. But I've never, I made the mistake in my first year of practice acting for a family member, would never ever do it again because it just caused tremendous friction. His cousins, they won't talk to me now because they thought I overcharged them for something, and now I'm finding out what it says there. I don't know if that existed 41 years ago, but it's just can cause a lot of friction. And the other irony is, my family, although I'm the only lawyer in our family, extended family, they never come to me anyways. They go to everybody else. So my brother-in-law, who's a former banker, they ask him all the legal advice.
Well, obviously they know about the rule.
Yes, but it's sort of like, they wouldn't come to me anyways for stuff.
Hi, it's Sheena Weir. I work at the Law Society. I'm not a lawyer, I'm not a paralegal, I don't work in the regulatory department. I am actually in the communications end of the business, and I do stakeholder relations. So I just wanted to give a bit of context, though, for this rule, because I was around for the evolution of the rule, which was around paralegal regulation. Before regulation of paralegals, there was a lot of activity at tribunals and other places where people would appear as an agent, as it was then. And what happened was, when we started regulating paralegals, there were a lot of people that were using the exemption for family and friends to get around paralegal licensing. It wasn't about legitimate friends and family trying to assist people. It was about people trying to thwart the regulatory process for licensing and public protection. So this was then narrowed, because what had happened is we had people actually appearing before tribunals with their 50 or 60 or 70 friends, which they weren't. So that's the context for this rule, and I think it's important to keep that in mind. It's not about paralegals or lawyers acting for their friends. It's about people that are neither acting as a friend or family. So, and it's mostly around representation. So, as I say, not a lawyer, not a paralegal, not a legal opinion, and not from the regulatory department, but just a little bit of context from the policy development process.
So that is so helpful, Sheena. So that's particularly vis-a-vis that 3 matters, right?
Absolutely, because as I say, there was somebody that used the exemption for friends and family under our bylaws to represent 50 separate people at one of the tribunals. So that, you know, he had a lot of friends and family.
Right. Well, I know, and it does raise the question of how, like a neighbor could be just, you know, how close does somebody have to live to be a neighbor? You know, you have a big apartment complex, right?
Well, this was meant to be helpful, and it was actually something that the tribunals felt was very important, was for them to be able to say, yeah, no, you can't have 50 friends like that. You know, you're restricted to 3 matters, and that was seen as a good amount. So it was fairly arbitrary. Should it be 1? Should it be 5? It was 3, and it seems to have helped to curtail the problem that it was designed to.
I was going to ask that. So it has helped.
Absolutely.
Good.
And we heard from, it was Joel Miller that talked about that this excludes friends and family from helping in family law because it's out of scope, which is true. We also don't recommend that friends and family represent you on murder charges and things like that, right? So it's out of scope. This is really about paralegal regulation. So if there's ideas about how other people should be getting in, I think it has to come in a bit of a different conversation.
Yeah.
If that's helpful.
Yeah. Thank you. Yes, sir.
Being a lay bencher, and the whole access to justice and how important it is, and it's been a very interesting day. I was just curious, nobody's mentioned in any research about the impact of Google, because I don't know how many times a day we Google for everything from definitions to a problem we have to get it solved. So with anything here, does Google have an impact in access?
Yep.
Yeah, that's a really good point. I'm glad that you raised that. And I'm going to throw this open as well a little bit wider, because in addition to forms like Google, we wanted to, within the context of thinking about like who is your neighbor and what does your community look like, what about the online community, what about discussion forums that happen online, and a lot of the questions and answers that are being posted on online forums. Arguably legal matters and legal advice being dished out on those mediums as well too. So I'll throw that back open as well to the rest of the group to see if people have anything they want to bring forward on that front. But I think, Deborah, we got a question from New Brunswick.
Yeah, we have a family law information line, and we get over 3,000 unique callers that we help each year. And I can't tell you how many we started actually tracking them in our data collection. Or somebody's mother, somebody's sister, especially males, and we'll say, well, why don't you give your son this toll-free line and he can call and the operator will give him information about, well, he's a long-distance truck driver, he never can. I'm finding the information for him. He asked me to call, and can I go with him to court? We get that so much, so much, and in our emails too. I'm writing on behalf of my son or daughter. So then, of course, we have all this information on going to family court. It says, can I have a friend or family person with me? Oh, yes, for emotional support, but they cannot sit up front with you. They have to be in the gallery. They're not allowed to be at the bench. So, which I know is not the same in BC, for example. There's actually a sheet on how you can prepare yourself as a friend or family member to support somebody who's going to be in family court. So I am just saying there are people out there who are friends and family, and they want to be there to support and whisper in their ear if they're allowed, and things of that nature to help.
Yeah, I mean, I think that in terms of the bylaw here, I think when it specifies legal services, and it says legal services, paralegal legal services, the equivalent. So I think emotional support would not be part of legal services, but I think in Ontario, and somebody else can correct me if I'm wrong, I think it's up to the court, to the adjudicator or the judge to decide whether somebody can be accompanied. Is that right, Paula? Yeah, I think that's the understanding. So it's still not a clear, okay to do it. It's up to each decision maker. Yeah.
The common element in those two are the aspect of money. Doing it for a fee. Wouldn't it be simpler to say you have an exemption if you're not doing it for a fee? Number one. So that leads me to the question of what's the intent? Are you trying to prohibit people from offering legal information, legal services for a fee? Or are you trying to regulate so that you can maintain quality level of, it's quality control, or is it, I find well, anyway, I've said enough.
Well, it's interesting because that's what we'd like to hear from you. Like, what are your thoughts and the reason? I sort of came up with, Jess and I came up with sort of 3 thoughts on what we thought might be behind this. We didn't have, and it may have been wiser, but we wouldn't want to put the Law Society on the spot, so better if we just speculate, right? Anyway, we'd like, pardon me? Yeah. So let's go on this. We'll go ahead, but I would like to hear from you about what you think of this, what the reasons might be, and whether there's any way that, maybe we'd like to give some guidance on a better interpretation or better use of this. I mean, getting at some of the reasons behind it. Sure.
So I practice as a paralegal now. Before I was a paralegal, I actually assisted people for no fee. So I have read this directive several times, and I understand it. One thing I will say is that there needs to be a support system similar. If we're going to allow people to do this, there needs to be a support system for them to be able to educate themselves. I have a helpline, for instance, with the Law Society that I can call if I have questions. There really isn't anything like that for people that are going to go in and help their friends or family. So if we're going to allow this, If it's allowed, it is allowed. Maybe there should be a support system for those individuals who are going to step into the court. And perhaps even an encouragement to get licensed and go through the education system for it. Yeah, that's my thought.
Are you thinking that, like, if it's a helpline for family, friends, wouldn't that, I guess you'd somehow have to define that in some way, otherwise it would be probably a helpline for almost anybody, not that anybody doesn't need that, but.
Yeah, but just a support system for those individuals who are going to try and do this for free and actually represent somebody without a license. Perhaps something that's targeted towards that so that those individuals that are looking to do it have a specific place to go that is a little bit different than the person who's going to self-represent. Because there are some additional considerations that you have to think about if you're not doing your own matter, you're doing somebody else's.
Yeah. Oh, good, we get Tanya here.
I mean, if we're going to speculate on the reasons for this, I
We
mean, my
did do more than-
speculation.
We did do more than speculate.
Well, I
We were
would
just
think that the
trying-
rationale is simply a human one, that they recognize that family members are going to talk to people about their family problems, and they didn't want to make it an offense.
That was
and
our
that's
third
about it,
yeah.
rather than some thought that this was a particularly identified area of legal service provision.
That was one, and it wasn't just pure, that was, thank you, Tanya, yes, yes.
So my question is there not an obligation on whoever's in charge of the venue, whether it's a tribunal or a court, to ensure that if there's someone who is not a barrister or a solicitor, is qualified to be assisting with that? I mean, I can think of the number of times where people whose first language is not English or French are using their children to interpret things. They have no legal knowledge whatsoever. There's all sorts of examples of people in terms of, say, injured workers talking to doctors. And, you know, can you imagine like the 14-year-old daughter trying to explain something about the dad's inability to have sex now or something because of an injury? Like the inappropriateness of allowing family to be involved is something that I would be concerned about. And I'm wondering if, rather than sort of, you can do it 3 times and then quit, there should be some requirement of the venue to ensure that if there's someone there representing or assisting, that they're qualified to do that. Otherwise, get an adjournment and get legal advice.
Yeah, because I like so I like your thoughts on just a question in response to that, sir, which is, so would you also see, and maybe this is what you're saying about the adjournment, some obligation though on the court or on the venue or on the decision maker to ensure that people in the court are able to be heard in some way? I mean, it's interesting to me that there's always a balancing, right? So you might have some people who are there and don't really know what they're doing in assisting a family member, but without that help, maybe a party in a proceeding isn't able to have any voice heard. So how do you balance that? Maybe an adjournment isn't in the cards, let's say.
Well,
Just a dilemma, I think, maybe.
I mean, if it were a criminal matter, there'd be no question, right? It'd be like, yeah, we're having an adjournment,
yeah.
right? And some of these issues that are dealt with by tribunals or courts have a huge impact on people's lives in terms of the money that they get or the treatment or losing their home or whatever. And I mean, when landlord-tenant used to be in the district court, I'd go there and are you a lawyer? No, I'm not. Are you supervised by one? Yes, I am. Oh, okay, now proceed. You know, and some judges didn't care one way or the other. But when a kid stands up to do the translation in court, like the judge has to step in and say, wait a minute, I don't think we're going to let this go.
As long as there's somebody else who can interpret, so the person still can get heard in court, right? It's like,
Or adjourn it.
yeah.
Uh,
Is the court going to give them the resources
Yeah, that's the thing.
when they come back after the adjournment to then have
Yeah, that is a huge issue, right? But the thing is that, I mean, I can think of a lot of people who have issues with their family. You don't really want them touching your stuff.
Yeah, 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 yeah.
I was going to pick up on the same comment about venue and services. What about a checklist? Something that if there's a court procedure and it's a family member or an individual, can they do a checklist that they give when they sign in to say, yes, I've checked steps for justice, I've talked to a legal clinic and they're not able to represent or something, but maybe to assist the court that they've been given at least some information, so there should be a checklist available.
Yeah, that's a great idea, and it sort of echoes what I think you said back there. Maybe, like, Cleo's never done work sort of for family and friends. We try and do it for community workers because we do think there's some real concerns about family and friends, but recognizing the reality of it, which was another reason for what we think is the exception, was the reality, trying to maybe support that, and so that we know that it's pretty good help. Okay.
I would just wonder if a court would not treat it just like they were a self-rep. If you're standing there with someone who's untrained, who's your mother, you know, is there necessarily any more knowledge about the system, and just treat them like a self-rep, that they're more there for emotional support? And the other issue I wondered was about privacy. You were talking about the situation with the child interpreting, but if you have a parent who's got a young adult or something, and are there issues of duress, or they're forcing you to work a certain way, and the mother's speaking on their behalf or something like that?
Yeah, I think to your point, Jane, actually both of them were ones I'm glad that somebody has raised. On the point about recognizing them as a self-rep, I think there is something in that provision as well too that recognizes that family and friends aren't necessarily going to be recognized as experts in the law. They're not being held out as experts in the law. So there is some understanding and awareness around they have no expertise. And I think the power imbalance issue is another really interesting one to look at, because you can imagine situations where you have, you know, it might be a family member, but like if it's a daughter and a parent, you know, there are issues around a power imbalance. You can imagine other situations where, you know, it might be somebody who is held out, you know, to be authoritative in other ways. Maybe it's a faith-based leader, and that can cause some problems as well too.
Other thoughts? Yeah, sir.
So I actually am glad that this bylaw is there, in large part to stop those individuals from going in and saying that they're friends and family. And I know that in some of those cases where an individual had 50-some plus friends, family, whatever, they were before the court saying that they weren't charging for their services, but then they were. This really has capped it with the 3, and it is a preventative measure from basically somebody going in and practicing without a license, but then also making it accessible to have somebody on a few occasions go in if they're absolutely needed and somebody needs the extra support. So it's a very fine balancing act, and I think the Law Society did a really good job doing this.
Yes, sir.
I'm just wondering about, you know, just thinking in the big picture about gaps that are still present. We all know there's a really serious gap with access to justice. There's a lot of self-reps. And, you know, with this here, we see no more than 3 matters per year. Now, we already talked earlier about how nonprofit organizations, if it's within their profession to do work that would otherwise constitute legal advice, they are covered by an exception. But what about those communities? What about smaller towns where there just isn't the infrastructure for nonprofit organizations? There's not enough funding to hire professionals, things like that. So there's just nothing there, but you have individuals who are very unsophisticated, don't want to go in and represent themselves. There's just no lawyer or paralegal who's available, no money available, no legal aid available. You have a person I just want this person who's way more educated than me to help me out. I know they're not a lawyer. I know they're not insured, but I'm better off with this person than I am by myself. Like, what about for those people? Like, why is that wrong for someone to ask someone in their community to help? And maybe this community, there's like a few people that get together. They have an informal group of people that are doing this service, like let's say for tenants' rights, where there is no tenant rights organization present. What is wrong with group of like grassroots people just getting together and helping more than 3 people, helping like 100 people. If there's really nothing else and those people are asking for the help, they say, I'm okay with that.
Yeah.
This is all I have.
Well, yeah, we'd like to hear others' thoughts on that. I mean, I haven't visited it, but I guess there's a very, very active Facebook discussion group. See, I can't even get quite the Facebook discussion group for tenants. And so how many members are there on that? Or how many people are, like 27,000, where people give help. Okay, not advice, I'm sure, but what do you call it? But they're helping each other with their problems as tenants. And I'm sure that, I'm sure that some of the help on this Facebook group is wrong. Some of it probably is right. Probably most people know that what they're getting, they can't, entirely rely on, but it's better than just relying, on their own devices when they may not have that legal training. So what is wrong with that, to the gentleman's point? Anyway, go ahead. We'd like to hear any comments you have on this.
Yeah, Ben Fulton here again. Just to respond to that, I just want to comment about the public perception around this law or rule, regulation. Now, of course, I don't have accurate statistical analysis. All I have is the worst kind of scientific data, which is anecdotal, or, what you hear by the man on the bus, the Clapham omnibus, as it were. But basically, there's this perception that I'm aware of, I don't know, how prevalent, but that this is really just a, gatekeeping mechanism that's used to, keep lawyers' salaries really high, to basically make it so the only person who can help out these people has, undergone fairly extensive and expensive legal training. And now, of course, to justify the cost of their legal training, they're now forced to charge or be perceived as overcharging cousins or whatever the case may be. And so the public just, feels that this regulation is actually just a barrier to access to justice, and they see it as basically a gatekeeping function, and it's really just, something that was created by the self-regulating body of lawyers to insulate their high-paid positions.
Yeah, thank you for that perspective. And I'm sure some members of the public do feel that way. I really think that anecdotal is among the best evidence, so there you go. Jackie and...
So I'm back. Before it was all regulated, I did a lot of tribunal hearings for Canada Pension Plan, EI, the Board of Referees, Social Benefits Tribunal, which has now been replaced, and the Housing Tribunal. Not licensed, never have been, but we followed all the rules, and we had access to case law. So we had access to the information and the legal supports to do the work really well. I've never lost one. I don't do them anymore. I refer them to the legal clinics because I'm too busy and they get lots of money to do it and we don't. So having access to the information will enable people to be able to help each other better. I do think that it has a lot to do with money and people getting paid to do the work outside of not-for-profits who were doing it for free for many, many, many years before this regulation came in.
Thank you.
I was writing something, but did you say that Clio was not designed for friends helping friends?
Well, it's not that we're not designed. Our efforts have been, our mandates to reach people who have low income and disadvantages with information they need to exercise their rights. And often we do that through supporting community workers, community helpers. We haven't designed anything specifically for friends and family who may be helping. So like if you think of people experiencing problems, community workers who are assisting them, and if you think of this, and it's really, these categories all blend together, but we don't have something, are you a friend or family member trying to help? We haven't designed anything specifically for that purpose.
Okay, so I can tell you I'm a self-represented litigant and people come to me all the time because they think that my one experience makes me an expert. And the first place I send them is to Clio.
Good. That's good to hear.
And it wasn't available when I started, and it would have been incredibly helpful to me. It would have saved me a lot of time reading very thick books, which saved me hundreds of thousands of dollars after I spent $200,000. And it's still going on. It started in 2008. So the first thing I do when they come to me is tell them I'm not a lawyer and that I can't help them, and tell them that they absolutely need a lawyer. But then I try to help them to narrow the issues down to the legal issues. So they always want to vent. It's a very overwhelming, it's a very emotional experience. So as a friend, you can listen. And then at the very end, you can say, well, in that hour and a half, you just burnt through $1,000, and here's the 2 questions that you need to ask a lawyer, which will take you 5 minutes. So I try to help them, listen, and then I try to provide just-in-time information. So it's so overwhelming, and they don't have. There's so much going on in their life is falling apart, and they just need to know, for this exact situation for me today, right now, what do I need to know? And then I point them to Clio, and I point them to the LexisNexis Practice Advisor, which is very expensive, but a fraction of the price of a lawyer. And you can do an awful lot of really good research because it's incredibly well organized. And then it's all about preparation so that by the time you get to the lawyer, your time is really focused on the legal issues, and then you're taking advantage of that very, very, very expensive resource. I hope that's helpful.
That's very helpful. Thank you.
Yeah. And I think echoed by some of the other people in the room who are talking about some of that legal life skills support that you can give as family and friends, which helps people to narrow down their issues so that we can create that pathway that makes it easier for people to engage with legal professionals and allow the system to work a little bit more fluidly.
Hi, I'm Dave. I'm from Justice Education Society in BC, and I know John from BC is next, and so a couple other perspectives. Oh, so, fair enough, sorry. So I just want to say my take on this is I actually see this as a barrier in terms of access to justice, and seems like a massive denial of the reality in terms of family law and the needs. And I'll just say that Justice Education Society is introducing a new service called Law Coach BC, and we provide legal help services to the public. It will be for a fee, and we have the blessing of the Law Society of British Columbia. So there is another way. I just want to say that from the start. And so we met with them. They understand that we are providing legal help to people with family law issues. We're not providing legal advice, legal help. And so just as a point in this where it says legal services, that in particular is what I have objection with. If it had talked about practicing law, that's that world of legal advice, and I would have been far more okay with it. But to deny the opportunity for so many, whether it's interpretation or ourselves in the PLEI community, for helping people in terms of providing legal help services, again, for me, that's just a denial of the reality.
Thanks. That's interesting, Dave, what's going on there. Yeah.
I feel like I'm cheating and shouldn't be allowed to speak because I was involved with planning this day, but I have a lot to say about this topic. One thing that I wanted to ask about is you had mentioned at the top of this session that you would get a little bit into how legal services are defined in this, and I just wanted us to revisit that because I feel like we're at risk of wrapping in a whole host of supportive behaviors into this category of legal advice, and like no one needs anyone's permission to show up to a friend's public hearing and sit in, like, not with counsel and be supportive and be present. No one needs anyone's permission to do some of the translation work. So I don't want us to roll in a bunch of stuff that isn't this with this specific thing. And I'm really sympathetic to what at least I perceive as the policy goals of this, which to me is sort of a challenging concession to the reality that nothing that anyone in this room will ever say will stop people from going and asking their most knowledgeable family member or friend what they should do in a situation, right? Like, we pay a lot of attention to the boundaries of all of this, and it's for good reason because we care about the services that we're providing and the access that people have to the system we work in. But I think where some of this starts to get challenging is when we hold up something like this, which seems like in many ways a concession to just how the world works and always will, with something like the agonizing thought we are putting into whether our panelists from this morning can help with relatively mundane things that they see all day. And so I guess my two things are, could we just quickly revisit as a group what the legal services are that we're talking about in this case? And secondly, can we maybe think about this rule and how it lives in the same regulatory environment with our thoughts from the morning about community workers? Thanks.
Just wanted to comment, in BC, and I don't know if it's true in other provinces, but there's this concept of a Mackenzie friend who is a support person that is allowed to appear in provincial court, doesn't have to be a lawyer or a regulated paralegal. And for certain small claims and family matters, and I'm just going to read what a Mackenzie friend is allowed to do, and this is from the provincial court's guidelines. A support person may provide the following help in court: taking notes, organizing documents, making quiet suggestions to the litigant, providing emotional support, and, interestingly and intriguingly enough, any other task approved of by the judge. But then it goes on to say a support person shall not address the court or speak on behalf of the litigant except in exceptional circumstances only with the advance permission of the judge. So there's scope, and I don't know if that's true in other provinces, but the provincial court, as a result of the work of the National Self-Represented Litigant Network, decided that it was going to put this in writing, that people could appear for certain purposes. So there isn't an absolute ban in BC in provincial court, for example. It is certainly highly regulated, and I invite any of you that are interested, go to Courthouse Libraries BC, and you'll find a link to the, I don't know if you want to say anything about it, no? You'll find a link to the provincial court guidelines. They're quite interesting. I don't know that anyone tracks how often they're used, but it's certainly a way to have a support person in court. And as I say, it's within a box. And you see, if you look at the guidelines, it's a very clear box what the limits are. But still, it's a little more than not being able to. So.
Yeah, thanks for sharing that, John. So any other comments as we just wrap up in the next 3 or 4 minutes on ideas for giving support to family, friends, and neighbors in this? I mean, I think what I'm hearing is we understand the policy reasons. It's also reality that friends, family, neighbors are going to be turned to for help. They're going to give it. We may not understand all this, although Sheena helped in terms of the 3 matters, but generally it's happening. People aren't misled when they go to a friend or family member. They know that as long as they're not a lawyer themselves, they know that what they're getting. So nonetheless, given the frequency that this form of help is turned to, you know, there were some good ideas, some checklists, you know, some things to make sure that friends and family know to tell somebody to, when you talk to your lawyer, when you're meeting with your lawyer, make sure you find out these types of things. And some of those resources exist. Any other thoughts on how we can, lawyers and legal professionals and the rest of us can support friends and families? I mean, particularly one of the questions I have is with the proliferation of these online discussion groups, Facebook and Reddit and everything else with thousands of participants, should lawyers be playing a role in those? Should we be dipping in and out? Should we just let them go? They're all neighbors, right? It's a community of people. You know, do we care? Do we have a responsibility to say, hey, whoa, that's not quite right? Or is it just not our thing? Any thoughts on that in the next 3 or 4 minutes? Oh, good, we have a couple.
So part of the ODSP action, there used to be a fireside chat group. And that was often, they'd turn to the legal clinics to make sure that their legal information was correct. Up in Alcona, we have an Alcona Chats. So if I find something as a neighbor, I'll do it as a referral. oh, are you aware there's a legal clinic up at Simcoe County, and I'll provide the link to the legal clinic. So I'm making them aware that there are other services available for information.
So that's great.
Yeah, I think the community legal clinics, insofar as they can, in the midst of all the cuts that have come down, I think it is part of their mandate to provide education to the community, and we do that. You have the Federation of Metro Tenants. Jordy was here earlier. They do a tenant school. I think that in addition to training the frontline staff of community partners, having, you know, general open to the public, not just for people who are really poor, basically open to anyone to come in to learn in the different areas of law that we handle, is a reasonable expectation on community legal clinics, especially the specialty clinics.
Yeah.
And they do that.
Yeah.
And I think maybe it could be more systematic or often, but that's something that we need to do.
Yeah. Thank you.
I'll say thanks to Sheena later.
Yeah.
Just to address a earlier statement, the scope and the area that the legal services are being discussed here, it's for paralegals only. So this is not addressing individuals that are trying to do a job of a lawyer. It's individuals appearing before board, tribunal, going before the court for a highway traffic matter. Something I've seen so many times where individuals will do it, and they'll do it on bulk, or try and hold themselves out as somebody who can charge for the services, and then go before the judge and say that they're not charging. I really like that gentleman's idea, and I'm going to expand on that. Have a mini diploma or a miniature course, a mini law thing and it's not so that somebody can go in and act as a lawyer. Again, this is paralegal. We're not doing murder trials. It gives them the basics so that when they walk into the courtroom, they know how to address the court, they know the basic procedures, where to sit. That type of thing should be offered. There should be something for individuals so that they can sign up to get a basics. They don't have to go necessarily through the I admit the fact that the individuals are going to exist. They're in the courts now. So rather than just leave them out there, at least by providing a structure that they can tap into, whether that's virtual or show up for a class like this, we're better supporting people that are definitely out there. They're there. So ignoring them is not going to make them go away. I'd rather have somebody who's assisting a friend to have a little extra support than to just leave them out there and possibly make further mistakes, therefore affecting the client. So that's my thoughts on the whole thing.
That's great. Thank you. I like those constructive, concrete ideas. And one last comment.
I have two things to say. The online forums can be so misleading and it's so dangerous if people land there and then they think they're getting good information. And I would wonder, it's a really sort of throwing a question back to you as experts and at CLEO, is there an opportunity for you, either using text analytics or humans, to go through those forums and start to look for the patterns and then common misconceptions and then maybe address them appropriately?
Serves me right. I can't believe I raised that question. Anyway, I'll make a note of that idea.
And in fairness, I would say also we don't want to lay the education piece solely at the clinic store. There are, other actors out there. CLEO is an example. OGen is an example where we are trying to work to proactively, ensure that people, even from a young age in our case, like working through the schools, working through community organizations, having people understand that there is some basic information, knowing where to go to turn to help. So I don't want to leave us thinking that it's all on the clinics, because there are other actors out there who work in this respect.
But the idea is just to see the patterns of the common misconceptions and extract them from that resource. And then the second, again, it's a question, is it possible to have once a year, twice a year, something where people can come into a facility like this where there are experts? A lot of people have the exact same questions, and just give them access so that they can be informed, and then maybe even live stream it so that people can get a sense of the structure and the resources and so on.
Yeah, thank you. Libraries have a lot of those sessions, is what, And Dave, you have
I'll
2
be
seconds.
super
Okay.
quick. So Reddit, their legal channel, gets 600,000 questions per month, and about 10% of those are Canadian. So I don't know if Cleo wants to take on editing that. Certainly we do not. But you just
Thank you, Dave. I hear that there's a really good organization in BC.
There are 9 moderators for the whole 600,000 questions, by the way. So the challenge is immense, and it is truly the World Wide Web. The other I wanted to say is I've been talking about for a while is advocating for this notion of a legal navigator class of employment where there would be certification for said such things. All of us provide some measure of training to people who help individuals in different areas of law. We make people who have parenting issues take a course, and it's mandated by the courts. Why can't we have a series of courses for us in the PLEI sector to be legal navigators? I'm not quite fit, whatever the term may be, I'll just say, but something like that, a class of legal helpers where there is certification for it.
Yeah, thank you, Dave. I've made lots and lots of notes. Before we wrap up, I would like to say 2 things about this session. Firstly, it's truly extraordinary that the Law Society, our regulator, is not only participating, but happy and encouraging, okay, maybe not ecstatic, but happy, encouraging, and fostering this conversation. I think that's unusual. I think I really appreciate it. I think all of you really appreciate it. And I wanted to say thank you to the Law Society for... I also wanted to say that, you know, Jess and I and the other organizers today, we wanted to just engage you in some of the hard questions. We weren't sure whether we picked the right one here, but we knew that there were a lot of talking heads, and we appreciate your patience and your willingness to participate in this conversation, you know, despite, you know, the topic and, you know, and sort of a lot of questions about it. There were a lot of interesting things that people shared and ideas. So I think the goal of prompting sort of idea sharing was accomplished, but we do appreciate you staying and participating in this wide-ranging conversation. Do you want to close up the day?
Yeah, so I know that we're running over time, so I think without further ado, we'd like to say thank you very much to all of you who have stuck it through on a day where it's really quite nasty outside, and I know that some people are going to be rushing home in order to do Halloween activities with their kids, so thank you for taking the time to come out here. Thank you so much to those of you who came in online as well today. We're very pleased to see such a high number of registrants participating via webcast, and of course, thank you to both the Law Society and the Law Foundation of Ontario for making this all happen. We are delighted to be able to do this kind of conference, and we look forward to hopefully engaging you guys in the future. Thanks.